ಕೋರ್ಟ್ ಆಫೀಸರ್ ಇದು ಓದ್ತಾ ಇಲ್ಲ. What up, sir?
Wait, we'll go row wise. ಎಲ್ಲ ಮಿಕ್ಸ್ ಬೇಡ ಏನ್ ಹೇಳಿ ಫ್ರೆಶ್ ಪೆಂಡಿಂಗ್ ಸರ್ ಕೊಡಿ ಪೆಂಡಿಂಗ್ ಎಲ್ಲ ಮೆಮೋಸ್ ಕೊಟ್ಬಿಡಿ ಪೆಂಡಿಂಗ್ ಕೊಡಿ 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 ಗಿವ್ ಇಟ್ ಹಾ ನೆಕ್ಸ್ಟ್ ಹಿಂದೆ ಬೇಡ ಫಸ್ಟ್ ರೋ ಮುಗಿಲಿ ಎಸ್ ಫಸ್ಟ್ ರೋ ಮುಗಿಲಿ ವೆಯ್ಟ್ ಎಸ್ ಹೂ ನೋಸ್ ಏನಾಗಿದೆ ಮಾಡಿ ಎಲ್ಲಿದೆ ಮೆಮೋ ಸರಿ ಬಿಡಿ ಎಸ್ 2:30 ಹಾಕ ಆಯ್ತು 2:30 ಬರುತ್ತೆ ಕೊಡಿ 2:30 ಎಸ್ ವೆಯ್ಟ್ ವೆಲ್ಕಮ್ ಯಾವತ್ತು ನೋಟಿಸ್ ಕೊಟ್ರದ ಯಾವತ್ತು ಕೊಡಿ ನಾಳೆ ಹಾಕಿ ಹಿಂದೆ ಬೇಡ ವೆಯ್ಟ್ ಹಿಂದೆ ವೆಲ್ಕಮ್ ವೆಯ್ಟ್ ಎಲ್ಲ ನಾಳೆ ಎರಡು ನಾಳೆ ಹಾ ನಾಳೆ ಕೊಡಿ ನಾಳೆ ಕೊಡಿ ನಾಳೆ ನಾಡಿದ್ದು 2 ವೀಕ್ಸ್ ಅಂತ ಆಗಿದೆಯಾ ಯಾಕೆ ಇರಲಿಲ್ಲ ಅವತ್ತು ನೀವು ನೋಡೋಣ ವಿಲ್ಸಿ ಎಸ್ ಹಾ ಏನು ಅವ್ರು ಹೇಳ್ತಾ ಇದಾರಲ್ಲ ಒಂದ್ ನಿಮಿಷ ಪೊಸಿಷನ್ ನೋಟಿಸ್ ಕೊಡಿ 2:30ಗೆ ಎಸ್ ಇನ್ಫಾರ್ಮೇಶನ್ ಕಮಿಷನ್ಗೆ ಅರ್ಜೆನ್ಸಿನಾ ಕೊಡಿ 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 ಮಂಡೇ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಕೊಡಿ ಏನ್ ಬಿ ಗ್ರೂಪಾ ನೆನ್ನೆ ಬಿ ಗ್ರೂಪಲ್ಲಿ ಇತ್ತಾ FR ನಂಬರ್ ಇದ್ರೆ ಕೊಡಿ ತೊಂದರೆ ಕೊಡಿ ನಾಳೆ ಕೊಡಿ wait second row wait yes
disconnecting the electricity connection
2:30
Because temple jatra is scheduled on 24th. I moved that matter, country's matter. It did not reach on Monday. Maybe tomorrow will.
ನಾಳೆ ಕೊಡಿ ನಾಳೆ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಹಾಕಿ
My lords, there is a constitutional crisis, my lord. Yesterday I had mentioned. My right for peaceful protest is withdrawn in the last moment and police notice have been issued against me.
ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಕ್ರೈಸಿಸ್ ನೆನ್ನೆ ಬರ್ಲಿಲ್ವಾ ಅದು
ಇನ್ನು ರೀಚ್ ಆಗಲಿಲ್ಲ ಲಿಸ್ಟ್ ಆಗಲಿಲ್ಲ my lords. Only have it at 2:30 today.
ಆಯ್ತು ಕಾಪಿ ಎಲ್ಲಿದೆ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್
servant,
ಅಥಾರಿಟಿ ಕಾಪಿ ಎಸ್
Both the matters.
ಬೋಧ ಮ್ಯಾಟರ್ಸ್ ಕೊಡಿ
Grateful.
The Bescom disconnect electricity.
ಆಗಿ ಹೋಗಿದ್ಯಾ
ನೆನ್ನೆ ಕಟ್ ಮಾಡ್ಬಿಟ್ಟಿದೆ ಸರ್.
ಮಾಡ್ಬಿಟ್ಟಿದಾರ ಕೊಡಿ ನಾಳೆಗೆ ಹಾಕಿ ಎಸ್
2:30
ನಾಳೆ ಕಟ್ ಮಾಡ್ಬಿಟ್ಟಿದಾರಲ್ಲ
LB ಮ್ಯಾಟರ್ ಸ್ಟೇ ಇದೆ ಅದನ್ನು ಡಿಸ್ಕನೆಕ್ಟ್ ಮಾಡಿದೆ.
ಆಯ್ತು ಕೊಡಿ ಮಧ್ಯಾಹ್ನ 2:30ಗೆ ಹಾಕಿ ಮೇಡಮ್ ಡಿಸ್ಕನೆಕ್ಷನ್
Advocate, my lords, I've been constantly being harassed by the Kothur police station to appear before them, wherein there has been no complaint.
appear before whom
Appear before the police station, there has been no complaint that has been lodged, there has been no FIR.
where is the notice
My lords, I've not received any notice.
ಮತ್ತೆ orally you have been instructed even I will pass oral orders no written order
My lords, there's been calling and harassing me. since November.
that is not a ground to list the petition at all
But maybe take.
Arey, why, sir?
The CC or endorsement.
there is if there is any semblance of reasoning in what you say then I will take He's been called and harassed. What is that?
Sending third parties to my house to.
Where, sir? Complaint register ಮಾಡಿ.
My lords,
Complaint register ಮಾಡಿ.
my lords, we've already.
ಫೋನ್ ಮಾಡಿ ಕರೀತಾ ಇದ್ದಾರೆ ಅಂತ ರಿಟ್ ಪಿಟಿಷನ್.
Submitted my representations to DGP as well as the Commissioner of Police. My lords.
You have
There's been no
submitted?
action. There's been no action.
Ah,
It's
give
been
to-
almost 2
tomorrow.
months, my lords.
Tomorrow.
We take it tomorrow, please.
Yes. Tomorrow day after ಕೊಡಿ ಅದು. Yes. ಯಾವತ್ತಿಗಿದೆ ಸು? 2:30 ತಗೊಳ್ಳಿ. Pending matters. ಕೊಡಿ, give the memo. It won't be listed. No, not tomorrow. Just give it. Yes.
Direction, therefore I filed a press release.
ಕೊಡಿ 2:30. ಯಾಕೆ ಅಲ್ಲಿ ಹಿಂದೆ ಬರ್ತಾ ಇದ್ದೀರಾ? No, wait.
My lord, sir,
Second row, wait.
the bank has already taken possession. my lord.
Already
Sir,
taken,
yes,
ಕೊಡಿ.
yes.
Let's
Can you
say,
have it tomorrow? my lord?
Tomorrow day after we'll see.
issuance of sale certificate, my lord, sale has taken place. Issuance of sale, 2:30.
Tomorrow day after.
My lordship is,
ಏನು?
because they have
Auction
issued
purchaser,
notice,
ah?
they have issued notice
Auction
to,
purchaser ತಾನೆ?
no, we are the
Where?
trade sector, my lord. We are
Sale
the
certificate
owners,
ಯಾರ್
we are,
ಪರವಾಗಿ ಇಶ್ಯೂ ಮಾಡೋದು?
they are in residing in the scheduled property, my lord.
ಹಾ.
They are issued.
You are the
notice-
borrower.
Yes, my lord, they have
ಹಂಗ-
issued
ಹಂಗೆ
notice
ಹೇಳಿ
to
ಮತ್ತೆ.
vacate the premises because of
Give it,
issuance of sale.
2:30 ತಗೊಳ್ಳಿ.
Please.
GMAC
GMAC.
for a reach ಆಗಿಲ್ಲ ತಮ್ಮ ಮುಂದೆ.
ಸರಿ ಕೊಡಿ.
My lord, the matter pertains to the performance of Karga Mahotsava at
ಯಾವತ್ತಿದೆ?
4th is the date, my lord, but no orders has been passed by the Tahsildar who has to.
2:30. ಅದೆಲ್ಲ ಕಾಪೀಸ್. Wherever state is the party, copy will serve ಮಾಡಬೇಕು. Not in the AG's office. Will not grant stay otherwise.
Auction is scheduled on the 20th.
20th. Tomorrow ಕೊಡಿ.
Tomorrow.
Treatment.
ಒಂದು ನಿಮಿಷ. ನೀವು
List, date ಕೊಟ್ಟಿದ್ದು ಸ್ವಲ್ಪ list ಆಗಿಲ್ಲ.
ಅದು ಪರವಾಗಿಲ್ಲ ಕೊಡಿ. ಆಯ್ತು ಬರುತ್ತೆ. ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರ್ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದು ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಮಂಡೇ ಬರುತ್ತೆ ಕೊಡಿ.
Children suffering LDC.
ಹಾ.
Second round of litigation, first round in 2018.
ಪೆಂಡಿಂಗ್ ಫ್ರೆಶ್ ಸರ್?
Pending, sir.
ಕೊಡಿ. ಪೆಂಡಿಂಗ್ ಮೆಮೋಸ್ ಕೊಡಿ ಸರ್. ಪೆಂಡಿಂಗ್ ಮೆಮೋಸ್ ಕೊಡಿ. ಟುಮಾರೋ ಹಾಕಿ. 20th ಆಪ್ಷನ್ ಫಿಕ್ಸ್ ಆಗಿರೋದು ನಾಳೆಗೆ ಹಾಕಿ. ಹಾ. Friday it will come. Parted ಅಲ್ವಾ? Parted.
Allowed the writ petition and the division bench has requested my lord to reconsider.
We'll post it on Friday.
My lord, in the fresh matters this one.
Division bench has asked me to hear it, right?
Yes.
We'll post it in hearing list. Yes.
But a fresh matters. Been kept in the past 2 years.
Nigerian. ಹಾ.
Pending matter, my lord, the notice has been issued, but the matter has not come up.
ಆಯ್ತು ಕೊಡಿ ಅದನ್ನ. He's in detention to ಅದು ಫ್ರೈಡೆ ಹಾಕಿ. ಈಗ ಫಸ್ಟ್ ರೋ ಆಯ್ತಾ ಇಲ್ಲ? ಸೆಕೆಂಡ್ ರೋಗ್ ಬನ್ನಿ. ಎಸ್. ಸೆಕೆಂಡ್ ರೋ, ಥರ್ಡ್ ರೋ ಅಲ್ಲ. ವೇಟ್. ಎಸ್. ಬಿಫೋರ್ ಲಾಸ್ಟ್. ಸರಿ ಕೊಡಿ. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟ್ರ್ ಅಲ್ವಾ? ನಾಳೆ ಬರ್ಬೇಕು ಅಂತ ಆಗಲ್ಲ ಕೊಡಿ. ವೇಟ್. ಹಾ. ಕೊಡಿ. ಅದು ಫ್ರೈಡೆ ಹಾಕೋಣ ಕೊಡಿ. Be loud. Give it, yes. Give it. ಏನ್ ಅರ್ಜೆನ್ಸಿ ಕೊಡಿ. We'll see ಕೊಡಿ. Give it, we'll see. ಕೊಟ್ಟೆ, thank you. We'll see ಕೊಡಿ. ಎಸ್. ವೆಕೇಟಿಂಗ್ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಕೊಡಿ. ಮೇಡಮ್ ಅದು ಇಯರ್ ನೋಡ್ಬಿಟ್ಟು ವೆಕೇಟಿಂಗ್ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಯಾವ ಥರ ಹಾಕಿ. ವೇಟ್. ಎಸ್. 2:30.
Pending idea, time bound is there.
Tomorrow. Oh, you are in the second row? Yes. Tell me. Two thirty ಕೊಡಿ. Yes.
My lord, FR number 8760.
FR ನಂಬರ್ ಇಲ್ಲ. ಏನು ಆಕ್ಷನ್ ಯಾವತ್ತು? ವೇಟ್ ಮೇಡಮ್, ಏನು ಯಾವತ್ತಿದೆ ಆಕ್ಷನ್? 2:30. ನಿಮ್ದೇನು
Auction ಇದೆ
ಕೊಡಿ.
today's.
ಅದೇ 2:30ಗೆ ಸರ್. FR ನಂಬರ್ ಕಂಪ್ಲೈ ಆದ್ರೆ ಮಾತ್ರ.
My lords, it has to be vacated, my lords. The
It has to be vacated.
property has to be vacated as the retail outlet dealership has to be established. my
Oh,
lords.
seriously. Pending matter.
Yes, my lords, a hearing Friday.
ಕೊಡಿ. Yes.
My lords, it's on 20 and 20 or 21st, my lord.
We'll see. Give it. Yes. Wait.
Due to technical issues, Kaveri website registration in a bit.
ಕೊಡಿ. tomorrow day after give it, pending matter ಅಲ್ವಾ? ಫ್ರೆಶ್ ಆದ್ರೆ ನಾಳೆಗೆ ಹಾಕಿ. 2:30. Not? Madhukar, third row, wait. ಹಾ.
On the same address proof given to me.
ಏನು? ಡೊಮಿಸೈಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ಪೆಂಡಿಂಗಾ? ಕೊಡಿ. Give it, yes.
My lord, it's a vacation of stay. We are for IOCL.
Vacating stay ತಗೊಳ್ಳಿ ಮೇಡಮ್.
IOCL establishment of.
Vacating stay ತಗೋ ಹಾಕಿ ಅವರು.
He did this week.
Fix it.
My lords, for vacating stay, my lords.
Give that.
My lords, the petitioner have alternate remedy in state commission, but approached this honorable court. Kindly have this matter to.
ಕೊಡಿ, ನೀವು ರೆಸ್ಪಾಂಡೆಂಟಾ?
Respond.
ತೊಂದರೆ ಇಲ್ಲ ಕೊಡಿ. ಎಸ್.
Fresh matter. There's a debit freeze and I have been wrongfully pulled into the matter, my lords. I am nowhere included in the cybercrime. Kindly, my lords, tomorrow my account has been frozen and I'm not able to make any transactions. The AC court has passed an order to evict me from my shared house.
2:30. Where are you, sir?
My lords,
We have a National Commission for Backward Class.
What happened?
It is now a constitutional body.
Yes.
Earlier it was a statutory body. The writ petitioner, KPCL, had challenged our proceedings on the belief that we are still a statutory body.
All right.
The statutory body, we did not have power to summon. The matter was directed to be listed today. It is not listed.
ಅದು ASG ಅವ್ರದ್ದು ನಾಳೆ ಆಗ್ಬೋದಾ?
ನಾಡಿದ್ದು.
ನಾಡಿದ್ದು. ನಾಡಿದ್ದು ತಗೊಳ್ಳಿ ಮೇಡಮ್.
pick one.
ವೆಕೇಟಿಂಗ್ ಸ್ಟೇಗೆ ಹಾಕಿದ್ದೀರಾ?
ಅಲ್ಲ, the writ petition is not waiting.
Ah,
Vacating stay ಕೂಡ ಹಾಕಿದ್ದು.
Fine, yes.
My lords,
Day after tomorrow.
my lords, this another fresh matter.
ಹಾ? ಪೆರೋಲ್ ಕೊಡಿ. ಪೆರೋಲ್ ಎಲ್ಲ ಮಂಡೇ ಆಗ್ಬೋದಲ್ಲ? ಪೆರೋಲ್ಗೆಲ್ಲ ಮಂಡೇ ಕೊಟ್ಬಿಡಿ.
One
Wait,
memo
wait,
for
wait.
withdrawal, my lords.
Wait. ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಕೊಡಿ. ಹಾ? ಅದು ತಗೊಳ್ಳಿವೆ. ಮೇಡಮ್, ಅದು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಸೇರಿಸಿ ಲಿಸ್ಟ್ ಮಾಡಿಸಿ. ನಂಬರ್ ಕೊಡಿ. ಹಾ, ಎಸ್ ನಾವು.
Withdrawal, my lords.
ಹಾ? ಕೊಡಿ. ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಪರವಾಗಿಲ್ವಾ? ನಾಡಿದ್ದು ಆಗ್ಬೋದಾ? ಕೊಡಿ, ಥರ್ಸ್ಡೇ ಕೊಡಿ. ಹಾ? 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 ವಿಚ್ ಒನ್ ಸರ್? ಹಾ, ಗಿವ್ ಇಟ್, ಎಸ್. ಈಗ ರಿಲೀಸ್ ಮಾಡ್ಬೇಕು ಅರ್ಜೆಂಟಾಗಿ. ಪೆರೋಲ್ ಕೇಳಿ ಬೇಕು ಅಂದ್ರೆ, ಎಸ್. ಗಿವ್ ಇಟ್. Day after tomorrow, yes. Appointment of Friday. ಯಾರು ಕ್ಲೋಸ್ ಮಾಡಿದ್ದಾರೆ? ನಾಳೆ ಕೊಡಿ. ನಾಳೆ 2:30 ನಾಳೆ ಕೊಡಿ. ಬ್ಲಾಕ್ ಲಿಸ್ಟ್ ಆಯ್ತು ಕೊಡಿ. 2:30. Tomorrow.
Auction is on 26th, fresh matter.
ನಾಳೆ 26th ಮಂಡೇ ಬರ್ಲಿ ಬಿಡಿ. ಆಯ್ತು ಸರಿ ಕೊಡಿ. ಫ್ರೈಡೆ. Wait. Yes, madam.
Karnataka. 25 matter. Says in 15 days.
All right. It's a pending matter. It's a pending matter. Then next Tuesday ಕೊಡಿ.
Considering the urgency.
Serve ಮಾಡಿದ್ದೀರಾ? Have you served the respondents? All right, Friday? No, not tomorrow. Thursday, yes.
But our pending matter, there is no interim order. Yesterday I filed a interim application, but tomorrow maybe.
Monday.
The MESCOM has sent a notice threatening to blacklist me, my lords, and also they've illegally withheld.
Tomorrow.
My lords, 2:30, my lords.
ಆಯ್ತು ಕೊಡಿ. 2:30 blacklist.
Fresh tender matter. Stay was granted by this court.
2:30.
Stay work order.
2:30, yes. Pending ಕೊಡಿ. Pending
Fresh matter, my lord, the ozone urbana subvention scheme, twice it was memoed.
ನಾಳೆ ನಾಡಿದ್ದು ಹಾಕ್ತೀನಿ.
Lordship's order is there in this matter.
It's all right, give it, yes.
Tomorrow
day
for
after.
withdrawal, my lords.
Withdrawal ತಗೊಳ್ಳಿ. 2:30 ಹಾಕಿ.
Grateful.
Yes.
Bank matter frozen.
Pending
Pending.
Friday, Saturday ಬರ್ತದೆ.
Friday.
Saturday or
My lord,
Friday.
it's fresh matter. I have been wrongfully impleaded as a director of the company where I'm not even the director. And my lord, there is an executive.
Fresh matter.
Fresh matter.
Tomorrow,
Thank you. 2:30, please be in possession.
2:30, yes.
Pending matter, your lordship. Contrary to the interim order, the property has been sold for.
Next week, madam, give it.
From kindly have it tomorrow.
ಆಯ್ತು, ಇನ್ನೇನು ಮೆಮೊ ಮತ್ತೆ? ಫ್ರೆಶಾ? Vacation of interim order. Monday, give it. Monday, give it. ಅಲ್ಲ ಮಂಡೆಗೆ ಬರುತ್ತೆ, ನಾಳೆ ಆಗಲ್ಲ. ಗಿವ್ ಇಟ್ ಮೇಡಮ್. ಕೊಡಿ, ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರ ಟುಮಾರೋ ಕೊಡಿ. 2:30. ಎಸ್.
Pending matter.
ಆಕ್ಷನ್ ಸೇಲ್ ಟುಮಾರೋ 2:30 ಕೊಡಿ.
Pending matter.
Give the
Matter
memo.
pertaining to defreezing of the account.
ಬರುತ್ತೆ ಕೊಡಿ, ನೆಕ್ಸ್ಟ್ ವೀಕ್.
Extendo madam.
ಟುಮಾರೋ, ಎಸ್.
As per your lordship's order on the last date, which will be listed today, it's not come up on the causes today.
It will come on Monday.
Submit your
Monday, yes.
much-
This is pending writ petition. In this, tomorrow, the order, interim order is passed by this honorable court. In that, there is a slight modification, in oral order.
ನಾಳೆ
and,
being spoken to hakim.
No, there's no interim
ಆಯ್ತು,
order in
AM.
this matter.
ಹಾ,
They had asked for opening of the locks of the scheduled property.
ಕರೆಕ್ಟ್, ಏನಾಯ್ತದು?
That was allowed. I had.
ಅಷ್ಟೇ
said no
ಮಾಡಿದ್ದು,
objection.
ನಾನು ಅಷ್ಟೇ ಮಾಡಿರೋದು, ನೋ ಮಾಡಿಫಿಕೇಶನ್.
Bond now.
ಐ ಡಿಡ್ ನಾಟ್ ಗ್ರಾಂಟ್ ಸ್ಟೇ.
ಹೇಗಲ್ಲ sir.
ಮತ್ತೆ ಲಾಕ್ ಓಪನ್ ಮಾಡ್ಲಿಲ್ವಾ ಅವರು?
Half open ನಾಳೆಗೆ date ಕೊಟ್ಟಿದ್ದಾರೆ.
ಹಾ, ತಗೊಳ್ಳಿ.
ಮಾಡ್ತೀವಿ. ನಾವೇನ್ ನಮ್ದೇನ್ ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ವೇ ಇಲ್ಲ.
To take only the documents and.
ಇನ್ನೇನ್ ತಗೋಬೇಕು ನೀವು?
ನನ್ನ ಪರ್ಸನಲ್ ಬಿಲಾಂಗಿಂಗ್ಸ್ ಬೇಕು, ನಾನು ಯಾವ, ಇಟ್ಸ್ ಮೈ ರೆಸಿಡೆನ್ಷಿಯಲ್ ಹೌಸ್.
ಅವ್ರ ಮನೇಲಿ ಏನ್ ಬೇಕೋ ತಗೊಳ್ಳಿ ಅಂತ
ಎಲ್ಲ
ಸಬ್ಮಿಷನ್.
ಸಿ, ನಾನು ಐ ರಿಮೆಂಬರ್ ವಾಟ್ ಐ ಟೋಲ್ಡ್ ಆಲ್ಸೋ, ಎಕ್ಸೆಪ್ಟ್ ದಿ ಹೌಸ್ ಯು ಟೇಕ್ ಎವ್ರಿಥಿಂಗ್ ಅಂತ ತಗೊಳ್ಳಿ. ಅಯ್ಯೋ, ಅವರೇ ಹೇಳ್ತಾರೆ, ಡೋಂಟ್ ವರಿ ಅಬೌಟ್ ಇಟ್, ಯು ಟೇಕ್ ಎವ್ರಿಥಿಂಗ್.
ಮನೇಲಿ
ಅವ್ರದ್ದು ಏನಿದೆ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ.
ಎಲ್ಲಾನು
ಇಲ್ಲ ಇದಾರಲ್ಲ, ನೋ ಪ್ರಾಬ್ಲಮ್. ಅಬ್ಜೆಕ್ಟ್ ಮಾಡಿದ್ರೆ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಮೂವ್ ಮಾಡಿ ಮತ್ತೆ. ಆಯ್ತು, ಕೊಡಿ. ಆಲ್ರೆಡಿ ಟೇಕನ್ ಅಲ್ವಾ, ಮಂಡೇ ಕೊಡಿ. ಮಂಡೇ ಕೊಡಿ ಸರ್.
My lordship, this.
2:30.
ಪೊಸಿಷನ್ ತಗೊಂಡು ಆಗೋಗಿದೆ,
ಎಲ್ಲ ಒಳಗಡೆ ಇದೆ.
ಅದು ತೊಂದರೆ ಇಲ್ಲ, ಕೊಡಿ. ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಕೊಡಿ.
My lordship, this is for the parole, my lordship.
ಪೆರೋಲ್
This is very urgent.
ಮಂಡೇಗೆ ಆಗುತ್ತಾ?
No, my lordship.
ಅಯ್ಯೋ, ಯಾಕೆ?
Tomorrow is the,
ಏನ್ ಅರ್ಜೆನ್ಸಿ ಏನು?
because 20th is the last date, my lord, extension of parole.
ಪರವಾಗಿಲ್ಲ, ಎಕ್ಸ್ಟೆನ್ಷನ್
But
ಕೊಡಿ.
because son is
ನಾಳೆಗೆ
met with a serious accident, my lord.
ನಾಳೆಗೆ ಹಾಕಿ ಕೊಡಿ, ತಗೊಳ್ಳಿ.
Tomorrow, your lordships, the property has been sold for very less amount, your lordship.
ಮಂಡೇ
Contrary to the interim order.
ಮಂಡೇ ಸೇಲ್ ಆಗೋಗಿದೆ. ಏನ್ ಗೌಡ್ರಿ ಮತ್ತೆ?
ಕನ್ಸಿಡರೇಷನ್ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದಾರೆ.
ಹಾ.
ವಿವೇಕಾನಂದ ಸರ್ ಏನು ರಿಪೋರ್ಟ್ ಸಬ್ಮಿಟ್ ಮಾಡ್ತಾರೆ, ಡಿಸ್ಪೋಸಲ್ ಎನಿ ಡೇಟ್.
ಫ್ರೈಡೆಗೆ ಹಾಕಿ. ಎಸ್, ಸಾಕು ಎಲ್ಲ ಆಯ್ತಾ? ಲಿಸ್ಟ್ ಕೊಡಿ ಮೇಡಮ್.
ಫ್ರೈಡೆ.
ಎಸ್ ಜಯಕರ್ ಶೆಟ್ರ್, ಏನು
ಕನ್ಫರ್ಮೇಶನ್ ಆಗಿಲ್ಲ.
ಆಗಿಲ್ಲಲ್ಲ? ಮತ್ತೇನು ಹೋಯ್ತಾರ?
ಅದೇ ನಾವು ಕೋವಿಡ್ ಪೀರಿಯಡ್ ಅಲ್ಲಿ ಒಂದು ಸೇವ್ ಲೇಟರ್ ದೇ ಹ್ಯಾವ್ ಫೈಲ್ಡ್.
ಅಲ್ಲ, ಕೋವಿಡ್ ಪೀರಿಯಡ್ ಬಿಟ್ಬಿಡಿ ನೀವು, ತೊಂದರೆನೇ ಇಲ್ಲ. ಅಪ್ ಟು 22nd October 2022 ಐ ವಿಲ್ ಡೆಫಿನೆಟ್ಲಿ ಮಾಫಿ, ತೊಂದರೆ ಇಲ್ಲ. ಯಾಕಂದ್ರೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಗೇವ್ ಡೈರೆಕ್ಷನ್.
ನಂತರ ಅವರು
ಒಂದ್ ನಿಮಿಷ,
17/6
ಸರ್
ಪ್ಲೀಸ್.
ಅದರ ನಂತರ ಯಾವಾಗ ಆಗಿದೆ ಕನ್ಫರ್ಮೇಶನ್?
ಅಲ್ಲ, ಇವ್ರು ರಿಪಿಟಿಷನ್ ಹಾಕಿದ್ರು.
ಅವ್ರು ಬಿಟ್ಟಿತ್ತು, ಅದಕ್ಕೆ ಸ್ಟೇ ಇತ್ತಾ? ಇಲ್ಲಿ ಸ್ಟೇ ಇತ್ತಾ?
ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಗ್ರಾಂಟ್.
ಅಲ್ಲ, ಯಾವಾಗ ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕಿದ್ದೀವ್ರು?
17/6
17/6
22
17 ಅಲ್ಲ 20th June 22. ಆಲ್ ರೈಟ್, 17/6 ಇಟ್ಕೊಳ್ಳಿ. ಸೊ
However, my lord, if I may, even COVID, my lord, the various high courts have held that COVID is on limitation. Here, it's validity of the provisional attachment order. Hence, that Supreme Court direction also would not.
ಡೋಂಟ್ ವರಿ, ಅವ್ರೇನೋ ಹೇಳ್ತಾರೆ. ಕೋವಿಡ್ ಅಂತ ತಗೊಂಡ್ರೂ ಆಗಲ್ಲ.
ನಾರ್ಮಲಿ ವೆನ್ ರಿಪಿಟಿಷನ್ ಪೆಂಡಿಂಗ್ ಮೇಲೆ
ಹೌದಾ ಸರ್?
ಅಥಾರಿಟಿ
ಐ ವಿಲ್ ರೆಕಾರ್ಡ್ ದಟ್ ED will not act if writ petition is filed. ಸ್ಟೇ ಇಲ್ಲದೆ ಇದ್ರೂ ಪರವಾಗಿಲ್ಲ, ED will not act at all when writ petition is filed. Shall I record that?
ಅಲ್ಲ, ನಾರ್ಮಲಿ
Shall I record that?
ನಾರ್ಮಲಿ ಅಂತ ಹೇಳಿ
ಯಾವ ನಾರ್ಮಲಿ? ಸ್ಟೇ ಇದ್ರೂನು ಇವ್ ಆಕ್ಟ್, ಇಲ್ಲದೆ ಇದ್ರೆ ಏನ್ ಬಂತು?
ನಮಗ್ ಬೇಕು.
ಅಂಡ್ ಮಾಡಿಲ್ಲ ಅಂದ್ಮೇಲೆ ಮಾಡಿಲ್ಲ ಅಷ್ಟೇ, ಆಸ್ ಸಿಂಪಲ್
ಮಾಡಿ.
as that.
That is
ನೀವು ಇದೀರಾ ಇದರಲ್ಲಿ?
The difficulty which has arisen is that an identical matter arising out of the same transaction.
ಹಾ.
Which is, we could move the memo and have it listed.
ಹ್ಮ್.
And that could be considered because it is an identical matter.
So let it come, we'll pass an identical order in that also.
My lord, consider posting that.
No, sir. We'll do it, yes. We'll finish this, ಆಮೇಲೆ ನೋಡೋಣ. Actually, if it is different. No, this has been getting adjourned for the last 4-5 occasions on this ground. Yes, ಅಷ್ಟೇ ಅಲ್ಲ ಜಗದೀಶ್. The petitioner, whoever judgments ಕೊಡಿ.
Please.
ಯಾಕೆ ಇದು ರಿಪೋರ್ಟ್ ಆಗಿಲ್ವಾ?
My lord,
ರಿಪೋರ್ಟ್ ಆಗಿಲ್ವಾ?
please.
Which is the one
Para 20, my lord.
of
page 9, the first judgment, para 20 at page 9.
Yes.
A reading of the above provisions would clearly show that 180 days before the passing of the provisional attachment order is not prescribed as a period of limitation to do a particular act, but as the outer period of validity of the provisional attachment order itself. Further, my lord.
But why you don't act? ಸುಮ್ನೆ ಇರ್ಲಿ ಅಂತ.
Please, my lord.
ಅಲ್ಲ ಸುಮ್ನೆ ಏನು ಮಾಡೋದ್ ಬೇಡ ಅಂತ. ನೀವ್ ಯಾಕೆ why do you keep quiet in the sense ಇಡಿ
ಅಥಾರಿಟಿಗಳಿಗೆ
ಮರ್ತು ಬಿಟ್ಟಿದ್ದಾರೆ. Yes.
Please, para 30, my lord, at page 20. In the present case, section 5.1 and 5.3 do not provide for the period of limitation, but the period
Para?
of validity of the provisional.
Sorry, Monica madam. Para?
This is para 20, my lord. Para 30, I'm sorry, at page 20, my lord. Further, at para 37, my lord,
One moment.
at page 29.
Para 37.
Please, ma'am. The 180 days from the date of provisional attachment order having expired without any order under section 8.3 of the act being passed by the adjudicating authority, it is held that the adjudicating authority has been rendered functus officio and cannot proceed with the original complaint.
Yes. We'll close it, sir. Jagar Shet. The petitioner.
filed objection ಮಾಡಿದೆ. Stand ಮೇಲೆ.
ಏನು ಕೋವಿಡ್ ಬಗ್ಗೆ ಹೇಳಿದ್ದನ್ನ?
ಕೋವಿಡ್
ಆಯ್ತು ಸರಿ. ನೀವಿದ್ದೀರಾ ಸರ್?
My
ನೀವು
my
ಕೋವಿಡ್
name-
ಬಗ್ಗೆ
my-
ಹೇಳ್ತಾ ಇದ್ದೀರಾ?
My name may be replaced with Jaikar Shekhi
ಅಷ್ಟೇ.
in one matter.
in one matter.
ಅಲ್ಲ ಇನ್ ಮಿಕ್ಕಿದ ಎರಡು ಮ್ಯಾಟ್ರು
ಅದ್ರಲ್ಲಿ
Jaikar- In all the matter, Mr.
ಎಲ್ಲ ಜೇಕರ್ ಶೆಟ್ರ ಇದಾರ? The petitioner, common petitioner is what?
different one.
The petitioners in all these cases call in question the act of the respondent enforcement directorate in terms of an order date, they call in question the order of provisional attachment in order number 13 of 2021 dated November the 2nd, 2021, attaching the properties of the petitioner, invoking its power under subsection 1 of section 5 of the Prevention of Money Laundering Act 2002, hereinafter referred to as the Act for short. Heard so and so. A complaint comes to be registered on March the 3rd, 2018 against Vikram Investments, and the complaint was alleging that amounts invested in the said investment company were not returned by the organization. After the registration of the complaint, the Enforcement Directorate registers an enforcement case information report, the ECIR, in so and so for conduct of investigation under the provisions of the Money Laundering Act. In furtherance whereof, on November the 2nd, 2021, a provisional attachment order is passed by the first respondent under section 5.1 of the Act, attaching the properties of the petitioners in all these cases. On the basis of the provisional attachment order dated 2nd November 2021, a complaint under subsection 5 of section 5 of the Act comes to be filed before the second respondent. The respondent then issues a show cause notice on 17th November 2021, to which a reply is said to have been submitted by the petitioner. 17.5, 17.5, yes. A show cause notice is said to have been issued on December 17, 2021, to which the petitioners have said to have submitted their reply. After submission of the reply, the petitioners are at the doors of this court calling in question the order of attachment. The order of attachment on the score that the order of provisional attachment on the score that the attachment has not become final as it is not confirmed within 180 days as obtaining under subsection 8 alladu?
Please, my lord.
Under section 8, subsection 3 of section 8 of the Act. The learned counsel Monica Patil, appearing for the petitioner, would vehemently contend that the action of the respondent in not passing an order of confirmation as obtaining under subsection 3 of section 8 of the Act would render the provisional attachment a nullity, and the officers therein would become functus officio to pass an order beyond the period of 180 days which is a statutory validation period under the Act. She would seek to place reliance upon plethora of judgments of the high courts to buttress her submission that the very act of provisional attachment has today become a nullity. The learned counsel, per contra, the learned counsel Jaikar Shetty, appearing for the respondent, would seek to refute the submission, taking recourse to the orders passed by the apex court during COVID-19. The apex court from 24th March 2020 to 22nd October 2022 has protected the period of limitation by several orders intermittently passed. The council seeks to take recourse to the same and contend that the order of the 180 days period of outer limit of 180 days for validation should be extended.
It's the appealable order, my lord, PA.
It's all right. Should be jurisdiction, sir. Should be extended. And the petitioner has a remedy of filing an appeal against the said order of provisional attachment. The learned counsel would further contend in any so and so. The learned counsel would thus contend that the period of limitation that was extended to all the entities should be extended to the respondent as well. But would admit the fact that even as on date, there is no order passed under subsection 3 of section 8 confirming the provisional attachment that was made made on our date
2/11.
on 2/11/2021. I have given my anxious considerations once. The aforenarrated facts are not in dispute. The Respondent Enforcement Directorate is empowered to attach a property on the registration of an ECIR on the basis of complaint or investigation that would ensue after the registration of the ECIR. This has happened in the case at hand on 2/11/2021. The properties of the petitioners herein are provisionally attached, invoking power under subsection 1 of section 5 of the Act. After the of the Act, the section 5 reads as follows: for an attachment to become final, an order under final or to be confirmed, an order under subsection 3 of section 8 is mandatory. The section 8 reads as follows. Subsection 3 of section 8 mandates that in the event the order would not be validated within 180 days of passage, the provisional attachment order would lose its efficacy. This is what has happened in the case at hand. On 2nd November 2021, the provisional attachment order is passed. We are in March 2025. Even today, there is no order passed confirming the said attachment as is necessary under under subsection 3 of section 8. The period of 180 days is long over, and the Respondent Enforcement Directorate has lost its power under the statute to pass an order today. The learned counsel for the petition respondent submits that the benefit of extension of limitation should be extended to the Enforcement Directorate as well. The submission is noted only to be rejected, as this is not limitation for filing of a case or otherwise to a litigant. It is the period of validation. If the order is not passed within 180 days, the statute itself says that the statute itself would mandate that the order would be a nullity. Once the order,
Pendency of writ.
And the order having become a nullity cannot be given a breather by extending the limitation period as is done by the apex court during COVID-19. Another submission is made that during the pendency of the writ petition, the Enforcement Directorate did not want to pass the order. This said submission is noted only to be rejected. The petition was filed. There was no interim order of stay granted till 2025. Therefore, for a period of 3 years, the Respondent Enforcement Directorate have not passed the order of confirmation, cannot now contend that they were wanting orders from the hands of this court. Both these submissions are noted only to be rejected. The rigor of the statute would run for all time to come, except when this court would stall the hands of the respondent in passing the order. That none of those things have happened till 2025. in the light, 2025, it becomes apposite APPO. Apposite to refer to the judgments of the different high courts on the issue, holding it that the enforcement directorate would become functus officio if they would not pass an order within 180 days to pass an order after 180 days. In that light, the petitions deserve to succeed and the impugned provisional attachment to be obliterated. So and so allowed first.
Great.
Listing of my matter.
Move ಮಾಡಿ sir. Copy ಬಂದ್ಮೇಲೆ move ಮಾಡಿ sir. Yes, same
Transaction.
same transaction.
Arising of same transaction, co-petitioner, co-accused.
ಜೇಕರ್ ಶೆಟ್ಟಿ ಅದ್ರಲ್ಲಿ ನೀವೇ ಇರೋದಾ? ಅದ್ರಲ್ಲಿ ನೀವೇ ಇರೋದಾ? ಮೆಮೊ ಕೊಡಿ ನಾಳೆಗೆ ಹಾಕ್ಸೋಣ.
Same transaction.
ಇಲ್ಲ ಫ್ರೈಡೇಗೆ ಆದ್ರೆ ಕಾಪಿ ಇರುತ್ತೆ, ವಿಲ್ ಡೂ ಇಟ್. ಆಯ್ತು ನಾಳೆಗೆ ಹಾಕಿ. ಸೇಮ್ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಅಂದ್ರೆ ನೋ ಪ್ರಾಬ್ಲಮ್, ಗಿವ್ ಇಟ್. ಎಸ್ ಎಸ್ ಕೊಡಿ ಕೊಡಿ ನಾಳೆಗೆ ಹಾಕಿ.
I'm ready to apply. I'm hoping for a similar order tomorrow.
ಏನು ಗೊತ್ತಾಗಲ್ಲ, ನಾಳೆ ಬೇರೆ ಬರಿಬೋದು. ಅಲ್ಲ ನಾಳೆ ಬೇರೆ ಬರಿಬೋದು.
I will try my level best.
ಎಸ್ ದಿ ಲೈಟರ್ ವೇ. ಎಸ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ಹೇಳಿದ್ನಲ್ಲ.
It's a writ for mandamus, my lord.
Correct.
Seeking for a direction to presentation may be considered, my lord, at annex E, my lord.
ಕನ್ಸಿಡರ್ಡ್ ಅಂಡ್ ರಿಜೆಕ್ಟೆಡ್ ಅಂತ ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದಿನಲ್ಲ.
Copy I have not received.
Copy also was served to you. Sir, if you are aggrieved, challenge that. This
I may be permitted to convert it into a writ of certiorari.
ಕನ್ವರ್ಟ್ ಆಗಲ್ಲ
I have
ಸರ್,
passed the
ಇನ್ನೊಂದು
order,
ಹಾಕ್ಬಿಡಿ.
I will convert this to a. writ of
ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡೋಂದ್ರೆ ಮಾಡಿ, ಏನ್ ತೊಂದ್ರೆ.
I will convert it into a writ of.
ಕನ್ವರ್ಷನ್ ಎಲ್ಲ
For a
ಕೊಡಲ್ಲ.
direction.
ಡೈರೆಕ್ಷನ್ ಫಾರ್ ಕನ್ವರ್ಷನ್ ಇಲ್ಲ.
I'll
Passing
amend.
2023, my lord. Now they cannot seek for a conversion.
ಕನ್ವರ್ಷನ್ ಯಾರು ಕೊಡ್ತಾರೆ?
They are asking for.
Amendment ಮಾಡ್ಕೊಳ್ತೀನಿ.
ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿ. You have a right to amend it.
Writ of certiorari.
ನೀವ್ ಏನ್ ಬೇಕಾದ್ರೆ ಮಾಡಿ ಸರ್. I will not pass any order.
Please.
This court on 11/3/2025 had passed the following order. The learned counsel for the petitioner now seeks leave of this court to raise a challenge to the order dated 31/8/2023 by filing an appropriate application. List after 2 weeks, 3 weeks, 4 weeks.
Please. Date may be.
First haki sir. Yes.
Three. For the petitioner, my lord, matter pertaining to composition of RERA appellate tribunal.
ಇನ್ನು ಆಗಿಲ್ಲಲ್ಲ?
ಆಗಿಲ್ಲ.
We'll grant you 2 more weeks time. List after 2 weeks. Yes. Execution ಅಲ್ಲೇ ಮೂವ್ ಮಾಡಿಲ್ಲ ಅಲ್ವಾ? ಮಾಡಿದ್ರೆ ಮೂವ್ ಮಾಡಿ, I'll grant stay also. Yes.
The handicapped applied for.
ಗೊತ್ತಾಯ್ತು. Yes.
We're trying to collate all the documents and see
No.
how many handicapped people have made an application,
Correct.
my lord,
Mm.
in all districts.
Hmm.
It's taking a little bit of time, my lord.
When do you want?
10 days, my lord, we'll.
Bless the matter on 2nd April.
Please.
Bless the matter on 2nd April at the request to learn HCG. Next.
Five.
Respondent, 2 weeks time may be granted to file my objection.
ಏನಿದು?
My lord, the respondent issued a demand notice.
Enter ಮಾಡಿದ್ಯಾ?
ಇಲ್ಲ. 2 weeks.
Learned counsel for the respondent seeks 2 weeks time to file statement of objections. Bless the matter on 3rd April. Objections if any by then.
Yes, much.
Six.
Deputy for respondent number 1, my lord.
I undertake to file wakalat in for the petition. No, see. Blood that Janaushadhi blood store.
ಓ ಮತ್ತೆ ಈಗ ಏನ್ ವಕಾಲತ್ತು?
My lord.
ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗೋಗಿದೆ.
We have
Yes.
issued the.
Who was the counsel ಅವಾಗ? Badrinath.
Badrinath
Yes.
has issued the NOC.
He said he will shift the premises.
No, my lord, we have issued the.
ಈ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಹಿಯರಿಂಗ್ ಆದ್ಮೇಲೆ NOC ಎಲ್ಲ I will not accept. Don't do all this.
We have taken back.
Just because court is against you, you can't bring in another counsel. Anything else? Huh? Hearing ಆಗಿದೆ. We'll pass orders.
That's one opportunity when we go.
No.
Beyond
Heard reserved.
beyond my lord, 1 kilometer from my point.
It's all right. ಈ ತರ ಕೌನ್ಸಿಲ್ ಚೇಂಜ್ ಮಾಡಬಾರ್ದು, ಎಲ್ಲ ಹಿಯರ್ ಆದ್ಮೇಲೆ.
ಇವಾಗ ಇನ್ನೂ ಫೈಲ್ ಬಂದಿಲ್ಲ, ಇವಾಗ ನೇನು.
Counsel already ಆಗಿದೆ. Your second counsel.
Heard reserved.
Great.
Badrinath was completely heard. He said he'll seek instructions from the petitioner to withdraw the petition.
My lord, I appear for the behalf of the petitioner.
Huh?
He has issued the NOC to the parties, my lord.
Parole. I will not permit such things. Yes, next.
Grateful.
Dated 10/3/2025, the lordship has passed the order
Huh?
regarding
Why
the
work order is not issued?
Fifth respondent.
Work order is not issued.
Fifth respondent.
Who is the
my lord.
fifth respondent?
He is not before this court.
Mysore paper mill, my lord.
Serve ಮಾಡಿಲ್ಲ ಅವ್ರಿಗೆ.
So, served, my lord, unrepresented.
ಯಾವಾಗ ಸರ್ವ್ ಆಗಿದೆ ನೋಡಿ ಮೇಡಮ್. And summons ತಗೊಳ್ಳಿ. It is useless if I pass an order. Otherwise. ನಿಮಗೆ ಬೇಕು ಅಂದ್ರೆ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಕರ್ಕೊಂಡ್ ಬನ್ನಿ, ಡೈರೆಕ್ಟ್.
They'll also have to place their security deposit in these matters.
Let him come and say that security deposit is not placed.
Please.
ವಸಂತ್ ಯಾರಿಗೆ?
For Veena Kumari, my lord.
Who is ವೀಣಾ ಕುಮಾರಿ?
No, no, no.
Serial.
This is serial number.
Respond ನಮ್ ವೀಣಾ ಕುಮಾರಿ.
Serial number 8.
All of us.
All others ಅಲ್ಲ. Next matter ಹೇಳ್ತಾ ಇದೆ. Yes. So the petitioner shall serve the fifth respondent. Paper mills, you are here.
Sorry, my lord. I was-
Learned counsel registered to print the name of Prashant
Sure.
BV ಅಲ್ಲ?
BR.
Prashant BR is appearing for the fifth respondent, Mysore paper mills.
No.
ಈಗ ವರ್ಕ್ ಆರ್ಡರ್ ಯಾಕೆ ಇಶ್ಯೂ ಮಾಡಿಲ್ಲ ಅವ್ರಿಗೆ?
My lord, there are few developments after that, representation, my lord, they have given one more representation on 1/7/2024. After that, they have been considered, and in one, this one, they have given the work order.
Only 500, sir.
ಅದೇ ಅದು ಕೊಟ್ಟಿದೆ, ಅದನ್ನೇ ಬರ್ದಿರೋದು ನಾನು.
ಅದಾದ್ಮೇಲೆ ಇನ್ ಎರಡಲ್ಲಿ, some negotiation was going on, my lord.
Negotiation.
My lord, and also there are few documents, my lord, which I have to submit to the court. my lord. Weeks take.
ನೆಗೋಷಿಯಬಲ್ ಮ್ಯಾಟರ್. ಎಸ್.
My lord, out of. my
ಆಯ್ತು,
lord,
ಈಗ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಯು ರಿಡೀಮ್ ದಿ ಗ್ರೀವೆನ್ಸ್ ಆಫ್ ದ petitioner. Otherwise I will pass an order because you have come today. I am giving you a week's time.
My lord, I have few documents, my lord.
ಎಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ, ಎಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ, I will take it next Tuesday.
My lord, one submission, my lord. Pulp order, my lord, 3,000.
ಈಗ ಒಂದ್ ಬಂದಿದ್ದಾರೆ ಅವರು ಮುಂದಿನ ಮಂಗಳವಾರ ಇಫ್ ದಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಆರ್
Agreement ಅಲ್ಲಿ, ಒಂದ್ agreement ಅಲ್ಲಿ 3,600 metric ton ಗೆ ಬರೀ 500 metric ton ಗೆ ಮಾತ್ರ ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಒಂದು ವಾರದಲ್ಲಿ ಸಪ್ಲೈ.
I'll tell you, I can pass an order right away on merits. ಅವ್ರು ಇವತ್ತು entry then an appeal will be
Yes, I
filed.
understand.
I was not heard.
I understand the difficulty of my friend.
List the matter on Tuesday, the next in the fresh matters list. Yes.
Please.
At the BR Prashant ಅಂತ ಹೇಳಿದ್ರಲ್ಲ, registry to print. Yes.
Please.
Next.
8.
ವೀಣಾ ಕುಮಾರಿ. ಇದರಲ್ಲಿ ಎಲ್ಲಿ ವಸಂತ? ಎಸ್.
The last occasion, your lordship has directed
Lord, and
to
4/3,
survey the land.
4/3, my lord, there's direction, my lord, to the environmental officer, my lord, to.
What happened?
No, we conducted a survey, my lords. We found that, my lords, the report is ready. My lords, may give me a day's time, I'll file it before the court. What we found out is that, my lords, the survey number, what the petitioner is claiming, and the unit which is being put up for the solid waste management are two different, my lords. And in fact, there's a compound.
No, two different. It is at the radius 500 meters, huh?
Yes.
Adjacent to it, anta that is
To
there.
this land only.
ಅಲ್ಲ ಕೊಡ್ಲಿ.
It's,
Let them file a report.
Let him,
I will, that's.
Thursday,
Please, my lords.
Thursday fresh matters list. Yes. You will file a report by then. Learned counsel A. Mahesh Chaudhary seeks days accommodation to file the report of inspection so conducted pursuant to the order of this court.
Great.
9.
For respondent number 2, respondent number 1, my lord. I am filing my statement of objections, my lord.
Copy ಕೊಡಿ ಅವ್ರಿಗೆ.
And Indian appeal.
Madam.
Insurance claim repudiated. Why you are for the insurance, is it? Oh, ಇವರು ಬ್ಯಾಂಕ್ ಗೆ.
I am for the bank, my lord.
What is the reason for repudiation?
My lord, ink page number 10, my lord, in my statement of objections.
1 minute. Yes, madam. ಹೇಳಿ. Objection ನೋಡ್ಬೇಕಾ? Objections ನೋಡ್ಬೇಕಾ? ನಾಳೆ ತಗೊಳ್ಳ? Yes. or we'll take it on Friday?
Please.
Friday in the fresh matters list. Objection, learned counsel for the first respondent files a statement of objections. Same is taken into the file. List the matter on Friday in the fresh matters list. ನೀವು ಹಾಕಿದ್ದೀರಲ್ಲ?
Petitioner.
Friday in preliminary hearing ಅಂತಾರೆ. Friday in preliminary hearing, yes.
Lord, I apologize, my lord. Copy was served upon them. Prepared an objection was not filed. I made a mention that objection is filed. I apologize, Lord, it is here.
ನೀವು ಕಾಪಿ ಎಲ್ರಿಗೂ ಕೊಟ್ಟು ಕೋರ್ಟ್ಗೆ ಕೊಡಲ್ಲ.
I apologize. Now they have stated whatever the facilities they have given, that has to be stated. Regarding this aspect, like on the day, first day also I mentioned, my lord, my objections are not in an adversarial form.
Correct.
I just wanted to bring the facts before the court, and with all due respect to the martyr. Only thing is, my lord, the policy incentive said that we would give them a site at his native place or an equivalent cash amount of 4,50,000 rupees. Now here is a unique case where, my lord, her housing is taken care till 2030. That is till the day that the martyr would have superannuated. That she is residing in a government quarter. Now, my lord, their specific prayer is that they want a site from the BDA. But it is not that if they had said that they need an site in Bangalore because they don't, because he's from a native of Maharashtra. If your lordship could kindly see
Native of Maharashtra.
No, yes, ma'am.
Now kindly peruse the annexure, yes, my lord. Even commandant ಅವರೆಲ್ಲ ಬೇರೆ ಬೇರೆ ಕಡೆ ಇದು ಸ್ಟೇಟ್ ಅಲ್ಲಿ ಮಾಡಿದ್ರು ಸಹ they have given the PDA sites ಕೊಟ್ಟಿರ್ತಕ್ಕಂಥದ್ದು ನಕ್ಸಲೈಟ್ attack ಅಲ್ಲಿ.
That what he's telling.
Again Prabhakar Bande case ಅಲ್ಲೂ ಸಹ they have given the BDA site.
That Venkatramanali case, where the BDA sites were given, the first case of a Naxal attack in the state of Karnataka. At that point of time, then the ruling government had made an announcement itself that they will give them a site. Then such incidents occurred at several places, my lord. Then the government has framed a policy. In the policy, my lord, they have taken care of the families of the deceased, the martyred personnel, by giving them educational benefits, marriage, children marriage fund, and housing and other things, my lord. And also in this case also, my lord, this petitioner is given a employment, compassionate employment also.
It's given?
Yes, yes, sir. Yes.
Compassionate employment ಕೊಟ್ಟಿದ್ದಾರಾ?
Yes. He's working in employment. Now, my lord, the only prayer what happens is, my lord.
4.5 lakhs ಕೊಟ್ಟಿದ್ದಾರೆ.
That what had happened was the amount was kept ready. My lord, she gives a letter to us saying that I have moved a writ petition before the court. Please hold the amount till the outcome of the writ petition. Now, my lord.
ಈಗ ಕಂಪ್ಯಾಷನ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
Yes.
4.5 lakhs ಕೊಡ್ತಾರೆ, ಇನ್ನು ಜಾಸ್ತಿ ಕೊಡಕ್ಕೆ ನೋಡೋಣ, we'll see. But how are you entitled to a site in precincts of BDA?
They have permanent resident at Bangalore. Other cases, even the Naxal attack ಪಾವಗಡದಲ್ಲಿ ಆಗಿರ್ತಕ್ಕಂಥದ್ರಲ್ಲೂ ಸಹ ಸೇಮ್ ಸೆಟ್ ಆಫ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಇರ್ತಕ್ಕಂಥದ್ದು ಅದರಲ್ಲೂ ಸಹ BDAದಲ್ಲಿ ಪ್ರೊವೈಡ್ ಮಾಡಿದ್ದಾರೆ. ಈವನ್ ಪ್ರಭಾಕರ್ ಬಂಡೆ ಇರ್ತಕ್ಕಂಥದ್ದು ನಾರ್ತ್ ಕರ್ನಾಟಕ ಅವ್ರಿಗೆ
ಯಾವಾಗ ಅದಾಗಿದ್ದು?
2007 ಮೇಲೆ.
7 ಅಲ್ಲಿ, ಆಮೇಲೆ
2007.
ಅದೊಂದೇನಾ?
Yes, ma'am.
ಮಿಕ್ಕಿದೆಲ್ಲ ಯಾವಾಗ ಆಗಿದ್ದು?
Subsequent ಆಗಿ 2016 ಪ್ರಭಾಕರ್
ಪಾಲಿಸಿ ಬಂದಿದ್ದು ಯಾವಾಗ?
ಪಾಲಿಸಿ 2007 ಮೇಲೆ.
7 ಏನ?
Yes, ma'am.
How could you violate the policy then and not give it now?
Page number 22, ma'am. Annexure 26/10/2006, ma'am.
24 to 2007 ಯಾರಿಗೂ ಕೊಟ್ಟಿದ್ದೀರಾ?
Yes, ma'am. Even ಎಲ್ಲರಿಗೂ ಅಲಾಟ್ ಮಾಡಿದ್ದಾರೆ. ನಕ್ಸಲೈಟ್ ಸೇಮ್ ಅಟ್ಯಾಕ್ ಆಗಿರೋರಿಗೆ ಆಲ್ರೆಡಿ PDAದಲ್ಲಿ ಪ್ರೊವೈಡ್ ಮಾಡಿದ್ದಾರೆ.
That is the Venkatraman.
ನಾವು 2012 ಇಂದ given the representation, but
ಅವ್ರಿಗೆಲ್ಲ ಏನೇನ್ ಕೊಟ್ಟಿದ್ದೀರಾ? ಕಂಪ್ಯಾಷನ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಇಲ್ಲ.
ಯಾರಿಗೆ?
ಎಲ್ಲರಿಗೂ ಹಾಗೆ certain benefits, the marriage benefit and all has not been given to them. My lord, that is the first case of Naxal attack in the state of Karnataka. Pavagada. My lord,
Anyway, let me see the objections.
yes, my lord.
ಇವಾಗ
My lord,
ಕೊಟ್ಟಿದ್ದೀರಾ?
if I can mention this, they have not made an application to the PDA, my lord. Now, my lord, my learned friend also very fairly submitted to the court that day, as per Rule 5F, there is provision to consider their cases as a special case.
Which rule 5F?
PDA.
ಯಾವ rule?
Department of Site Rules. So if at all it can be observed, then she can take this money and make an application there.
ಕೊಡಿ.
F, my lord.
Stray sites.
Yes.
Dependents who died while on duty. G category sites.
Alla, G, G, alla, F, my lord, ಅದಕ್ಕೆ very clear F.
Yes.
F R will G there.
Trace it, G category less. D category is now what?
Yes.
Now,
Whatever.
We'll consider in terms of this.
But they'll have to make an application in a prescribed format.
annexure B ಮೇಲೆ annexure B.
ಮಾಡಿದ್ದೀರಾ ಅಪ್ಲಿಕೇಶನ್?
ಇಲ್ಲ, ಇದು ಗವರ್ಮೆಂಟ್ ಕೊಟ್ಟಿರ್ತ ಗವರ್ಮೆಂಟ್ ಇನ್ಸೆಂಟಿವ್ ಕೊಟ್ಟು ಅವ್ರು ಫಾರ್ವರ್ಡ್ ಮಾಡಿರ್ತಕ್ಕಂಥ.
ಆಯ್ತು, ನೀವು ಮಾಡಿ ಈಗ ಅಪ್ಲಿಕೇಶನ್ ಕೊಡಿ, ದೇ ವಿಲ್ ಕನ್ಸಿಡರ್ ಇಟ್.
Again ಮತ್ತೆ ಈಗ ಆಲ್ರೆಡಿ 30
madam?
years. To BDA. Now they direct the government to consider the representation and make.
That I will
necessary
direct.
amendment. Yes.
Government consideration representation I will direct. They will, you have,
we will
you have
also
seen the
issue-
objections. They will quote everything and then leave it.
So issue a letter of recommendation also to the BDA, my lord.
Now,
That's yours, all these.
Page annexure B, page number 10.
No,
please.
if we will dispose it, that's not the
The
problem.
official recommendation issued.
ಈಗ
in the year
ನಿಮ್ದು
2012.
mandamus to consider the representation.
Representation.
That I will direct. By observing everything, I will direct. The petitioner is before this court seeking a direction by issuance of writ in the nature of mandamus to consider the representations submitted to the respondents on 21st August 2017, 30th August 2017, and May the 2nd, 2018, and have sought a consequential direction for grant of an allocation of site to the legal heirs of the martyr. The heard so and so. Facts in brief, Germain, are as follows. The petitioner is the widow of one, Mahadev S. Mane. Mahadev S. Mane lost his life while on duty due to an Excel attack in Udupi district on October 8th, 2011. In terms of the policy prevailing for grant of benefits to the family of those who die as those who would die in the manner that is projected in the case at hand, the petitioner the Inspector General of Police recommends the case of the petitioner noticing his sacrifice during the Nexel operation, and the recommendation was for grant of all benefits. The state has a policy for grant of benefits to the martyrs who would die in attacks of this kind. The policy page ಹಾಕಿದ್ದೀರಾ?
20,
Annexure.
25, 20, page 25. In the petition.
ಇದು ಆರ್ಡರ್, ಇದು ಪಾಲಿಸಿ ಅಲ್ಲ. ವೇರ್ ಇಸ್ ದ ಪಾಲಿಸಿ?
ನಡವಳಿಗಳು.
Page number 13, my lord.
13.
Annexure D. In respect of this.
Have framed a policy in terms of a government order dated 17th July 2017.
Yes, my lord.
7 ಇಂದಾನೆ ಇದೆ ಅಂದ್ರು?
17, that's what, 7 is the.
Seven is
Where the
the-
sites are given, my lord, is a complete different facts altogether. That is the first attack that had happened. There.
ಅವಾಗ ಪಾಲಿಸಿ ಇರಲಿಲ್ಲ.
ಇರ್ಲಿಲ್ಲ.
The first time 7 al tartare, 2007 al 24 to 2007.
First time government order is issued on 17 July 2017.
24, page annexure, the annexure B, page number.
ಅದರಲ್ಲಿ ಕೆಲವು ಬೆನಿಫಿಟ್ಸ್ ಇದೆ
Yes, my lord.
ಕೊಡಕ್ಕೆ.
ಅದು ಈ ಕೇಸಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಮಾಡಿದ್ದಾರೆ. ಜನರಲ್ ಬಂದು.
ಈ ಕೇಸ್ ಸಂಬಂಧಪಟ್ಟಂತೆ ಮಾಡಿದ್ದ?
Yes.
ಮಹಾದೇವ್, ಎಸ್. ಜನರಲ್ ಎಲ್ಲಿದೆ?
ಜನರಲ್ ಬಂದು ಪೇಜ್ ನಂಬರ್ 10 annexure B ನಲ್ಲಿ 24 to 2007 ಮೇಲೆ. But of the details.
24 to ಎಲ್ಲಿದೆ? 24 to
ಉಲ್ಲೇಖ ಒಂದು.
ಉಲ್ಲೇಖ ಅಲ್ಲ ಸರ್, ಪಾಲಿಸಿ ಎಲ್ಲಿದೆ?
Policy ಇಲ್ಲ. No policy.
Have you produced something?
No.
2011.
I have not put it.
This is the problem. Where is the policy, sir? 2007 policy ಎಲ್ಲಿದೆ?
I will.
ನಿಮ್ಮ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದೀರಾ ಏನಾದ್ರು ಜಾಫರ್?
ನಾವು ಪಾಲಿಸಿ ಹಾಕಿಲ್ಲ. We have.
ನಮ್ಗೆ ಏನ್ benefit
Order that
ಕೊಟ್ಟಿದ್ದಾರೆ
is,
ಅಷ್ಟೇ.
order of.
ಈಗ ಡಿಸ್ಪೋಸ್ ಆಗ್ಬೇಕಷ್ಟೇ ನಿಮ್ಗೆ.
ಇಲ್ಲ.
ಕನ್ಸಿಡರ್ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕಳಿಸ್ತೀನಿ, ತೊಂದರೆ ಇಲ್ಲ.
Relief ಸಿಗ್ಬೇಕು.
ಮತ್ತೆ ಇನ್ನೊಂದು ರೌಂಡ್ ಆಗುತ್ತೆ. Wait.
Please.
Get the policy by tomorrow at least. List tomorrow in the fresh matters list. Yes. Dispose ಮಾಡೋದು easy. Consider representation.
That P, my lords, the cancellation of the letter of acceptance and forfeiture of EMD
It's under challenge.
Hmm.
First, the letter of acceptance is issued on 37/24, page 22, my lords.
What is the date of tender, sir?
What's the date of the tender?
Fishing
is
tender ತಾನೆ?
14/2.
Fishing ಅಲ್ಲ.
Huh?
ಹೌದು. ಅಲ್ಲ, ಅಲ್ಲ.
Work.
Dredging work.
Trenching
Capital
work.
dredging. 14/2/23 is the date of tender.
Yes. You are allotted the work when?
The annexure B, my lords, 3/3/23 is technical bid and price bid opening.
Work order ಯಾವಾಗ issue ಮಾಡಿದ್ sir?
37/24.
37/20/24. ಎಷ್ಟು ದಿವಸದಲ್ಲಿ ಕಂಪ್ಲೀಟ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು?
Lords, I was required to deposit security deposit, my lords.
ಎಷ್ಟು?
As per the tender, it is
ಎಷ್ಟು?
3%, my lords, as per the tender document. They have issued for 5%.
Oh, that was the controversy.
Yes, my lords.
ಸರಿ.
Then, my lords, I requested a clarification, my lords.
Page.
For which annexure, page 26, my lords, annexure J.
Hmm. Hmm.
For which, my lords, on 27/9/24,
Hmm.
a
Page.
clarification is given.
Page.
Page 28, my lord.
All right. Hmm.
The operative portion is at page 30.
All right.
They don't say it is, I have to pay 5% or 3%. They only extract the government order.
Hmm. ಆಮೇಲೆ?
ಆಮೇಲೆ ಅದೇ ದಿವಸ they recommend for cancellation of the tender.
Where is that?
That is referred in the annexure P, my lord.
Page.
Page 38, my lords. ಉಲ್ಲೇಖ 10.
ವಿಷಯ ಉಲ್ಲೇಖ.
ಉಲ್ಲೇಖ 10ನೇ ಡಾಕ್ಯುಮೆಂಟ್ 27/9/24.
ಬರೆದ ಪತ್ರ 27/9/24.
Please, my lord.
This is the document of cancellation.
Cancellation which is found at page 40, my lords, in the impugned order.
Dredging it.
ಈಗಾಗಲೇ ಹೆಚ್ಚುವರಿ ಕಾಲಾವಕಾಶ ನೀಡಿದ್ದರೂ ಸಹ ಗುತ್ತಿಗೆದಾರ ಅನುಸರಿಸಲು ಯಾವುದೇ ರೀತಿ ಕ್ರಮ ಕೈಗೊಂಡಿರುವುದರಿಂದ ನಿಮ್ಮ ಟೆಂಡರ್ ಅನ್ನು ಟೆಂಡರ್ ನಿಬಂಧನೆಯಂತೆ 29/4 ಪ್ರಕಾರ ಅನುಮತಿ ಆದೇಶವನ್ನು ರದ್ದುಪಡಿಸುವಂತೆ ಈಗಾಗಲೇ ಮೇಲಧಿಕಾರಿಗಳಿಗೆ.
In this matter, madam, what had happened was, my lord, when the letter of acceptance was issued, he was required to deposit the amount within 30 days from the date of issue of the letter. My lord, he does not reply saying that whether he is liable to pay 3% or 5%. My lord, that 3% was reduced during the COVID period, my lord. Otherwise, the government policy is 5%, my lord.
ಟೆಂಡರ್ ಪ್ರಕಾರ ಎಷ್ಟಿದೆ?
Page 27, 3%.
3% ಇದೆ ಅದು. But then what had
ಒಂದು
happened?
ನಿಮಿಷ. Page
27.
ನಿಮಗೆ ಲೆಟರ್ ಆಫ್ ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಎಲ್ಲಿದೆ?
ಲೆಟರ್ ಆಫ್ ಅಕ್ಸೆಪ್ಟೆನ್ಸ್
5% ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದ್ರು ನಿಮ್ಗೆ?
ಅಲ್ಲ, ಅಮೌಂಟ್ 5% ಬರುತ್ತೆ.
ಹಾ?
ಈ LOA ನಲ್ಲಿ ಪೇಜ್ 22
ಅದೇ ನಾನು ಕೇಳಿದ್ದೆ ಎಲ್ಲಿದೆ ಅದು?
ಪೇಜ್ 22.
That day you accepted it, amounts to 5%.
Yes, yes.
ಕ್ಲಾರಿಫಿಕೇಶನ್ ಕೇಳಿದ್ರಿ? ಕ್ಲಾರಿಫಿಕೇಶನ್ ಕೇಳಿದ್ ಯಾವಾಗ? ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಕೇಳಿದ್ರ?
ಅಲ್ಲ, clarification ಕೇಳಲಿಲ್ಲ ಅವರು. They wrote a letter. They do not say, give me a clarification first.
Page 20.
Alla, page 23, my lord. This letter is very important. Page 23, 28/8/2024. There he says, we would like to inform you that we have already submitted application to the bank for issuing us the bank guarantee towards security deposit to our banker. The generating process of the bank guarantee and issuance is being processed in the bank, and the process is slightly delayed due to ongoing bank holidays. So he requests for an extension of 10 to 12 days, my lord, which was also given to him. That is the next annexure H, my lord. There also, my lord, he says it is not 5%, I am liable to pay 3% anta. He has not said.
Oh, EMD is forfeited.
Yes, my lord, cancelled work order.
Now, my lords, even if in the letter dated 27/9/24, if they had clarified, my lords, the required
not even sought
security
clarification,
deposit
my lord.
would have been given.
ನೀವು ಕ್ಲಾರಿಫಿಕೇಶನ್ ಎಲ್ಲಿ ಕೇಳಿದ್ರಿ?
Annexure J, my lords, page 26.
ಅದ್ರಲ್ಲಿ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಇಲ್ವಲ್ಲ?
ಇದೆ.
ಎಲ್ಲಿದೆ?
Your lordship may kindly see 2 paragraphs.
ಭದ್ರತಾ ಠೇವಣಿ ಹಣವನ್ನು ನಿಮಗೆ ನಾವು ತಿಳಿಸುವುದಾದರೆ
ನಾನು ಟೆಂಡರ್ ನಿಯಮಗಳು ಮತ್ತು ಬ್ಯಾಂಕ್
ಆದ್ದರಿಂದ ನಿಮಗೆ
ಬ್ಯಾಂಕ್ ಅವರು ರೈಸ್ ಮಾಡಿದ್ರು ಅಬ್ಜೆಕ್ಷನ್ ಅಂತ ಹೇಳ್ತಾರೆ.
ಏನಂತ?
ಪೇಜ್ 26 ಅಲ್ಲಿ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾ. ನಾನು ಟೆಂಡರ್ ನಿಯಮಗಳು ಮತ್ತು ಬ್ಯಾಂಕ್ ಗ್ಯಾರಂಟಿ ಫಾರ್ಮ್ಯಾಟ್ ಬ್ಯಾಂಕಿಗೆ ಕೊಟ್ಟಿದ್ದೆವು. ಬ್ಯಾಂಕಿನವರು ಪರಿಶೀಲನೆ ನೋಡಿದಾಗ ಈ ವ್ಯತ್ಯಾಸ ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಆದುದರಿಂದ ಅವರು ನಮ್ಮ ಬಳಿ ಇದರ ಬಗ್ಗೆ ಸ್ಪಷ್ಟೀಕರಣ ಕೇಳಿರುತ್ತಾರೆ. ಆದುದರಿಂದ ತಾವುಗಳು ದಯವಿಟ್ಟು ಈ ಬಗ್ಗೆ ಪರಿಶೀಲಿಸಿ ಸ್ಪಷ್ಟೀಕರಣ ನೀಡಬೇಕಾಗಿ ವಿನಂತಿಸಿಕೊಳ್ಳುತ್ತೇನೆ.
That is on 23/9/24.
ಪ್ಲೀಸ್.
ಸ್ಪಷ್ಟೀಕರಣ ಕೊಡ್ಲಿಲ್ವಾ?
ಇಲ್ಲ, 27(9) ಅಲ್ಲಿ they only extract the government order. They don't say 5% or 3%.
ಭದ್ರತಾ ಠೇವಣಿ ಗುತ್ತಿಗೆ ಮೊತ್ತದ 5ರಿಂದ 3ಕ್ಕೆ ನಿಗದಿಪಡಿಸಲಾಗಿರುತ್ತದೆ. ಸದರಿ ರಿಯಾಯಿತಿ ಪ್ರಸ್ತುತ ಚಾಲ್ತಿಯಲ್ಲಿ ಎಕ್ಸಿಸ್ಟಿಂಗ್ ಮತ್ತು ಟೆಂಡರ್ ಮಾಡಿಕೊಳ್ಳುವ ಒಪ್ಪಂದಗಳಿಗೆ ಅನ್ವಯವಾಗುತ್ತದೆ. ಆದರೆ ಚಾಲ್ತಿಯಲ್ಲಿರುವ ಒಪ್ಪಂದಗಳಿಗೆ ಆರ್ಬಿಟ್ರೇಷನ್ ಪ್ರಕಾರ ಕರೆಕ್ಟ್ ಆಗಿ ನಿಮಗೂ ಹೇಳಕ್ಕೆ
For cancellation.
ನಿಮಗೂ ಹೇಳಕ್ಕೇನು ಕರೆಕ್ಟ್ ಆಗಿ EMD ಎಷ್ಟು? How many lakhs?
EMD 24,48,000.
That's the refund you are seeking?
No, my lords.
Okay.
Now the LOA is cancelled.
LOA will not.
If 5%
ಮತ್ತೆ
is-
ಟೆಂಡರ್ ಕರೆದಿದ್ದೀರಾ?
ಇಲ್ಲ,
Because of the entry order here,
Entry order is granted.
ಇಲ್ಲ.
because of this pendency of the writ petition.
ಏನ್ ಎಲ್ಲಾರು ಪೆಂಡೆನ್ಸಿ ಆಫ್ ದಿ ರಿಟ್ ಪಿಟಿಷನ್ ಇಷ್ಟೊಂದು
ಇವಾಗ್ಲೂ ಕೂಡ 5% ಆದ್ರೂ ಅವ್ರು ಕಟ್ಲಿಕ್ಕೆ ರೆಡಿ ಇದಾರೆ. There is no, but bank disputes that.
I may have to seek instructions, my lord.
this has to be allowed.
I will verify.
You have created this obfuscation when nothing was there. ಒಂದು ರಿಪ್ಲೈ ಕರೆಕ್ಟ್ ಆಗಿ ಕೊಟ್ಬಿಟ್ಟಿದ್ರೆ ಆಗ್ತಾ ಇತ್ತು.
I will seek it.
I'll take this on Friday. If you want to redeem the situation, redeem.
Yes, sir.
Or work order has to be given to him. He is ready to pay also.
I will seek it.
ಇನ್ನು ಏನು ಮಾಡ್ದೇನೆ ಯಾರಿಗೂ ಇಲ್ಲ, ಇದು ಇಲ್ಲ. Yes. Next. List on Friday in the fresh matters list. Next. Parole.
Well,
Rahul.
Petition is not here.
Sirajuddin.
Senior is not.
Senior counsel. Kodi.
No, senior is not available.
Not well. All right.
302 and 379 convicted.
ಎಷ್ಟು ವರ್ಷ ಆಗಿದೆ? Let him do it.
No,
Leave it.
he's in prison for 7 years and 8 months.
Will grant. The petitioner is before this court.
So your lordship, here, yeah, he has given an application.
The petitioner is before, the petitioner is himself the convict?
Yes, my lord.
He is a convict. The petitioner is before this court. What's your name?
Petitioner is the brother lordship.
What is your name, sir?
Naveen.
Naveen. The petitioner is before this court seeking his release on grant of parole for a period of 90 days. Heard so and so. The petitioner gets embroiled in a crime which is tried in SC 201 of 2013 for offences punishable under section 302 and 379 of the IPC. It transpires that since the said date, the petitioner has been in prison and as on today has completed 7 years, huh?
7 years, 8 months and 11 days.
7 years, 8 months and 11 days in prison and has not sought parole even once. The
No, no, he has
application.
sought parole earlier.
Sought, ಎಷ್ಟು ಸರ್ತಿ?
3 sati.
And has sought parole on 3 occasions. And again applies for grant of parole on the ground that his mother is ailing with several ailments and his presence with the mother is imperative. The application is filed by the convict, which comes to be reject madidara,
Rejectment.
which comes to be rejected on the score that several rounds of parole is already over. The learned counsel for the petitioner submits that the petitioner who was released on parole on 3 occasions has suffered no adverse finding or has not jumped parole. Therefore, he is entitled for grant of parole for the period that the court would grant. The learned counsel, learned AGA Rahul, though would refute the submissions, would submit that there is nothing adverse against the petitioner both inside the prison or outside the prison while he was out on parole. In that light, and also the illness of the mother projected with adequate material, I deem it appropriate to grant the petitioner parole for a period of 60 days.
Convict
Is not
hinders.
well. His medical is produced.
Howda? All right. Along with the certificates produced along with the mother, the certificates produced would depict that the convict himself is unwell, apart from the mother being unwell. In that light, 60 days parole. Yes. 60, to be operational from Friday, from Thursday, yes.
This they have not made an application.
302 application ಮಾಡಬಾರ್ದಾ?
They were mail ಕಳ್ಸಿದ್ದಾರೆ. Advocate has sent a mail.
We have application.
ಇದೇನ್ 302 ನಾ?
This is 302 and 307.
Application ಕೊಟ್ಟಿದ್ದೀವಿ ಅಲ್ಲ.
ಎಷ್ಟು ವರ್ಷ ಆಗಿದೆ?
6 years, 3 months and 13 days.
ಪರೋಲ್ ಎಷ್ಟು ಸರ್ತಿ ಆಗಿದೆ?
ಇದು first time parole.
Grant that. Yes. The petitioner is convict ಯಾರು? Son na?
Son.
The mother of the convict is at the doors of this court seeking release of his son on grant of parole for the first time in the 6 years and
6 years, 3 months and
6
13
years,
days.
3 months tenure of the petitioner in prison, term of the petitioner in prison. The third one, the son of the petitioner gets embroiled in a crime for offences punishable under section 302 and 307 of the IPC. He is tried and convicted by the Court of Session and has been in prison for the aforesaid period till today. The petitioner files, the mother of the prisoner is said to be suffering from several ailments for which the presence of the son is being wanted by the mother. Therefore, submit the application ಕೊಟ್ಟಿಲ್ವಾ?
ಇಲ್ಲ application ಕೊಟ್ಟಿಲ್ಲ, that is.
The learned counsel submits, so on. The learned counsel for the petitioner submits that the application is given and no acknowledgement is with them. And it also takes this court through the medical records of the mother seek to buttress her submission with regard to release of the son on parole. The present certificate does not indicate anything adverse against the petitioner and also adverse against the petitioner for all the 6 years and 3 months that he is in prison and he is seeking parole for the first time. In that light, I deem it appropriate to grant parole to the petitioner for a period of 60 days. For a period of 60 days to become operational from Friday. Yes, the same conditions. Friday. Next.
14.
The
Parole.
POCSO.
ಹೋಗ್ಸೋ
And there's a body warrant under Arms Act.
ಎಷ್ಟು ವರ್ಷ ಆಗಿದೆ?
5 ವರ್ಷ ಆಗಿದೆ. 5 years.
There's a body warrant which the court has issued recently.
In
Arms
which,
Act.
in which case?
That is CC number 114 of 2021.
ಅದು offense ಏನು ಅದರಲ್ಲಿ?
Offense ಇದೆ.
ಆ ಬಾಡಿ ವಾರಂಟ್ ಕೇಸಲ್ಲಿ offense ಏನಿದೆ?
Offense is under the Arms Act. I'll have to procure.
Get the material.
I'll get them.
Learned AGA is directed to accept notice, secure information with regard to the conduct of the petitioner or any other cases pending against him. Monday, fresh matter.
Right.
15.
This tender is likely to be called in the next 15 to 20 days. If he wants to participate in that, my lord, he can participate in that.
He'll stay here.
Illa. Illa. The earlier tender, my lord, who's still supplying, is supplying at 115 rupees. Petitioner here, my lord, supplies at 250 rupees. Therefore, we decided to cancel it, saying it's too expensive.
That is
In fact, in another district, the petitioner supplies at 150 rupees.
Why?
Almost the same menu.
That is
I won't say
factually-
it's the same menu,
Your
but
Lordship,
it's almost the same menu.
Annexure F, page 54.
What have you challenged, sir?
No, that I have to mandamus to issue.
To issue work order.
Work order.
The tender, cancel ಆಗುತ್ತೆ tender ಅಂತಿದ್ದಾರೆ.
Well, till today, they have not cancelled.
And
That
what
tender-
And you are permitting the old person to continue?
Continue at 115 rupees. Even he's not satisfied with it. He also doesn't want to do it.
Your Lordship, for
Well,
the moment.
in fact,
pay
we've
it and
called for-
No, you bring about a proper policy, proper tender,
Yes,
in which it is rational, not the prices are too high or too low.
I understand.
ಏನಾದ್ರು ಒಂದು ಮಾಡ್ಬೇಕು, ಯಾವಾಗಲೂ litigation ಲೇ ಇದ್ದಾರೆ.
And negotiation
in
is
fact,
made in this matter, and I have negotiated, they have accepted that negotiation price. And they have sent a proposal to respondent number 3, wherein respondent
hospital
number 3
accepts
void
it.
annexure F, your Lordship. He.
ಇಲ್ಲ, I will grant work order, direct work order to be issued to.
But not at this rate, my lord. That's the only issue.
Negotiation ಮಾಡಿದ್ದು ಎಷ್ಟಕ್ಕೆ?
No, negotiation was done with the
respect to-
hospital. Hospital has no authority to decide.
Then
the
you
rates.
sit and negotiate with him, he is a successful bidder.
Even annexure
Just a
H
bidder, ma'am.
representation.
Is he the sole bidder?
He's not the sole bidder.
Competition itself.
Competition is.
Then sit with him and do it. I'll take this on Monday in the fresh matters. You, on Friday, you
Speak to the officer and see what.
speak to the officer, get him on Friday and talk to him.
Yes.
The petitioner emerges as the successful bidder. Noticing the right of the petitioner, this court on 14/3/2025 had passed the following order. The learned HCGP on instructions would submit that the price at which the petitioner quoted is not viable for the reason that it is too high. And the petitioner himself is supplying in the neighboring district at rupees 150. Now the tender is accepted at rupees 250, which is too exorbitant. It is ununderstandable as to how the petitioner with that figure emerges successful and negotiations take place with the petitioner with regard to the price. And now at the time when the work order is to be issued, all kinds of objections are projected by the state without scrutinizing everything before issuance, before declaring the petitioner to be the successful bidder. Therefore, in the light of him getting some semblance of right, I deem it appropriate to direct the officers to, direct the petitioner to sit with the officers and negotiate the price if necessary and bring about a solution by the next day.
Negotiations were never with the tender accepting authority. It was with the
Now
hospital.
negotiate, yes.
Please.
Your Lordship, annexure H series representation, wherein in those.
I think meet Madi on Monday, fresh matters. You call him on Friday and finish it.
16.
Parole, Your Lordship. Posted yesterday. Since his bail application is pending in the appeal, criminal appeal.
Notice produced, Your Lordship, rejected for bail application.
ಏನು
One
offense?
application.
302.
302.
ಎಷ್ಟು ವರ್ಷ ಆಗಿದೆ?
Around 7 years.
7 years. Yes, will grant 30 days. ಆಮೇಲೆ extension. Wait, because your bail application is pending.
Your Lordship, it's
No, no, no.
No, yesterday itself, Your Lordship had made it clear, 30 days.
Yes, yes. ಕೊಡೋದ್ರಲ್ಲಿ ನಾನೇ ಕೊಡ್ತೀನಿ. Yes. The petitioner is before this court. Who is the convict? Mother, all right. The mother of the convict is before this court seeking the release of his son on grant of parole, her son on grant of parole. The son of the petitioner, her son of the petitioner gets embroiled in a crime for offences punishable under section 302 of the IPC and is tried in SC 15018 of 2018. Since the registration of the crime, the petitioner has been in prison and as on today has spent 6 years, 11 months and 15 days in prison. The imprisonment certificate is appended to the petition. A perusal at the imprisonment certificate would indicate that the petitioner, in your case pending is
There is no case.
sir. So a perusal at the imprisonment certificate would indicate nothing adverse against the petitioner in the prison. The learned AGA would submit that the criminal appeal against the order of conviction is pending and the application seeking bail therein is also pending consideration at the hands of this court, and in such cases parole should not be granted. The learned counsel for the petitioner submits that the first time the convict, the convict is wanting, second time, the learned counsel for the petitioner submits that it is not the first time that the petitioner, the son of the petitioner is being released on parole. It is for the second time that he is seeking. In that light, I deem it appropriate to grant the petitioner parole for a period of 30 days to become operational from Friday, with liberty to seek extension. Yes, next.
20. Hearing for the respondent bank, my lord. Please, Your Lordship.
My lords had specifically asked a question whether the accounts were regular in the interim from 2016 to 22. No, my lords, I'm filing the affidavit of both the parties along with the bank statement to show that from the date of
Ega, what have you challenged, sir?
I'm seeking for one-time settlement, my lords.
One-time settlement.
Yes, sir.
Thank you, sir. Amale.
That,
How can I direct one-time settlement?
my lords, I've produced the citations.
You can grant one-time settlement. Where is it? SBI matter.
Yes, ma'am. produced the citations in 0522. And in the division bench of this honorable court. This is an agriculture loan, my lords. One is.
Where is OTS ಕೊಡ್ಬೋದು ನಾವು ಅಂತ ಎಲ್ಲಿದೆ ಕೊಡಿ.
Please, my lords.
ಕೊಡಿ.
305, first I'll come to the petition. my lord.
No, first come to the judgment you said.
Please, my lord.
Your
30
prayer is for grant of OTS.
Please,
Give
my
it. ಎಲ್ಲಿ ಯಾವ್ದ್ರಲ್ಲಿದೆ ಮೇಡಮ್?
My lord, the first case is Sardar Associates.
ಯಾವ್ದ್ರಲ್ಲಿದೆ? ಒಂದು ನಿಮಿಷ.
Third case, my lord.
Just one moment.
Please. I filed it on 11/2/24.
ಆಮೇಲೆ
First is the case of Sardar Associates, my lord,
all right, next.
page 15. Next is the case of Visional Cooperative Society, where the Honorable Apex Court has had.
Where is ಇದ್ರಲ್ಲಿ paragraph ಹೋಗಿ.
Visional
ಆಮೇಲೆ
Visional Cooperative last para, my lords.
SBI ನೀವು SBI Supreme Court directs that we should not grant direct OTS.
Extension, Gitra, my lords. Page 33, case of SBI, page 33, para 14. While considering the aforesaid issue, the recent decision of this court in Minal Agarwal is required to be referred to as. In Minal Agarwal, this court answered the following two questions. Whether the benefit under OTS scheme can be paid as a matter of right, whether the High Court in exercise of power under Article 226 of Constitution India can issue a writ of mandamus directing the bank to positively consider the grant of benefit under OTS scheme, and that adheres the eligibility criteria mentioned under the OTS scheme. The sum and substance it says, if there is OTS policy and I am eligible, the bank cannot refuse.
ಮುಂದೆ ಓದಿ.
Please, my lords. On detailed analysis of the OTS scheme, it is observed that no borrower can, as a matter of right, pray for grant of benefit of one-time settlement scheme. No writ of mandamus can be issued by the High Court in excess of Article 226 of the Constitution, directing the financial institution bank to positively grant a benefit of OTS to the borrower. The grant of benefit of OTS scheme is subject to the eligibility criteria and the guidelines issued from time to time. That is what I'm saying. Last year's OTS policy I have already produced. From last 3 years, they have uploaded it, and the second matter, 70.1, I've requested for OTS policy in both the matters, and I filed writ petition before this honorable court. I personally perused the policy, but I have not handed over the policy. There is no change in the policy. When there is an existing policy, my lords, admittedly, the first loan is of year of 2014, the second loan is of 2016. So as per their own policy, I'm entitled for OTS for amount not more than the principal in both the cases. The division bench at Dharwad.
ಯಾವ್ದು?
Please, my lords.
Which is division bench Dharwad?
Bench order is there, my lords, please. First, I'll refer to page number 82, my lords. Single bench.
Division bench ಯಾವ್ದು?
Division is at page number.
Which division bench?
Please.
Yes, Divya, which division bench?
My lord, he is referred to another case pertaining to the bank where they've been directed to consider the representation.
That I will correct right away.
They have, at present also the matter is pending before the division bench where they have scared the all further proceedings. Where
No problem. You want OTS scheme? No positive direction.
and the further proceedings may be stayed, my lords.
No. I will direct consideration of OTS. Where is the question of stay?
They have- Please, my lord. The first matter, there is a order of the learned.
See, I am holding writ petition 4343 of 25. All right. Idರಲ್ಲಿ, what is your prayer?
My prayer is to consider the request for one-time settlement, my lords, as
What?
per the policy of the bank. It is not as per the whims and fancies. They are rejecting it in a two-line word saying that you are not entitled. But the Honorable Supreme Court in the case of Sardar Associate, Visional Cooperative Society, and this Honorable Court has categorically stated, I produced the two citations, my lords, of the learned single judge of at the Dharwad bench. That is page number 80.
Page?
80.
80 of what?
The
Justice Dixit ಅವ್ರದ್ದು.
No, Justice Yada Saibru.
Date?
Date is 21st July 2022.
22.
Please, ma'am.
All before Arvind.
In the Arvind also, they are saying eligibility criteria.
Adikke, that is what
Yes.
I will follow Arvind and direct them to consider. That's all.
Here also the court has not departed, but the court has said that until it is considered, the further proceedings have been stayed. At present, the
Yeah.
matter is
Which
posted,
judgmental?
page number,
Arvind Ali, is it said so? That a further proceeding should be stayed?
no, in the,
Mate?
the single judge has considered it. And in that case, it is the Union Bank of India only, my lords. My submission is that if I'm not entitled as per the policy, then they have got right to say whatever they want.
What is, 1 minute, what is the amount in due?
My lord, 1,59 lakhs. My lord, in 4343, what has happened, my lord? They had in fact made a representation after several representations without quoting a specific figure. Finally, they made a representation in January this year with the figure of 40 lakhs. And the total dues are 1,59 lakhs. And my lord, so there, that particular representation we have considered
And
at
rejected.
page 135, my
And
lord.
rejected.
Yes, my lord, and rejected because it's not even the principal amount. My lord, he has availed loan of even 70 lakhs. And he has in fact received subsidy, my lord, subsidy of 18 lakhs. There is no mention, there is no whisper of that.
Subsidy, all
Yes,
right.
but he has received subsidy from the horticulture department. This is he has availed a loan under the floriculture scheme, where the horticulture department in fact gives them the technical support, and he has got a subsidy of 18 lakhs. There is no whisper of that. There
All
is no
right.
mention of that.
Next.
So, my lord, he has made several representations to several other departments, copying being issued to several departments. There was no specific figure he had quoted. And then he had approached this honorable court and he was allowed to make another representation, fresh representation. That representation he has made in January, and annexure N is the endorsement rejecting that, my lord, because he has made a representation for 40 lakhs, which does not even come within the principal amount.
My submission is, my lord.
My lord, there is no, yes, my lord, there is no scheme this year, my lord. In fact, it was there last year, it was there before. So he's not eligible for any scheme. So OTS is to be considered on case-to-case basis. And there is security of both the residential property as well as the agricultural property. We have made that clear, my lord, at para 2, my lord, at page 135 and 136. We have made it clear that even the agricultural land, he is only considering the residential property. But there's agricultural land, we have filed OA. OA is pending. In fact, it's there for evidence. They are not representing. So all those, we only want them to revise their offer, my lord. It's not.
Yes.
My lords, my submission is, it is a polyhouse loan. The subsidy which is they are speaking, I have not received a single rupee in my hand. That
That's
subsidy,
okay.
my lords,
Give it, don't worry.
I was defrauded by the corporation bank official. It is not my single case. There are 14 people. I'm producing the.
Register crimes against them.
My lords, but the NPA is 6 years. 6 years they have slept over it. They have not issued any notice. Only in the year 2020.
When did it turn into NPA?
2021, my
But
lord.
producing the bank statement.
No, that is only a part of the bank statement, my lord.
They're not.
2021, it turned into NPA.
Yes,
Oh,
my
my
lord,
lord,
because
16, I'm filing the affidavit. I've not paid a single rupee.
no,
In
I'm
both the
producing
cases.
Yeah,
the
with
entire
pride,
statement.
with pride, you're telling you're not paid a single rupee. Yes.
What I'm saying is I went to the bank immediately after the polyhouse failed. I requested the erstwhile corporation bank official said that we're trying to help you out because I was not there alone. There are 14 farmers who have been defrauded. The amount was directly released into the hands of the dealers.
No, my lord, in their SP account, they have
That's
received
all
and
right.
producing.
Now, mandamus, I can't issue.
My submission is, as per the direction of this honorable court, I've deposited 10 lakh rupees in the case of Imla and 5 lakh rupees in the case of Santosh. And I have put the property for auction on 27th without considering the fact that it is agriculture loan and the OTS has to be considered in accordance with the OTS scheme. Then they are not stated in my reply stating that there is no OTS scheme.
If OTS has to be directed to be considered, it is on a case-to-case basis in terms of the guidelines, that's all. No mandamus positive direction to direct OTS at all.
That is true, but but my submission is, my lords, if they say that they cannot grant it, they have to give reason. They have to consider my OTS request in accordance or in connoissance with the policy which is existing. Then there is no whisper of anything. On just they are saying blindly that you are not entitled for OTS, your amount is meager. To avoid this problem, initially I had given a submission stating that.
Sir, 1 nimsha. Who will accept 70 lakhs loan to 40 lakhs notice?
My lords, I
So,
didn't not a single rupees in profit. I'm not utilized.
it's floriculture.
Please, my
High-tech
lords.
floriculture, my
But
lord. Greenhouse.
The polyhouse is failed. I made a last.
Don't project yourself to be a poor farmer here. It's floriculture.
My lords, I'm a victim. What? I'm a victim of the circumstances because it is not a single case. There are 14 farmers. Not a single person has earned a single rupee.
All-
I'm not a
DRT
business.
hogilva?
No, my lord.
No, my lords, I paid
Ah.
10 lakh rupees before this honorable court itself.
No problem. That
My-
will be
my-
taken into your account. You go before the
My-
DRT.
my-
Yes.
My lords, the DRT is not, my lords, so kindly refer to the OTS policy of the Bank of last year, what it says, page 48.
Page.
48. Page 48, annexure F, my lords. In the first case, that is 4343. My lords, they say that is of 22, the next is of 23. There is no difference in 22 and 23. Third, my lords,
OTA
said-
scheme for resolution of doubtful loan, NPS so and so. This scheme is not there, madam, now?
No, my lord. The scheme was in fact floated only in 2022 and 23.
Validity period up to 30th September 2022.
There is no scheme.
Now,
my
what
lord.
is the scheme now?
Now there is no scheme, my lord, on a case-to-case basis on the basis of internal
All
guidelines.
right.
They have.
Whatever you consider is
Yes,
case.
let them improve
my,
their
submi-
offer,
my-
my
my
lord.
submission is, my lords, I already deposited the amount as per the direction of this honorable.
ಈಗ refund ಕೊಡಕ್ಕೆ ಹೇಳ್ಬೇಕಾದ್ನ ಮತ್ತೆ? Then what?
I'm not going, I cannot, my lords is aware of the fact that the order.
When they consider OTS, they will consider the deposit also.
So, my
my
lord,
sub-
the
my submission
deposit was for the stay. My lord, what happened? He had challenged
You
surface action.
bank also cannot behave like
Lord.
this. You have 15 lakhs is with you now?
10
Lord,
and 5,
10, my lord.
10 and 5, two cases.
He had challenged, my lord.
10
he-
or 15 lakhs is with you now?
10 lakhs, my lord. He had challenged the surface action, my lord. That was not
All
for
right,
OTS.
now deposit ಆಗಿದೆ ಈಗ.
Yes, that we.
Deposit ಆಗಿದೆ. In case you consider is OTS, take note of the deposit also as towards payment towards OTS. That's all. It will redeem the problem.
And I'm not saying I'll stick to 40 lakhs. I'm making submission. If they show that this is the policy,
You will pay 41 lakhs.
no,
ಮತ್ತೆ?
ಒಂದೊಂದು ಲಕ್ಷ ಹೆಚ್ಚು ಮಾಡ್ಕೋತ ಹೋಗಲ್ಲ.
ಮತ್ತೆ ಇನ್ನೇನು?
Property valuation in.
70 ಲಕ್ಷ ತಗೊಂಡು 40 ಲಕ್ಷಕ್ಕೆ ಸೆಟಲ್ ಮಾಡಿದ್ ಯಾರು ಮಾಡ್ತಾರೆ?
My lords, our policy ಏನಾಗುತ್ತೆ ಅದ್ರ ಪ್ರಕಾರ 60 ಲಕ್ಷ time entitled.
The petitioner is before this court calling in question. ಇದು ಎಲ್ಲದರಲ್ಲೂ ಒಂದೇ ಪ್ರೇಯರ?
No, my lords, 4343.
First 4343 ತಗೊಂಡು. Writ petition 4343 of 2025. The petitioner is before this court calling in question an order, an communication dated 24/1/2025 by the bank rejecting the claim of the petitioner for an OTS and seeks a direction by issuance of a writ in the nature of mandamus for grant of a one-time settlement to the petitioner. The petition, ಇದರಲ್ಲಿ companion petition ಕೊಡಿ madam. In writ petition 30522 of 2024, the petitioner,
My lord, one submission. 305 2024.
It's
my
different,
lord, was-
different person.
is another part.
I know it's other part.
In that CMM order has been challenged.
The petitioner in writ petition 30522 of 2024, the challenge is to the order of the concerned court under section 14 of the Surface Act 2002. In writ petition 30509 of 2024,
Direction sought to issue the OTS policy.
That was filed in November.
the prayer sought for a direction to consider grant of one-time settlement in terms of the policy prevailing. In the, who is this other, Nalina yaru?
Nelina is the second case, my lords. That is,
Ade,
borrower is 35 lakh rupees is the principal.
the WP 4343 of 2025 and 30509 of 2025 is filed by the same petitioner. Therefore, facts obtaining in 4343 are noted for the purpose of brevity. For the sake of convenience and brevity. The petitioner in the case at hand is the borrower who secures finance of 70 lakhs as loan on 20th June 2014. It transpires that between 1/1/2015 and 31/12/2016, the petitioners suffer huge loss in the poly house due to steep fall in the agricultural products. The account then, no amount was paid to the bank in terms of the conditions of the grant of loan. This led the bank to initiate proceedings under the Surface Act by issuing a sale notice on 28/6/2024 after taking steps in terms of the Surface Act 2002. The bank then approaches the magistrate seeking an order at its hands under section 14 of the Surface Act. which is granted and challenged in the companion petition. The petitioner approaches this court not once but twice in WP 30489 of 2024, which comes to be disposed by the following order, page 87, 88. The petitioner, ಇನ್ನೊಂದು separate ಅದು. The petition,
Challenge all the orders.
in another petition, writ petition 30526 of 2024, the petitioner, 3256 30506 of 2024, the coordinate bench disposes the petition by the following order. The effect of the orders passed was consideration of the case of the petitioner for grant of an OTS. The representation was submitted by the petitioner in furtherance of the order passed by this court on on 8/1/2025. The representation comes to be rejected by the impugned order on 24/1/2025 on the ground that there is no, where is the order?
My lord, at page 135.
Page 127.
134.
Page 134.
135.
Page 136, madam.
135 and 136, yes.
Both the representations for one-time settlement comes to be turned down by the bank. The order reads as follows, page 134, 135. The petitioner now calls in question the said order and again seeks a direction for grant of an OTS. The learned counsel for the petitioner seeks to place reliance upon plethora of judgments of the apex court or that of the coordinate benches or the division bench of this court, contending that in all the cases, there has been a direction to the bank to consider one-time settlement in terms of the prevailing scheme. He would seek to place reliance upon it. Ella hakile. Para 1 to 13. All the aforequoted judgments which the petitioner seeks to place reliance upon were at the time when the judgment of the apex court, at least in a few cases, were at the time when the judgment of the apex court in State Bank of India versus Arvinda Electronics was not in place. The apex court in Arvind Electronics, reported in 2023-1 SEC page 4540, while considering an identical issue as to whether this court would be empowered to direct by way of a positive direction to grant OTS, holds that this court would not have the power. The paragraph 14, 15, 16, to 19. The judgment that the petitioner seeks to place reliance upon in Sardar Associates is relied on and distinguished. In that light, the petitioner becomes entitled to only a mandamus directing the bank to consider the case of the petitioners for grant of an OTS in terms of the scheme that is prevalent. The learned counsel for the respondent bank would vehemently object to any such direction being given on the score that the petitioner seeks finance of 70 lakhs, comes forward to the bank by giving a proposal for OTS of 40 lakhs, not even the principal amount. Therefore, there is no option to the bank but to reject the offer of OTS. She would further contend that the scheme of OTS which the petitioner seeks to replace reliance upon was subsisting only up to the end of the financial year of 2022 and is no longer in subsistence. The OTS is considered by the bank on a case-to-case basis now. In that light, I deem it appropriate to direct the bank to consider the case of the petitioner for grant of OTS. It should not be construed as a positive direction. It is only a direction to consider in terms of the extant guidelines, scheme, policy, or the manner in which the bank would consider cases for grant of OTS on a case-to-case basis. The petitioner has deposited 15 lakhs pursuant to the interim orders granted by this court.
10 lakhs.
10 lakhs, 10 lakhs pursuant to the interim order granted by this court. The interim order was granted, the interim order was staying the sale that was slated to be held on a particular date.
No, my lord, sale was not
No,
stated.
it was
Say
surface
like-
measures, my lord, not surface.
That's all right. The
Ask
interim
the
order was
specific.
granted on this court that the bank would not take
Specific.
any precipitative action qua the proceedings under the SARFAESI Act. Therefore, the bank, while considering OTS of the petitioner, considering OTS of petitioner in a manner known to law, shall take note of the deposit that is made pursuant to the direction of this court, add the same amount, add the amount to the OTS amount, and then pass necessary orders in accordance with it.
Because
that
then the auction
amount
may be
you-
stayed, my lord. 27th auction is there.
My lord, that amount we've already appropriated. We'll consider it, my lord, but then he
Appropriate.
does not get a right to refund in case. there is-
Refund, I'm not
yes,
saying,
yes.
so and so.
My lord,
That's all right.
27th auction is there, please.
You
not for-
consider it, till then wait.
My lord, let him, problem is, my lord, he is not depositing any amount for stay. Everybody wants some 1 crore 59 lakhs. There is nothing that he's offering with the.
27th auction. No?
Yes, my lord, 27.
27th deposit ಮಾಡಿ ಇನ್ನೊಂದ್ ಸ್ವಲ್ಪ.
5 lakh rupees, my lord.
ಅದು
My lord,
offer is too low.
deposit 10 lakh with 2 installments.
No, no.
No, my lord,
27th auction ಇದ್ರೆ 26th ಒಳಗೆ you deposit 10 lakhs.
please, my lord.
Only then I will defer it.
But my submission is.
The learned counsel for the petitioner at this juncture submits that the auction is slated to be held on 27th. The learned counsel for the respondent submits that since 2021, not a rupee is paid by the petitioner except the 10 lakhs pursuant to the order passed by this court. In that light, before the date of auction, intended date of auction, i.e. 27/3/2025, the petitioner shall deposit 10 lakhs to the bank. In the event the said deposit comes about, the auction shall be deferred, shall be deferred. In the event the petitioner would not deposit the amount, the bank is at liberty to proceed with the auction.
My lord, my humble submission is, I'll deposit, only thing that the consideration should be in reference, they should not pass an
In-
order in such manner as they have passed in.
You don't
page
worry.
135.
ಎಲ್ಲ ನೀವೇ ಬೇಕು ಅಂತ ಹೇಳಕ್ ಬಿಡಿ.
In the next case.
ಏನ್ ಕನ್ಸಿಡರೇಷನ್ ಕರೆಕ್ಟ್ ಆಗಿದೆ, ಏನ್ ತೊಂದರೆ ಇಲ್ಲ.
ಇಲ್ಲ.
ಏನ್ ನಿಮ್ಗೆ 2 ಲೈನ್ ಏನಿಲ್ಲ ಅಲ್ಲಿ.
My lord, sir,
That's why I did not refer to that. It's not 2 lines.
30522.
ಅದ್ರಲ್ಲೇನು?
Atrali 35 lakh rupees is the principal. Already 5 lakh is paid and 5 lakh rupees, 10 lakh rupees is there with. the
ಅದ್ರಲ್ಲೂ
bank.
ಕನ್ಸಿಡರ್ ಮಾಡಿ ಅಷ್ಟೇ. This is plain consideration.
My lord, the auction is there, same.
My lord,
20
in that
27
case, what has happened?
27
Again,
ಅದು
he has paid
ಡೆಪಾಸಿಟ್ ಮಾಡಿ
5 lakh rupees. my
10
lord.
lakhs.
No, my lord, that is 35 lakh.
ಅದ್ರಲ್ಲಿ ಎಷ್ಟಿದೆ
66,
ಮೇಡಮ್?
my lord, dues are 66 lakhs, my lord,
All right.
present dues.
5 lakh rupees, my lord. Here it is double the amount. I'll pay 5 lakh rupees.
ಹಾಗಾದ್ರೆ ಅಲ್ಲಿ 15 ಮಾಡ್ತೀನಿ, ಇದು 10 ಮಾಡಿಸಿ. Yes.
5 lakh rupees here, my lords. I already deposited 10 lakh, not 5. 5 in furtherance to direction of this honorable court, and 5 is already, they kept in a no lien account, my lord.
Same 5 lakhs he will deposit on before the said date. In the
We
event
make a specific of, in that he has not quoted any amount, my lord.
the
No,
petitioner
my submission
ಒಂದು
is.
ಸ್ವಲ್ಪ ಸುಮ್ಮನೆ ಇದ್ರೆ ಆರ್ಡರ್ ಮಾಡ್ತೀನಿ. ಎಸ್, ಇಲ್ದರೆ 4 ವಾರ ಅಡ್ಜರ್ನ್ ಮಾಡ್ತೀನಿ. ಆಗಿರೋದು ಡಿಫಾಲ್ಟ್. ಆರ್ಗ್ಯುಮೆಂಟ್ ಮ್ಯಾಟರ್ ಆಫ್ ರೈಟ್.
No, my lords.
Wait, sir. These are petitions which should not be entertained at all. ಎಲ್ಲ DRT ಕಳಿಸ್ಬೇಕು. Yes, the petitioner is before this court seeking the following prayer. The challenge in the case at hand, ಯಾವುದು 30522 na?
Yes, my lord.
The
that is
challenge in
CMM
the
order.
case at hand is to an order of the learned magistrate under section 14 of the SARFAESI Act 2002. The petitioner in the case, the petitioner in the case at hand is a borrower who borrows the finance of 35 lakhs and defaults in payment. The loan becomes sticky and the petitioners, the respondent bank has initiated proceedings under the SARFAESI Act 2002 and has now secured an order of possession from the hands of the learned magistrate. The property is now put to sale, the sale of which is slated to be held on 27th. The petitioners submit a representation to the bank on 11/11/2024 seeking one-time settlement. The learned counsel for the respondent bank submits that the policy of one-time settlement is not available today and it is considered on a case-to-case basis. And the case-to-case basis. She would further contend that in the offer made, there is no particular amount also said. It is vague. And therefore, it is not yet rejected, Allah?
It's rejected, my lord.
Therefore, the same has been rejected. In the light of the order passed in the companion petitions, and for the reasons recorded therein, I deem it appropriate to direct the bank to consider the case of the petitioner for grant of a one-time settlement strictly in consonance with law. It shall not be construed to be a positive direction. The sale that is slated to be held on 27th of the subject property shall be deferred subject to the condition that the petitioner would pay 5 lakhs to the bank on or before the 26th of March 2025. In the event, in the event does not pay, yes.
My submission is, my lords, I had not mentioned the amount. I had requested them as per the policy. They forced me to write the amount. I had not requested the amount. I said I'm ready as per the policy.
Yes.
In both the cases.
Next.
Please.
Please, my lords. I appear for the petitioner in item 18. My lords, we challenge the appellate authority's order dated 10/12/2024 cancelling the tender. My lords, I had supplied, I had won the tender with respect to supply of blast freezers for blood banks, which is used for freezing plasma. Now, my lords, they have cancelled my tender on the account that I was not able to produce a CDSCO certificate, which they say is the condition of the tender. Now, my lords, if I
It's cancelled on 12/10/24, or when was it cancelled?
On 12/20/2024, my lords, by the order of appellate authority, without giving me notice of termination under the contractual termination clauses was not followed, my lords.
Where is the contract awarded to you first?
Yes, my lords. That, my lords, may see at Annexure B 2022, which is the request for proposal, which my lords may have it on page number 22. It is dated as 18/10/2022.
18 page, sir.
Page 22, my lords. It reads as tender for supply and installation of blast freezers for health institutions. My lords have 22?
Yes.
Yes, my lords. The date of the tender was 18/10/2022. Now, my lords, I will take you through, my lords, the essential conditions of the tender, which according to me, my lord, the tendering authority itself has breached. Please, my lords, may have.
Where is the order of the appellate authority?
My lord, that my lords would find on page 20.
20.
Yes, my lords. The operative portion.
1 minute. Who files an appeal?
My lords, the disgruntled tenderer who didn't win the tender.
You are not heard before the appellate authority?
My lords, my lords, there is no order, there is no reasoning as to my defenses, my lords. It's simply name is shown, my lords.
The case was heard with appellant requirement of Cisco.
Third paragraph, page 18.
Conclusion, supply of more than 18 months have passed. The tender was
Supposed to supply it within six months.
My lord, they did not give the delivery location only, my lords. Please see, my lord, there is a condition of tender which they have to give the delivery location. I don't know where to deliver. How will I give, my lords? Please come to clause 8 at page 37, my lords.
Clause 8 at?
Page 37. The equipment shall be supplied to the locations across Karnataka state as stipulated in the purchase order.
Where is the purchase order?
Yes, my lords. My lords may kindly go to the supply order, which is at my lords, kindly go to page 79.
Where are you from?
My lords, from Delhi. The petitioner is based out of Lucknow, my lords.
No, I'm asking you, sir.
My lords, from Karnataka, but now practicing it before the. Delhi, my lords, Delhi.
Yes, we'll hear it. This has to be heard anyway.
My lords kindly grant stay because, my lord,
For
these
what
are
stay,
essential-
sir?
My lords, because they are essential equipments for, they will issue some other tender, my
You have
lords.
not
and-
delivered it anywhere.
My lords, already it is in my warehouse, my lords.
It's in your warehouse, I have to stay it, is it?
My lords, they have not given the delivery location itself. Please come to page 79, my lords.
18 months in the delivery location kotilva.
Yes, my lords.
Yes. Supply order, come to the supply order.
Yes, my lords. Please see clause 2 at page 79.
Delivery
The-
schedule.
Yes, my lords.
What is this, Shaman?
The equipment
Delivery
shall-
location is not given?
My lord, they only say that they will supply the location, but they have not given the delivery location itself. The items are lying in my warehouse in Lucknow. The day they give, I will supply, my lords. And I have spent already, my lords, more than 8 lakhs as EMD as well as some 3 lakhs on the
Yes, comment.
certification.
Get instructions.
Huh?
Get instructions next week. Use the
Learned
model
HCGP to secure instructions as the allegation of the petitioner is in the purchase order did not mention about the delivery location. Notwithstanding the fact that the tender condition was that the person to whom the tenderer to whom the work order would be issued with the delivery location as well. List the matter, next witness.
My lord, let it be status quo till that time. There
For
will
what,
be-
sir, status quo?
My lord, let it be status quo, my lord. Otherwise, they
For
will issue-
what status quo?
They will issue a fresh tender, my lord, and render it.
Nod. If they issue a fresh tender, you move the matter. Yes.
My lord,
them
let
issue-
that.
Let them issue,
at
we'll
least
see,
it-
sir.
My lord,
Let
let
them
it be
issue.
recorded, my lord. Let this
Let
be
them
recorded.
issue, we'll see, yes.
Much
Next.
of Much of
For the respondent.
My lords, I'm seeking for a short accommodation in this matter, my lords.
No, your
We have
lordship.
made a representation to the respondent bank, my lords, stating that we will clear all the dues by the 15th of April, my lords. That is being
Lordship, sale
considered
has
by-
taken place in this case, your lordship. I
What?
filed sale confirmation.
You do whatever you want. The learned counsel for the petitioner seeks 2
They have
weeks
not
time.
complied with the interim order also, your
Where is the
lordship.
interim order granted?
No,
It
in
is
the
connected matter, my lord.
2930, interim.
Tag
order
matter,
was-
my lords.
Yeah,
What is?
Here I'm challenging the section 14 order.
Give, sir.
connected with this
One
matter.
minute. ಎಷ್ಟು ಡೆಪಾಸಿಟ್ ಮಾಡಬೇಕಾಗಿತ್ತು?
10%, my lords.
Of what?
But 10% of
1.5 crore, my lords.
Submits that petitions are prepared to deposit 20% of the outstanding amount. ಎಷ್ಟು ಡೆಪಾಸಿಟ್ ಮಾಡಿದಿರ sir?
We
ಇದು
have
ಮಾಡಿಲ್ಲ,
not-
ಯಾವ್ದು
Nothing.
ಮಾಡಿಲ್ಲ.
Not a rupee.
No, my lords.
Thank
We intend to
Your intentions are very clear. Yes. The petitioner is before this court. Second one, bada, first, itagoli. Writ petition 293025.
one submission.
The
my lords.
petitioner is before this court
Fails to
seeking the following prayer. This court showing indulgence grants an interim order of stay on 1/2/2025, which directed deposit of 2025 on the undertaking of the petitioner that they were prepared to deposit 20% of the outstanding loan along with interest. The outstanding loan as on that day recorded by the coordinate bench was 1,55,67,806. Therefore, 30 lakhs had to be paid to the bank on or before ಯಾವತ್ತದು?
By the next date of hearing, my
Ah,
lords.
by the next date of hearing, the matter was directed to be listed on 4/3/2025. Therefore, 4 weeks' time was granted. The matter came up on 4/3/2025. The interim order was extended on the score that the petitioner had not served the set of papers upon the counsel for the respondent. Again, on 10/3/2025, the matter was adjourned on the submission of the petitioner that it has to be tagged with another petition. The petitions are tagged, but the money has not gone to the bank first in terms of the interim order granted on 1/2/2025. It is not 4 weeks, but 8 weeks have passed by now, and not a rupee is paid to the paid by the bank, by the petitioner to the bank. Therefore, the petition does not deserve any indulgence, does not deserve does not merit any further consideration at the hands of this court, reserving liberty to the petitioners to avail of
I'm ready to
such a
argue with
remedy
it.
as is available in law. The petition stands disposed. Interim order subsisting stands dissolved.
Lordship, both the petitions.
Both, yes.
I'm grateful, my lords.
Yes. Next.
Lord, I'm yet to receive instructions, my lord. Next Wednesday.
ಏನಿದೆ?
Bank guarantee return ಮಾಡ್ಬೇಕಾ 2014.
Yes. Learned counsel for the learned HCGP seeks 2 weeks' time to secure instructions and make his submissions. List the matter on 2nd April.
For the petitioner, my lords. Guarantee listed in matter.
Fresh ಹೇಳಿದ್ದು sir.
This is regarding the tender called by the respondent number 2 for the supply.
ಅದೇ ಒಂದೇ ಪಾಯಿಂಟ್ ಇರೋದು ಅಂದ್ರಲ್ಲ ಏನು?
ಅದು ಏನಿದೆ
They haven't furnished a SEDESCO certificate which they're supposed to give.
What certificate?
SEDESCO.
Hmm.
So CDS.
Sedesco.
It's the procurement of medical
Also,
devices
my lord.
or the functioning of the medical devices, manufacturing, everything is regulated in terms of the drugs and cosmetics.
Correct.
Notes 2017 medical devices rules has been framed. Notes 2020 an amendment was brought about to the rule saying that there are certain equipments for which CDSO certificate is mandatory. This is one such equipment which is sought to be procured.
So it does not have that certificate.
He admittedly does not have that. But now what he does is he participates in the tender. Even in the writ petition, he has not challenged the tender condition. Kindly have a look at page 92, my lords. He is relying upon the original tender notification which said in the alternative. Kindly have a look at page 92.
92.
Yes.
Hmm.
Column number 2, appendix specifications. The entire system shall be, that is the statement, then change to, not the earlier system which was provided for is changed to manufacturer stroke importer should have SEDESCO certificate for manufacturing and importing the equipments. Not, it is not that they have just prescribed this. I'll just point out, may I just pass on these rules. There is it is now completely regulated regime. May I just pass on those rules, my lords.
Hmm.
Notes
What-
the
What is the challenge?
My lord, one submission.
Hmm.
Kindly see page number 28, my lord.
Hmm.
For a moment.
28.
In eligibility criteria, serial number 8, my lord, page number 28.
Hmm.
Page number 11 of the tender document.
Correct.
They
One-
say that.
any one
they
of
can-
this
any one of
document
the
is
document
mandatory.
But they have not changed this condition, my lord.
This is only changed.
This is intact. But.
Corrigendum
they have
is issued to what?
They have issued corrigendum on the last date of submission.
Solve,
At
no
the end
problem
of the
at all.
moment, my lord, nobody can obtain the CDSO certificate on the date of submission. In the span of 3-4 hours,
Alla,
we
ಈಗ-
cannot obtain the CDSO
one
certificate,
minute.
my lord. Earlier condition.
Last date of tender ಏನು?
26/12 is the last
26/12,
date
my
of
lord.
tender.
26/12.
12, and the corrigendum issued is on 26/12, my lord.
But this is an inherent condition. That is the reason why I want to read the rules. Without the requirement of CDSO certificate, a person cannot supply. It is not permissible for him to supply in this
You have
country.
the certificate?
Yes, we have a certificate. But as on the date
What
of,
certificate do you have?
they don't
My
have
lord,
the certificate.
First,
ಅಲ್ಲ, ಈ ನಾಲ್ಕರಲ್ಲಿ ಯಾವ್ದಿದೆ ನಿಮ್ಮ ಹತ್ರ?
we have CDSO, C certificate, ISO certificate, and acknowledgement for applying the CDSO certificate, my lord.
Hmm.
First they contended that first their condition was to submit only acknowledgement for applying the CDSO certificate.
Yes,
Till
sir.
the last date of submission, they were silent.
Why did you notify like this?
And out of the 64 conditions,
Number
wait,
2
wait.
has notified it.
Huh?
Respondent number 2 has notified.
When it was the notification, tender notification depicted 4 kinds of certificates.
Yes.
On the last day, how can it be changed?
Keeping that.
just to favor the
Yes,
respondent
sir.
number 3.
No, Keeping.
May I just refer to that? Kindly have a look at the rules, my lords. Kindly have a look at the
ಆಯ್ತು,
rules.
ರೂಲ್ಸ್ ಸರಿ, ರೂಲ್ಸ್ ಪ್ರಕಾರ ಟೆಂಡರ್ ನೋಟಿಫಿಕೇಶನ್ ಇಶ್ಯೂ ಮಾಡಬೇಕಾಗಿತ್ತು.
Lords, the,
Where are the rules?
kindly
What
have a look
rules
at
are
the
you
rules.
referring to?
lords. Just passed on the rules. Lords,
Classification of medical device.
Lords, in that page number 5, your lords may kindly take. Rule 19A, which is inserted to 2017 rules by means of an amendment.
Medical devices shall central
Subrule 2,
licensing
yeah, medical
authority.
devices referred to in subrule 1 shall be registered with the central licensing authority through an identified online portal established by the Central Drug Standard Control Organization. This is CDSO. That is a certification. Then your lords may kindly take page number 7. 3, 19A3. In the said rules, the 8th schedule in the table relating to exemptions after.
Where is your tender document?
My tender document, my lords, is not produced.
ಅದ್ರಲ್ಲಿ ಏನ್ ಹೇಳಿದೀರಾ?
Not
What
CDS
certificate have you produced?
CDSO certificate, my lords, this is not the requirement as of today, my lords. CDSO certificates requirement has been there from 2020.
Why did you give 5 options? Why did the tender document depict five options?
Lords, may kindly take page 28, my lords. I'll just explain.
Yes,
Of course,
28
it's for
indeed.
them to explain.
Yes.
But nonetheless, if your lords is going to take page 28,
Yes.
lords, lords, I'm unable to, just page number.
25, sir.
Page 25, my lords, I'm sorry, page 25. Can you first open? Lords, clause F and G.
F and G.
Yes.
ಯಾವ್ದು F and G?
Lords, this is of the eligibility criteria at page 25.
F and G, all right.
F and G.
The bidder manufacturing so and
It is
so.
there.
License should be issued from CDSTO. For the import equipment so and
But
so.
manufacturer as well as importer. Now, lords, may kindly take page 92. There is nothing more which is said.
Option ಯಾಕೆ ಕೊಡ್ತಾರೆ ಇವ್ರು ಮತ್ತೆ ಎಲ್ಲ?
Lords, this option, whatever has been given, is the additional documents, ISO certification, all these things are. But what is the basic requirement in the first part of the tender itself is very explicit. They cannot, this is not challenged.
My lord, both are contradictory to each other, my lord. Once, one side they say any one of the document is enough, and another part they say CDSO certificate must be there. And in, on the last date of submission, they.
ಅದು eligibility criteria.
It's a eligibility criteria.
No,
That's the
even
first-
if we ignore the last day's change, last day's change is only recognizing the rules.
Yes.
Yes. Last date change, but until the last date of submission, there was a requirement for only kindly see point number B, my lord.
ಈಗ
at page number
how many people
28, my lord.
participated in the tender?
Only three members.
three.
my lord.
Three. Which is, who was the third one?
The other one, my lord, was health tech.
ಅವ್ರಿಗೇನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇತ್ತು?
They, my lord, also didn't qualify.
ಅಲ್ಲ,
They also didn't qualify.
that SEDSCO certificate was not there.
That, my lord, the records of your lords, right?
Records are here, correct.
My lord, kindly see page number 56 also, my lord. If
ತೊಗೊಳ್ಳಿ
that
ಅವ್ರು ಕೊಡಿ.
earlier condition was to produce any one of the certificate, my lord. Until then, we were required to produce only account for the CDSO certificate, my lord. If the condition was to produce.
ಆ ತರ
CDSO
ಎಲ್ಲಿದೆ
certificate-
acknowledgement ಕೊಡ್ಬೇಕು ಮಾತ್ರ
Yes,
ಅಂತ
my lord,
ಇದೆ.
kindly see page number 28, point number B, my lord. If the firm does not have the valid CDSO certificate, they should upload the
clause?
account for of the application.
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ?
submitted for
ಎಲ್ಲಿ
obtain-
ಓದ್ತಾ ಇದ್ದೀರಾ ಸರ್?
Page number 28, my lord. Page number 28 of the petition, page
If the
11
firm
of
does not have valid, they should upload the acknowledgement of the
of the
application
application
submitted
submitted
obtaining
for
renewal.
obtaining.
Obtaining renewal SEDSCO certificate before the issuance of award of contract.
Yes, my lord.
Now, whose bid is higher?
That of course,
Whose bid is higher
Actually,
or lower rather? Yes.
lower, this will be the lower.
Who is L1?
L1, my lord, is this person, my lord.
Petitioner or the respondent?
Respondent.
my lord. Petition,
can
we are
still-
the lowest bidders, my
But
lord.
we can still cancel it. Not issued work orders yet.
No, that's all right. ಏನ್ ಟೆಂಡರ್ ಇಶ್ಯೂ ಮಾಡೋದು ಕ್ಯಾನ್ಸಲ್
Cancel
ಮಾಡೋದು
ಮಾಡೋದು
ಕೆಲಸ?
ಅದೆಲ್ಲ ಅದೆಲ್ಲ.
I'm just saying that.
No, see,
Not that we're favoring any.
government, you should be clear in whatever you say.
Lords, if you
Why do you leave these loopholes every time you do this?
No, keeping this aside also, so far as annual turnover is concerned, he doesn't furnish
Qualify.
those documents and he doesn't qualify there. So there also he gets rejected. In fact, my lord, in the last 3 years, which was also 2021 to 2024, the first year, my lord, 2021, 2022, he's supposed to have at least half the amount of the tender value, which is about 13.5 crores. He has shown about 6.5 crores. Therefore, he
We
doesn't
are the
qualify.
MSME certificate, MSME.
MSME, that's why half. That's why half. He doesn't have half also. On that ground also, my lord, he's been rejected. Not just this certificate.
My lord.
2 points.
My-
No,
Ten-
Tender.
Technical bid has been
scope-
rejected only.
See,
on the
unless,
CDSO.
unless it is, the arbitrariness is palpable or demonstrable,
It is
it's very
arbitrary.
difficult. ಎಲ್ಲಿದೆ?
Kindly.
See, rules are in place. First thing, SEDSCO certificate.
CDSO cert-
That's what. CDSO certificate rules are in place. It
Yes.
is mandatory.
it
The
is
eligibility criteria says that. Then you, these people have created this ambiguity saying, one of these irbeku, illa setsko acknowledgement irbeku. Where is the acknowledgement of renewal?
Is produced at annexure F, my lord, page number 70.
Even then, you are not the L1.
We
You are
have
not the
quoted-
L1.
We are the L1, my lord. Because. No, no,
Records
we
will
have
be.
quoted much less than the
Yes,
respondent number 3, my lord. Proposed respondent number 3.
Milords, even that is expired, Milords. The
Yeah,
CESCO
what is expired?
certificate, that is also expired.
ಅಲ್ಲ ಅದನ್ನೇ acknowledgement for
Acknowledgement
renewal
ಅದನ್ನು-
ಅಷ್ಟೇ.
ಅದು expire ಆಗೋಗಿದೆ.
Which one?
ಅದು ಇವತ್ತಿಗೆ expire ಆಗಿದೆ.
I will.
No more adjournments in this.
My lord, madam.
Enough time
I
I've
will-
spent. No,
I will-
nothing.
I will submit the.
Page
this one.
76, Milords. I'm sorry, your lordship is looking at the records.
TDS, so acknowledgement, my lord, that is.
ಇದು 29/6/24. After corrigendum, 7 days was given, Milords, for the purpose of making applications. 26/12, that's the statement made by him is not correct. 26/12 was the initial date fixed for submission of the bids. After the corrigendum was issued on 26/12, 7 days was extended for submitting the bids.
Where do I get that?
In 7 days, we cannot obtain the CDSO certificate, my lord. It
That
is
is not a
issued by the
dispute.
central government in the Delhi. We cannot obtain the CDSO certificate in the span of 7 days, my lord. Initial condition. we-
No, if you are really the L1,
Yes,
then I would have shown some indulgence with all this. You are not the L1 even.
my kindly have it on Thursday, my lord. We are Engaging the senior council, my lord.
I know. ಇದ್ದು ಮಾತ್ರ ಬಿಡೋದೇ ಇಲ್ಲ. Yes.
Kindly, sir. Kindly have it on Thursday, my
No,
lord.
no, no,
Kindly
sir.
have it on Thursday. There is ambiguity in the tender conditions, my lord.
Correct, there is ambiguity. I will
Yes,
clear
my
that
lord.
ambiguity.
Kindly let them recall the tender and issue fresh tender
We'll
conditions.
see that what order will pass, will pass.
My lord,
Yes.
humble request, my lord. Kindly have it on Thursday.
ಇಷ್ಟೊತ್ತು ಕೇಳಿದ್ಮೇಲೆ. Yes, heard reserved. Next.
Please, Milords.
After 1.5 months, they are asking us to submit a CDSO certificate, my lord. In the initial condition, it was there, we would have obtained the CDSO certificate specifically for the equipment, my lord. In the span of 1 week, we are obtaining the CDSO certificate, my lord.
We'll see, yes. Heard reserved. Records ಕೊಡಿ. Huh? Yes.
Doesn't satisfy the annual turnover also, not.
Even in terms of annual turnover, we qualify, my lord.
Yes,
I
next.
have the documents.
ನೀವು ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ಮೇಲೆ ಆಮೇಲೆ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಅನ್ಬಾರ್ದು. Yes, next. ಯಾರು ಇವ್ರು ಇಂಪ್ಲೀಡಿಂಗ್ ನೀವು?
ಹೌದು.
All right, yes.
My lord, one submission, there was no time to, time granted to us to make any representation.
We'll see,
regarding-
I'll see what order I should pass. Next.
22.
ಈಗ ಸ್ಟೇ ಇದೆಯಾ ಅದರಲ್ಲಿ?
Yes, my lord.
Entry order stands extended till the disposal of the petition. Yes, next.
For the petition, this case.
For the respondents.
KEB.
Certain guidelines, my lords, were issued so as to call for tender, in which, my lord, the respondent authority wanted to, my lord, secure the tenders from the fresh contractors, my lords, even without any
Yes, madam.
experience.
Lord, first submission, what has happened, my lord, circulars were issued. Subsequent to the issuance of circular, if your lordship sees annexure B, page 26. The same circulars were questioned by, in another series of matters, my lord, but though on different grounds. Subsequent to this, my lord, the state government has issued a circular telling to withdraw all the tender notifications, my lord. In this regard, if I may pass on,
File your objections, madam.
please,
Yes. List the matter, 10 days.
Lord, 2 weeks. at least.
List the matter on 4th April. Objections, if any, by the respondent by then.
Till
Next.
then, my lords, they may not issue.
ಏನ್ ಮಾಡ್ತಾರೆ?
It is already acted upon. Circular is of last year.
Now, my lords,
Acting
there is no fresh tender invited. We have been continued. Now, my lords.
President issue ಮಾಡಿದ್ರೆ ಮೂವ್ ಮಾಡಿ. Yes. Next.
And
but don't issue the tender and frustrate these proceedings.
No, my lord, what has happened, all the existing tenders which are issued also are being withdrawn because the.
Give us this,
In this,
No,
they
no,
have not
they have
questioned
been
the tender notification at all.
yes.
Because government has now stated that reservation has to be adopted by KPTCL as well, my lord. So we're withdrawing all the tenders notified. So it
How
might.
can you stop that?
We are not questioning the
Then-
resolution. We are not questioning. One notes, the fresh contract, my lord, is thought to be inserted, my lords, without any experience.
No, no, no.
Where, my lord-
If they are violating the policy of reservation which by the state and then issuing tenders, you tell me. Yes, next.
Please.
4th April, yes, next.
Obliged.
23.
This is with regard to,
So no subsisting work order.
my lord had asked me, posed a question, my lord, with regard to my right. But kindly turn to page 16, my lord, clause 17 of the work order.
Objections ಹಾಕಿದ್ದೀರಾ? ಬೇಡವಾ? Yes. Yes, sir.
Page 26, my lord, clause 17. Which requires me, my lord, as a supplier, existing supplier, to go and collect that indents on 25th of every
Oh,
month.
the indent problem.
Yes.
31st March ವರೆಗಲ್ವಾ ಇರೋದು?
How, 31st March.
ಈಗ you're still supplying?
Supplying to
Nothing has
73,
been supplied since.
for which I have filed my.
Worship passed an order, my lord, asking him to supply. He hasn't supplied anything to.
That is what false.
Nothing has been
made, my lord. Incorrect
How
submissions
how
have
do
been
we now assess? He says he has supplied.
Lord, I
You
have
say you have
filed-
not
I have
supplied.
filed the
He has to come to
photographs
the
also, my
taluk
lord.
of.
1 minute, sir.
He has to come to the taluk office. He'll get a list of indent. There's a shortage in particular hostels. This is what is short of. Then, my lord, he'll supply to those particular hostels. There'll be.
You
acknowledgement
file an
done in that
affidavit of your
hospital.
officer that he has not supplied.
No, so I'll supply, I'll.
List the matter on
affidavit.
Friday in the fresh matters
The
list.
report here, man.
The allegation is
Report.
despite the grant of interim order, the petitioner has not supplied, which has led to a serious problem in the hostels. The officer,
District officer, my lord, is
district
supplying.
officer who's inspected the premises and alleging non-supply of food shall, is an affidavit?
No, it's a report.
Lord, I have no.
It's a
Shall
report.
file an affidavit
Will
that
do
the
it.
petitioner has not supplied. In the event the petitioner has not supplied despite the interim orders and created problem to the students, the petition would be dismissed with exemplary costs.
I have also filed IAs, my lord, to show
Yes,
that
next.
I have supplied to the hostels where the indents have been given and also to the hostels where indents were orally given to us.
Yes,
Those-
next.
Those documents are already on file.
Friday. Next, yes.
Got interim order.
ಅದ್ ಯಾಕೆ ಕಂಟಿನ್ಯೂ ಮಾಡೋದು ಬೇಡ. ಸಪ್ಲೈ ಮಾಡಲ್ವಲ್ಲ ನೀವು?
ಅಲ್ಲ
ಯಾಕ್ ಬೇಕು?
ಸಪ್ಲೈ ಮಾಡ್ತೇವೆ ಸ್ವಾಮಿ, ಅಲ್ಲಿ ಹೋದ್ರೆ ತಗೊಳ್ಳೋದಿಲ್ಲ ಅವರು, ತಗೊಳ್ತಾ ಇಲ್ಲ.
ಯಾರು ಫುಡ್
ಯಾರು ಹೇಳ್ತಾರೆ?
ನಾನ್
ಅಲ್ಲ, food material- ಫುಡ್ ಮಟೀರಿಯಲ್ಸ್ ತಗೊಳಲ್ವಾ ಯಾರು?
ಇಲ್ಲ, ಫುಡ್ ಮೆಟೀರಿಯಲ್ಸ್ ತಗೊಳ್ಳೋದಿಲ್ಲ. ದೇ ರೆಫ್ಯೂಸ್ ಟು ಗಿವ್ ದ ಡೆಲಿವರಿ ನೋಟ್.
Oh, now that is coming up.
No, I have produced those documents, my lord, for.
ನೀವು ಹೋಗಿ ಇಂಡೆಂಟ್ ತಗೊಂಡಿದ್ದು ಎಲ್ಲಿದೆ?
ಅಲ್ಲ 73, that is what.
ಓರಲ್ ಆಗಿ ಸಪ್ಲೈ ಮಾಡಿದ್ದು ಯಾಕೆ? ಇಂಡೆಂಟ್ ಯಾಕೆ ತಗೊಳ್ಳಿಲ್ಲ?
ಅಲ್ಲ, ಅವ್ರು ಫಸ್ಟಿಗೆ ಇಂಡೆಂಟ್ಸ್ ಕೊಟ್ರು. Now we have supplied to them. Some of the hostels did not give us the indents.
Friday.
Even that we
List
have
on Friday.
supplied.
List
Now
on-
they say that, my lord, we are not going supplying to the hostels. If they, even today I am ready, even now I am ready, because I have already procured, because procurement is also, photographs are also there. If they say that if I am entitled to supply, I will supply, my lord. They
I will
refuse.
dismiss it on the ground that seriously disputed questions of fact are projected here. To hold an inquiry and close it.
Yes, my lord, I am ready for that.
But interim order continue ಮಾಡಲ್ಲ.
ಅಲ್ಲ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಏನು ಅಂತ ಹೇಳಿದ್ರೆ, ನಾನು ಇಷ್ಟವರೆಗೆ ಸಪ್ಲೈ ಮಾಡಿ ಆಗಿದೆ ಸ್ವಾಮಿ. 35
ಸಾಕು.
ಅಲ್ಲ 73 hostels ಸಪ್ಲೈ ಮಾಡಿದ್ದೇನೆ. They say that I have not supplied to the remaining hostels.
List the matter on Friday.
ಅಲ್ಲ, ಎಂಕ್ವೈರಿ ಆಗ್ಲಿ ಸರ್, ಎಂಕ್ವೈರಿ ಆಗ್ಲಿ ಸರ್.
Yes.
I am ready for that enquiry.
But in 24, but I represent respondent number 7. I have filed wakalat yesterday.
ಏನಿದು?
Lord,
This
this
is
is
regarding the rare diseases matter.
Oh, yes.
Seeking for
Mm.
interim
I
order.
represent respondent number 7, my lord.
Mm.
I have been designated as a center of excellence.
Correct.
I have filed my wakalat yesterday.
All right.
Yes.
Mm.
Well,
What solution ಏನು?
solution, my lord, there is a policy, my lord, of the central government. Your lordship has seen the policy. In the policy guideline, your lordship kindly see, my lord, clause 1(8).
Page 3.
Where do I get the
Page
policy?
3, page 3, my lord.
You produced the policy?
Yesterday I placed on record.
Yes.
Page 3, madam.
Hmm.
The employees of central, state government, PSUs, autonomous bodies, statutory bodies, and their family who are beneficiary under the central government schemes such as CGHS, EHS, etc. State government health schemes and any other scheme of PSUs, autonomous bodies, statutory bodies will not be eligible for getting financial assistance as per NPRD 21. If the central or state government PSUs, autonomous bodies, statutory bodies, employees is not covered under any of their schemes as mentioned above, an undertaking should be provided by the head of the department of the employee. If they give that ballot, we are ready to administer. That is one thing. That is one thing. My lord, I've seen the writ petition. My lord, they have gone to the Baptist hospital. There it has been diagnosed. And they have to get it, my lord, this thing from the Center of Excellence. That is why, my lord, the Center of Excellence was, my lord.
Now, if they fulfill all your requirements, you will give it.
Yes,
Lord, we have gone to the
not
Center of
19 crores,
Excellence.
and all, this is staggered payment and
So
this is
staggered payment, not one day payment.
No, payment will be to the, my lord, payment will be to the CEO, not to the.
Correct, to
yes,
the hospital there.
hospital.
Yes.
And hospital will, my lord, we'll give the treatment. We will give the treatment, my lord. The central government is given monies to us. Under that, we will give the treatment.
Lord, we have already approached Center of Excellence at Annexure E, my lord. The same medicine has been prescribed.
What has happened there?
They have prescribed the same medicine which we
What
are.
else you want? You want a different medicine?
Lord, we want the same medicine, my lord, but Lord, money to buy the medicine.
That they will give is what is
They-
said.
we will not-
Maybe directed, my lord, because the.
That will
No,
do. I'll
that will subject to they're fulfilling all
I'll
the
record
criteria.
his submission. What is that they should fulfill now?
Well, that they have to give a undertaking by the employer, head of the department of the employee.
ಅದೇ CGHS
Yes.
the
ಯಾವ-
health schemes ಅಲ್ಲಿ ತಗೊಂಡಿಲ್ಲ ಅಂತ. ಅಷ್ಟೇ, you give an undertaking that you have not
ಸ್ಕೀಮು ಇಲ್ಲ
taken the
ನಮ್ಗೆ.
same amount from those schemes, that's all.
ಗವರ್ಮೆಂಟ್ ನಲ್ಲಿ ಇಲ್ಲ ಅಂತ ಕೊಟ್ಬಿಟ್ರೆ
ಅಲ್ಲ, ಈ ಅಮೌಂಟ್ ಗೆ ಯಾವ ಸ್ಕೀಮು ಇರಲ್ಲ.
ಅಲ್ಲ, ಇಷ್ಟ ಅಮೌಂಟ್ ಇರೋದಿಲ್ಲ.
ಅದೇ.
ಇಷ್ಟ ಅಮೌಂಟ್ ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ ಲಾರ್ಡ್ಶಿಪ್ ಕೈಂಡ್ಲಿ ಸಿ ದಿ ನೆಕ್ಸ್ಟ್ ಒನ್. ಈವನ್ ದಿ ಪೀಪಲ್ ಕವರ್ಡ್ ಅಂಡರ್ ಮಿಲಾಟ್ ದ ಪ್ರಧಾನ್ ಆಯುಷ್ಮಾನ್ ಭಾರತ್ ಅಂಡ್ ಪ್ರಧಾನ್ ಮಂತ್ರಿ ದೇ ಆರ್ ಗಿವಿಂಗ್. We are giving to them.
Yes, sir.
Lord, this
I will
scheme
close it by direction.
Lord, the scheme was uniformly extended to everyone, my lord.
They are not saying they will not extend. What do you want now? That without any undertaking or without compliance with this policy, you want me to direct them?
Lord, it may be taken up tomorrow, my lord.
Why, sir? ಮತ್ತೇನು?
I'll see that policy and make my submissions. my lord.
Policy ನೆನ್ನೆ ಕೊಟ್ಟಿಲ್ವ ಅವ್ರಿಗೆ?
It's aware, my lords, it is on.
It's on the website.
Taken up tomorrow.
No, you are in a hurry.
Please, my lord, I am in a hurry, my lord. I'll look into the policy and I'll make my submission.
See, policy, ನೋಡಿ ಇಲ್ಲೇ. ತೊಳಿ.
Sir, may I suggest this, my lords? He can raise funds through crowdfunding and all.
Lord, we have already
fact, he
raised
can place
funds,
a
my lord, with respect
request
to
on-
crowdfunding. It has been a big failure. The same has been recorded in the Delhi High Court judgment. From 2021 to 2024, my lord,
Oh,
hardly.
it's all right, look into this.
Now this policy is in place, but these policies were not before the Delhi High Court.
That's what she said.
Yes.
Those are, this policy, that judge, the Delhi Court judgment is prior to the policy.
Yes, back to the.
Yes,
Correct.
my lord. No, no, no.
No,
But Delhi High Court judgment is 7th October.
it is 7th
2024.
October, but this policy was not placed there.
2021.
21.
21. This is 22, 11th August 22, my lord, the policy is.
This is Delhi High Court judgment is stayed if my lords want.
That we
That's
told.
also state, my lord.
My lord, it is state subject to central government implementing the order
Could you-
dated 19/5/2022.
At
There's
the
a
19/5/20,
notification by the central
my lord.
government.
19/5/22, they are
2022, where,
referring
my lord,
to.
50
Now-
lakhs.
Now, the-
Ramesh sir is saying Center of Excellence is ready to grant you the medicine that you want,
yes.
subject to clause 3.
Please,
That's all. Clause 3 you saw?
clause 3.
You still want time?
Lord, ಮಧ್ಯಾಹ್ನಕ್ಕೆ ಹಾಕೊಂಡ್ರೆ ಆಯ್ತು.
ಆಯ್ತು, ಪಾಸ್ ಓವರ್ ಬೇಡ, ನಾಳೆ,
Please.
ನಾಳೆಗೆ.
tomorrow.
My name may be shown, my lord.
Registry to print the name of
I filed my state.
NK Ramesh appearing for the 7th respondent, Allah?
Yes.
Appearing for the 7th respondent, yes. ಅಕಸ್ಮಾತ್ ಪ್ರಿಂಟ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನಾಳೆ ಬನ್ನಿ.
That's one more submission I have. The eighth respondent is a private organization. It's not part of the government wing.
Oh,
So
ನಿಮಗೆ
my lords
notice ಆಗಿದೆ.
directed notice to me.
The
I cannot take it.
registry to delete the name of Sadhna S. Desai is appearing for the eighth respondent and retain the name as appearing for the first respondent only. Yes.
Same as 23. my lord.
Indent
is
ನಮ್ಗೇನ್
20.
ಕೊಟ್ಟಿಲ್ಲ, they are not supplied.
They have Friday ಹಾಕಿದ್ದಲ್ಲ.
Because there's no
They can
intermodern.
dispose of it, but I am not pressing for
Friday,
this.
yes.
I am not pressing for this because I am not,
Petition dispose ಮಾಡಲಿ. ಯಾಕೆ?
because I am not issued with an indent from
Ah.
1st of March.
Hmm.
I am not supplied till today.
Then what do you want?
Maybe
Disposed. The
because the fact remains that they have not issued indent to me.
The petitioner is before this court seeking the following prayer. The learned counsel, we are Sarthi appearing for the petitioner in all fairness would submit that in other cases, indents are issued for procurement and supply up to 31st March 2024-5. And in the case of the petitioner, it has not been issued.
Except the bank guarantee.
Except, not been issued and except seeking of a bank guarantee. Therefore, the petition would not survive for any further consideration is the submission of the counsel of the petitioner. In that light, the petition is disposed as having become infructuous. Yes.
Weeks time, right?
ಏನ್ ಕೇಸ್ ಇಲ್ವಲ್ಲ?
ಪಾರ್ಟಿಗೆ ಒಂದು ಸ್ವಲ್ಪ ಸೂಟ್ ಪೇನ್ ಅಂಡ್ ಪೆಂಡಿಂಗ್ ಇದೆಯಾ? If any pending minute, I will. 1 week.
At the request of the counsel for the petitioner, list the matter after 2 weeks. Next.
Petitioner submitted complaint to the respondent. Day before.
Police protection.
Yes, ma'am.
Yes, Rahul.
Is pending.
Injunction order ಇದೆಯಾ?
Injunction order, Disam court my lord disposed of the writ petition, holding that the title of the petition my lord. Annexure.
Concealed it.
Annexure.
Family litigation. Sir.
My lord, ink page number 121 my lord, wherein the.
Let him go before the civil court and seek.
In terms of circular 14/11/2018, if there is any threat in real time, you do it. That's all. No positive direction. Yes. The petitioner is before this court seeking the following prayer. The petitioner is said to have registered a complaint on 24/7/2024 against the other family members. Therefore, the dispute that is looming large in the case at hand is between the members of the same family or the siblings as the case would be. The petitioner then seeks police protection by submitting a representation on the score that the other family members are considering other family members are creating a problem to the possession of the petitioner. No civil suit is registered on the same issue.
Your lordship, there is a civil suit.
Civil suit, partition suit my lord. Partition suit is, it is self-acquired property of the
It's all
petitioner
right.
mother.
So the learned HCGP on instructions and verification of the records would submit that they have also filed a civil suit which is pending adjudication before the competent civil court. And in the representation, nothing is found that is warranting police protection. By way of police protection, the learned HCGP seeks to emphasize the petitioner wants to arm twist the defendants in the suit. Be that as it may, if the threat looms large against a citizen, and that threat is in real time, the police are necessary to accord such protection to the life and limb of those persons. The circular dated 14/11/2018 is apposite to be referred to, where the government itself recognizes that if there is threat in real time to the life and limb of any person, the police protection should be granted and not to be misused for collateral purposes. With the aforesaid observation, the petition stands disposed. Next.
Appearing for the petitioners, my lord, have challenged auction sale notice. Which is not taken.
1 minute. Yes, sir.
Challenging the auction sale notice in this petition.
It is
Sale has not taken place.
Sale did not take place.
Did not take.
Hmm.
My lord, for a moment, kindly see page number 44.
Sale ಆಗಿಲ್ವಲ್ಲ ಬಿಡಿ.
But they have seized my property. That subsequently they have issued another sale notice.
Where is
Auction
that?
is going to be held on 26/3.
ಎಷ್ಟಿದೆ?
My lord, 4,69,99,560.
DRT ಹೋಗಿಲ್ವಾ?
Got to my scheduled property, immovable scheduled property, my lord. where I
ಏನಾದ್ರು
have
ಇರ್ಲಿ.
filed-
What is the amount in due?
My lord, kindly see page number 44 for a moment, my lord.
Hmm.
It states that the overdue is on date, that is on 31st Jan 2025, my lord.
Ah.
The overdue is only 22 lakhs.
ವಿಘ್ನೇಶ್,
But if you
ಪೂರ್ತಿ
see-
ಫಿಗರ್ ಹೇಳ್ಬೇಡಿ. ಎಷ್ಟು ಓಲ್ಡ್
Regularize. The reason is
The
this, my lord, kindly come to page number 61.
ಯಾವತ್ತು
Sir,
NP
sir,
ಆಗಿರೋದು?
no.
1 minute, sir. ಯಾವತ್ತು NP ಆಗಿರೋದು?
My lord, account become NP on, my lord, 12/10/2024.
12/10/24. All right.
Call
ಅಲ್ಲಿಂದ
it as quick mortality. My lord, immediately after within a year.
12/10/24 ಗೆ 3 months ಮುಂಚೆ ಹೋಗಿ. ಅಲ್ಲಿಂದ NP ಆಗಿದೆ. ಅಲ್ಲಿಂದ
My lord,
due
kindly
ಆಗಿದೆ.
come to page number 61 for a moment. There's an IBC proceedings filed by one of the guarantor.
ಹಾ.
My lord, it is pending before the DRT. My lord, at page number 61, annexure J.
All right.
My lord, that being the case, my lord, when moratorium is operating, guarantor, my lord, in respect of restructure, my lord, this own, my lord, they have to come, they have to execute a document. There are certain procedures which can't be exercised in this matter. In way of, my lord, page number
Then
61.
why have you seized the vehicle?
Without,
my lord,
without notice, my lord.
Why have you seized the vehicle?
It is my security
Correct.
and it is not.
ಈಗ now they will pay whatever is to be paid. Release the vehicle.
My lord, he has to pay the entire outstanding that is. from
Not
the-
entire outstanding,
No,
sir.
in this matter, my lord, I can't restructure. The reason is, my lord, one of the guarantor already before the NCLT under section 94.
My lord,
Therefore, my
please-
lord, he can't come and, my lord, execute a fresh set of documents because of section, my lord, 96, my lord, moratorium is operating.
Hmm.
No, my lord, in fact, I will seize the vehicle because it's a quick mortality. It is not in dispute, my lord, that account become NPA. My lord, with all the, my lord, we have seized the vehicle and in fact, my lord, the sale, my lord, sale before this honorable court. My lord,
I'll stay the sale, yes.
my lord, subject to certain,
Nothing,
my
sir.
lord, I
The
just,
petitioner is
I'll make
before
only
this
one-
court.
my lord, I'll make only one submission before this honorable court.
I will reason it out now. Yes. The petitioner is before this court, calling in question an auction sale notice dated 29/1/2025. The sale is of the vehicle, right?
Vehicles.
The sale is of the vehicle that is said to have been seized from the hands of the petitioner. The learned counsel appearing for the petitioner submits that the seizure of the vehicle came as a bolt from the blue to the petitioner, as no notice even was issued with regard to any default prior to the seizure effected, and would submit that it is in gross violation of the law. In that light, I deem it a gross violation of the law. The NPA in the case at hand has emerged on 12/10/2024. And the outstanding due in terms of the account statement produced is the outstanding overdue in terms of the account statement produced is 22 lakhs. 22 lakhs. Therefore, the learned counsel would submit that the action of the petition respondent in bringing the vehicle to sale is grossly arbitrary. The learned counsel for the respondent, Bank Vignesh Shetty, also submits that one of the guarantor has knocked at the doors of the NCLT, is it?
Please, my lord.
Yes, ma'am.
Under
Under section 94
NCLT and proceedings are pending there.
Section 94 of my lord IBC.
Inter-moratorium.
And the interim moratorium is in operation. In
And
all,
outstanding, my lord, as on today,
Hmm.
my lord, 4,69,99,562.
In respect to scheduled property, movable property. immovable
whatever,
property.
ಈಗ vehicle ಬಗ್ಗೆ ಮಾತ್ರ,
Vehicle.
so and so. In that light, in the light of all the aforesaid proceedings, I deem it appropriate to stay
But in one
the
submission-
auction sale slated to be held on
26.
26.
26, it is not the prayer before this honorable court.
My lord, that is subsequent sale
My
notice
lord,
they have
it's not a
issued.
prayer. They have to file an application before this honorable court in respect of, my lord, subsequent
ಓ,
sale.
ಇದಾದ್ಮೇಲೆ ಇನ್ನೊಂದು
ಆ-
ಮಾಡಿದಾರಾ?
ಈಗ-
ಎಲ್ಲಿದೆ ಅದು? ಕೊಡಿ.
ಇಲ್ಲ.
Ma'am.
They have not served any application to me, my lord.
ಸೇಲ್ ಗೊತ್ತಿಲ್ವಾ ನಿಮ್ಗೆ?
Sale ಗೊತ್ತಿದೆ.
ಹಾ,
In fact, my lord, kindly see the prayer sought before this honorable court as well as interim order.
Prayer is setting aside the auction
File
sale.
an application.
Auction
in
sale
respect to- in
My lord,
respect
it
to
become
the
infectious.
subsequent sale notice.
Where is the applications? ಕೊಡಿ, ಕಾಪಿ ಕೊಡಿ ಅವ್ರಿಗೆ.
My lord, I'll take instruction on.
ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಸೇಲ್ ಗೊತ್ತಿಲ್ವಾ? ಈಗಲೇ ಹೇಳಿದ್ರೆ ಗೊತ್ತು ಅಂತ.
My lord, in respect of the present writ petition, my lord, the sale is supposed to be conducted on 29/1/2025.
Lord, for a moment, kindly see 44 page number, my lord. They have they have included all the seizure charges of 7 to 8 lakhs rupees, my lord. At the time of seizing my vehicle, it is only 12 lakhs rupees my outstanding. I mean, the overdue. After seizing my vehicles, they have include all the seizure
Where do I
charges
get that?
per vehicle.
Where do I get that?
44 page number. At the time of seizing, my lord, it was only 12 lakhs.
ಆಯ್ತಾ ಅದನ್ನ ಹೇಳಿದ್ರಲ್ಲ, how many times you'll repeat? Page?
44, my lord. 44, my lord.
ಅಲ್ಲಿ ಮತ್ತೆ ಬರ್ಕೊಳ್ಳಿ. The learned counsel for the respondent seeks to project an objection that the present writ petition is not is rendered infructuous due to the sale not taking place. During the subsistence of the petition, the bank has issued another sale notice seeking to sell the vehicles on 26/3/2025. The 2025. The submission is noted. The learned counsel for the petitioner submits that on the date of seizure of the vehicles, the overdue was 12 lakhs. 6 or 7 lakhs is added by the bank in a seizure, as a seizure measure or fees for seizure of the vehicles without even issuing notice to the petitioner with regard to said seizure or the overdue amount. In the light of the aforesaid, in the light of what is aforesaid, the sale that is slated to be held on 26/3/2025 shall stand deferred till the next date of hearing.
My lord, I may permitted to file objection. Fix a date, my lord. I'll serve it copy in advance. It is not the, my lord, the first time matter came up before this honorable court. Sale a sale that day, my lord, I mentioned before this honorable court, sale not taken place. My lord, I would have filed objection before.
Nimaguno, you also don't know the procedure. If subsequent sale is there, should you not file an application immediately?
I would have filed an objection.
Where is it?
Due course of law, I'll file
What due course?
I'll file an application.
You want all orders, nothing in terms of procedure. Bank will come up with all these things.
I'll file it today only, my lord. I undertake
Yes.
to file it.
My lord, fix a date in, my lord, coming week, my lord. I'll file my objection. It is not the case, my lord.
Division bench ಗೆ ಹಾಕಿ date fix
That, my
ಮಾಡಿಸ್ಕೊಂಡ್
lord,
ಬನ್ನಿ.
my respectful
Yes.
submission is this.
Yes.
It is a case wherein, my lord, I have all the rest to, my lord, seize the vehicle. Already, my lord, day before the NCLT.
It was
My lord,
a
I can't, my lord,
running
restructure.
vehicle,
My
Raw
difficulty it is.
materials,
Otherwise, my lord, I would have restructured it.
It was seized when it was on the road when running in the,
ಇಲ್ಲ ಮನೆಗೆ ಹಾರ ಹಾಕ್ಬಿಟ್ಟು ತಗೊಂಡೋಗ್ಬೇಕಾಗಿತ್ತ.
my lord, if they had intimated, I would
What,
have
sir?
taken
Yes.
of the goods, my lord.
Hmm.
The goods were also in the custody of
Any
the
date
bank.
may be fixed. That's all, my lord.
No problem. We'll fix it.
Grateful.
List the matter on 4th April.
Grateful.
Yes.
My lord, 7.
7th April, all right. Not on a Monday, sir. List on 8th, yes.
Grateful.
Here, as my lord, sale is sale. Sale not taken place. In fact, interim order their complaint.
Complied.
Sale again.
The petitioner is before this court seeking the following prayer. For this court on 7/3/2025 had passed the following order. 50 lakhs was deposited with the bank. This is accepted by the respondent's counsel Vignesh Shetty. And would further submit that the sale on the said date did not take place in the light of the interim order and its compliance. In that light, the petition is disposed, reserving liberty to the petitioner to knock at the doors of this court in the event another sale notice is issued. The bank, while issuing another sale notice, if needed, shall take note of the fact that the 50 lakhs is deposited pursuant to the order passed by this court. Ordered according. With the aforesaid observation, petition stands disposed. Ordered.
The order passed by this court, your lordship. In spite of it, your lordship has directed bank should put in question immediately. They have not put me in question, my lord. That is the memo I am filing.
Lord, action sale has taken place that has been suppressed, my lord.
Yavaga.
I'm telling you that. My lord, this action date notice was issued on 7/8/2024, my lord. Action took place on 9/9/24. The proposed respondent who has come was the highest bidder, my lord.
Auction 9/9?
9/9/24. And then physical possession was taken on 21/1/25, my lord. Sale certificate was issued on 31/1/25. And in the month of March, he comes up here with the DRT order telling that he has challenged the DRT order, my lord. Page.
DRT ಹೋಗಿರೋದು ಯಾವಾಗ?
ಅವರೇ ಹೋಗಿರೋದು ಸ್ವಾಮಿ.
ಅಲ್ಲಿ ಯಾವಾಗ?
See,
DRT has gone on
on 4/12/2024, page number 41 of the petition, my lord, they have filed the order. There was a conditional order that 23,74,000 to be paid on or before 3/1/25, which they failed. Stay automatically got vacated. We took the possession, my lord. Then second installment was to be paid on or before 2nd February 2025, which also they failed. On March, they have come.
DRT ನು comply ಮಾಡಿಲ್ಲ.
DRT have to comply ಮಾಡಿಲ್ಲ.
DRT comply ಮಾಡಲಿಲ್ಲ.
Sale ಆಗೋಗಿದೆಯಲ್ಲ ಸರ್.
ಅಲ್ಲ, your lordship has to appreciate this.
No, nothing.
ಅಲ್ಲ, your lordship has to appreciate it. 8/10/2024, they go before the magistrate to take possession. Not even a single word of sale has been uttered. 8/10/2024.
That's all right. ಈಗ
ಅಲ್ಲ,
ಸೇಲ್ ಆಗಿಲ್ಲ ಅಂತ ನೀವು ಹೇಳ್ತಿರೋದು.
ಅವ್ರು ಒಂದು ವರ್ಡ್ ಹೇಳಲಿಲ್ಲ ಸ್ವಾಮಿ.
ಎಲ್ಲಿ ಸೇಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ಎಲ್ಲಿ?
Milord, I have
ಆಗಿದೆ
produced
ಅಂತ.
along with my application, Milord.
It is a collusion between the action purchase and the bank because,
You approach the DRT, challenge it, sir.
I will challenge
Page
it.
6 along with my application, Milord.
Your lordship has
If
to
5 lakhs
appreciate
have
this.
not appropriated.
Sale intimation letter. ಇವ್ರಿಗೆ ಇಂಟಿಮೇಟ್ ಮಾಡಿಲ್ವಾ?
Yes, Milord.
ಎಲ್ಲಿ ಹೋಗಿದ್ದು?
ಏನು ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ.
Milord, sale notice
ನಮಗೆ
was
ಮಾಡಿದ್ರೆ
issued, he has not challenged it.
8/10/2024 ಅವ್ರ ಬ್ಯಾಂಕ್ ಇದು ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಮುಂದೆ ಹೋದ್ರೆ ಯಾಕೆ ಹೇಳಿಲ್ಲ ಸ್ವಾಮಿ? We have already sold the property ಅಂತ.
Milord, annexure.
That would have been
When-
One ನಿಮಿಷ.
certificate.
When did you file it before the magistrate?
8
Date of filing.
2024.
Date of filing.
8/10/2024. ಆ ಪಿಟಿಷನ್ ನಾವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ವಿ ಪೇಜ್ 16 ಇಂದ 19 ಅಲ್ಲಿ. Not even one word about the sale, your lordship. From 16 to 19, your lordship.
It is filed on 8/10/24.
ಸೇಲ್ ಆಗಿರೋದು ಯಾವತ್ತು?
9/9/2020.
ಮತ್ತೆ why did you not say that here?
Usually they are assigned to the agencies, my lord. for-
Alla, before DRT, he was a caveator, your lordship. He did not even whisper one word about it before the DRT. Though they were the caveators, bank.
Milord, I have taken a loan from the bank.
Now you are before the DRT ಅಲ್ವಾ?
DRT ನಮ್ದು ಡಿಸ್ಪೋಸ್ ಆಗ್ಬಿಟ್ಟಿದೆ ಸ್ವಾಮಿ.
ಏನ್ ಮಾಡಿದ್ರು DRT ಅಲ್ಲಿ?
ಪೆಂಡಿಂಗ್ ಇದೆ
DRT is still
ಅಷ್ಟೇ.
pending.
Still pending. my lord.
Then pursue everything there.
Then your
Milord,
lordship has to
before the
appreciate-
DRT, what was challenged,
Your
Milord,
lordship
is
will
order
kindly
of the
say,
magistrate.
my lord, your lordship has to appreciate the conduct of the bank in not whispering one word about the sale before the magistrate. And when they appeared before the DRT.
ಈಗ ಆಯ್ತು, all those things. Sale certificate is already issued.
Yes, your lordship. But your lordship,
46
if a
lakhs is
sale
the sale.
certificate has.
What is the amount in due, sir?
Your lordship will kindly say 2016 lakhs.
ಎಷ್ಟಿತ್ತು ನಿಮ್ದು?
Nanu 2,46,000 rupees is paid by them, according to them by the action purchaser. I am prepared.
ಎಷ್ಟು?
2 crores
2 crore 46 lakhs.
I am prepared to deposit the entire amount within 6 weeks, your lordship. The entire amount.
But ಎಲ್ಲಿ redemption ಕಷ್ಟ.
Alla, the redemption is your lordship has to appreciate if a fraud is played. Either,
That I am aware, that's all right.
therefore, the whole thing goes, your lordship.
ಏನ್ ಮನೇನಾ ಏನಿದು?
Mane Swami, residential house.
ಈ ಪೂರ್ತಿ ಕಟ್ತಾರೆ ಬಿಡಿ.
And your lordship will
I
kindly.
have taken, Milord, I have taken loan from the bank, State Bank of India. I have
He will
paid
pay
this-
solatium also to you.
My lord,
Milord,
another aspect, your
46
lordship.
lakhs I have paid.
After the sale, if they have received the entire money from the action purchaser, as per the direction of this court, when I paid 25 lakhs, they have accepted it.
I have
Direction.
They
I have
accepted it.
not appropriated, my lord. Your lordship directed me to
The
refund.
question
I'll
is
refund.
not appropriated.
I have not
The
appropriated.
fact they accepted without disclosing that it has been
Like
sold
instead
and
of
they have
Milord,
recovered the money.
for this court, Milord, he goes to the.
ಈಗ
police
ಸೇಲ್
station.
ನೋಟಿಸ್ ಇವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದು ಎಲ್ಲಿದೆ?
ಏನಿಲ್ಲ ಸ್ವಾಮಿ.
ತರ್ಸ್ತೀನಿ.
ಎಲ್ಲಿ ಸೇಲ್ ನೋಟಿಸ್ ಎಲ್ಲಿ?
ಇಲ್ಲ ತಗೊಂಡ್ ಬರ್ತೀನಿ.
ಇದು ಫಸ್ಟ್ ಸೇಲ,
Notice was
ಫಸ್ಟ್
issued
ಸೇಲ,
to the-
ಸೆಕೆಂಡ್ ಸೇಲ?
First sale,
First sale, your.
ವೇರ್ ಇಸ್ ಫಸ್ಟ್ ಸೇಲ್ ಅಂದ್ರೆ 30 days notice.
30 days ಕೊಟ್ಟಿದ್ದು.
ಎಲ್ಲಿದೆ?
See, date of notice is
Hmm.
on 7/8, my lord. Date of action is 9/9.
Sir, where is the notice? You
ನೋಟಿಸ್
search on
ಇವ್ರಿಗೆ
me.
ಸರ್ವ್ ಆಗಿರೋದು ಎಲ್ಲಿದೆ ನೋಟಿಸ್?
ತರ್ಸ್ತೀನಿ, it is from Mysore, I'll get it.
ಆಯ್ತು. Learned counsel Ahmad Ibrahim representing the respondent Bank of India shall place on record the notice issued to the petitioner seeking to sell his property as is necessary in law. As the allegation is, there was no notice issued to the petitioner prior to the sale. The learned counsel CM Nagbhushan appearing for the petitioner would further contend that if the sale has taken place on 9/9/2024, neither before the DRT nor before the magistrate in a proceeding under section 14 of the Surface Act 2002, the bank has whispered even about the sale that had already taken place. he would allege fraud played by the bank in the sale. Therefore, the respondent bank shall steer clear the said controversy. Again, intermodal ಇಲ್ವಲ್ಲ?
Intermodal is directly restore possession. Immediately ಅಂತ
He has gone to the police.
Status quo, where the property be maintained till the next date of hearing.
Acknowledgements are there.
ಎಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಅಲ್ಲ
ಎಲ್ಲ ಮಾಡಿ
ಹಾಕಿ ಯಾವತ್ ಬೇಕು
ಸೇಲ್ ನೋಟಿಸ್ ಒಂದು 7-8
ಯಾವತ್ ಬೇಕು ಅಂತ. Next week?
next week.
Yes, list on Thursday in the fresh matters list. Next.
The police, they are interfering with the matter. Yeah, in fact,
Status quo ಹೇಳಿದ್ನಲ್ಲ ಈಗ.
Saturday, Sunday, petitioner goes and sits in the police station, insisting that she should be handed over the possession.
All my materials. are
Status
inside.
quo, where the property be maintained by the parties. This is in modification of the earlier order.
I have not appropriated 25 lakhs, which is kept in the.
ಅದನ್ನ ಬಗ್ಗೆ ಹೇಳೇ ಇಲ್ಲ.
And that also I have kept. It is not that I have appropriated.
The only thing, let the police not interfere.
Status quo ಅಂತ ಹೇಳಿದ್ನಲ್ಲ.
ಹೇಳಿದ್ದಾರೆ, ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ ಸರ್.
Yes. 2:30 move ಮಾಡಿದ್ರು.
2:30.
Anyway, I have said status quo, now nobody can do it.
Yes.
Next.
14/3/2025
ಏನೋ ಸರ್ಫೇಸ್ ಡೇ ಅಂತ ಇಟ್ಕೊಂಡ್ಬಿಡ್ಬೇಕು. ಡೈಲಿ ಟೈಮ್ ತಗೊಂಡ್ಬಿಡ್ರಿ ಪೂರ್ತಿ. ಫ್ರೈಡೆ ಸರ್ಫೇಸ್ ಡೇ ಅವತ್ತೇ ಎಲ್ಲ. ಏನಿದೆ ಇದರಲ್ಲಿ?
ರೀಡೆಲಿವರಿ ಆಫ್ ಕ್ವಶನ್ಸ್ 14/3/2025 ಗೆ ಆರ್ಡರ್ ಮಾಡಿದ್ರ ಸ್ವಾಮಿ.
ಏನಂತ?
ಸೇಮ್ ಡೇ ನಾನು 10 lakhs ಕಟ್ಬೇಕು ಅಂತ.
ಹಾ.
ಐ ಹ್ಯಾವ್ ಕಂಪ್ಲೈಡ್ ಡೆಪಾಸಿಟ್
ಮಾಡಿದಾರಾ?
ನಿನ್ನೆ ಅವ್ರು ವೆರಿಫೈ ಮಾಡ್ಬಿಟ್ಟು ಹೇಳ್ತೇನೆ ಅಂತ ಹೇಳಿದ್ರು ಮೇಡಮ್.
ಸೊ ಪೊಸಿಷನ್
Possession if they are
ಎಷ್ಟಿದೆ?
47 lakhs ಇದೆ.
ಮತ್ತೆ ಡೈರೆಕ್ಟ್ ಮಾಡೋಣ, ನೀವು ಪೊಸಿಷನ್ ಕೊಡಿ.
At least they let them pay 50% of the amount.
ವಿಚ್ ಅಮೌಂಟ್?
Total outstanding.
ಔಟ್ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಓಡಿಯೋ ಅಮೌಂಟ್ ಏನಿದೆ ಅಂತ ಅವ್ರು ಹೇಳಿದ್ರೆ ರೆಗ್ಯುಲರೈಸ್ ಆಗೋಗುತ್ತೆ ಸ್ವಾಮಿ. 31st March ಒಳಗಡೆ ಅವ್ರಿಗೆ ಒಂದು ಅಕೌಂಟ್ NP ಇಂದ ಔಟ್ ಬರುತ್ತೆ. ಅಂಡ್ ಒಂದು
They said
ಜನವರಿಯಿಂದ
proceedings
ಹೊರಗಡೆ ಇದೆ
pending.
ಸ್ವಾಮಿ. 2 ಹೆಣ್ಮಕ್ಳಿದ್ದಾರೆ, ಬೇರೆಯವ್ರ ಮನೇಲಿ ಎಷ್ಟು ದಿನ ಅಂತ ನಿಲ್ಲಿಕ್ಕಾಗುತ್ತೆ?
ಕರೆಕ್ಟ್.
DRT proceedings is pending, my lord. ಅದನ್ನು
DRT
focus
ಏನೋ
ಮಾಡಿ
ಆರ್ಡರ್ ಆಗ್ತಾ ಇಲ್ಲ ಅಂತ ಇಲ್ಲಿ ಬಂದಿದೆ ಸ್ವಾಮಿ.
Yes.
ಚಾಲೆಂಜ್ ಮಾಡಿದ ಅಲ್ಲಿ DRT ಇದೆ ನಾನು.
So it is
ಅಲ್ಲಿ ಏನೋ
pending
ಆರ್ಡರ್
for
ಮಾಡ್ತಾ
their
ಇಲ್ಲ ಅಂತ
order.
ಸ್ವಾಮಿ. ರೆಗ್ಯುಲರೈಸೇಷನ್ ಬಂದಿದೆ
Any conditional order may be
10 ಲಕ್ಷ ಕಟ್ಟಿದ್ದೇನೆ. 43ರಲ್ಲಿ 10 ಲಕ್ಷ ಇಸ್ 25% ಸ್ವಾಮಿ.
any conditional order may be passed.
5 more lakhs.
ಪ್ಲೀಸ್
ಡೆಲಿವರಿ ಆಫ್ ಪೊಸಿಷನ್.
Please.
ಅದರ ಡೆಲಿವರಿ ಅಂತ ಇದ್ದಾರೆ ಅದಕ್ಕೆ. ಎಸ್. ನೀವು ಯಾರಿಗೆ ಮೇಡಮ್?
She is my.
Oh, both of you, yes. The petitioner will dispose it.
Please.
The petitioner is before this court seeking a direction to the respondent bank to reconsider the representation of the petitioners for regularization of their loan. The amount in due according to the respondent bank is 47 lakhs, out of which 10 lakhs is paid pursuant to the order passed by this court on
14/3.
14/3/2024. The issue now is redelivery of possession of the property to the petitioner. The learned counsel for the bank submits that if some more amount is directed to be paid, it would reach the stage of regularization of the account. In that light, I deem it appropriate to direct the petitioners to pay another 5 lakhs.
In
And-
one week.
ಅಲ್ಲ, anytime.
ಇವತ್ತು ಅವ್ರ
ನಿಮಿಷ.
ಪೊಸಿಷನ್ ಕೊಡ್ಲಿ 10 ಲಕ್ಷ ಕಟ್ಟಿದ್ದೇನೆ ಸ್ವಾಮಿ.
ಆಮೇಲೆ ನೀವು
ಆಯ್ತು.
ಕಟ್ಟೋದೇ ಇಲ್ಲ.
ಅಲ್ಲಲ್ಲ, ಒಂದ್ ವಾರದಲ್ಲಿ 5 ಲಕ್ಷ ಕಟ್ತೇನೆ ಸ್ವಾಮಿ. ತುಂಬಾ
ಆಮ್-
ಕಷ್ಟದಲ್ಲಿದ್ದೇನೆ. 10 ಲಕ್ಷನ ಎಲ್ಲ ಪ್ರಾಪರ್ಟಿ ಎಲ್ಲ ಅವ್ರಿಗೆ ಕೊಟ್ಬಿಟ್ಟು ನಮ್ಮ ಹತ್ರ ಏನ್ ಉಳಿತದೆ ಸ್ವಾಮಿ? ಬೇರೆ ಕಡೆಯಿಂದ
Keep on
ತರ್ಬೇಕು.
dragging.
ಮತ್ತೆ ಪೊಸಿಷನ್ ತಗೊಳಕ್ಕಾಗಲ್ಲ.
ಇಲ್ಲ, ನಾವು
Yes.
ಅಂಡರ್ಟೇಕ್ ಮಾಡ್ತೀವಿ ಸ್ವಾಮಿ ಬೇಕಾದ್ರೆ.
The learned counsel for the petition at this juncture would undertake that 5 lakhs would be paid in the next 1 week, i.e. on or before 1 week. ಇವತ್ತೇನ್ date? 19th. 18th.
18.
On or before the 25th of March 2025. The possession of the property shall be restored subject to the aforesaid condition. In the event the petitioner would breach the undertaking now given to this court of deposit of 5 more lakhs, the bank is at liberty to take action in accordance with law,
Great.
for which purpose the subject order shall be construed to be an order under section 14 of the Surface Act. With the aforesaid observation, petition stands disposed. Next.
Respondent bank, my lord.
Lord, this is the matter where 3.25 crores is the outstanding due for which they want to bring a property, of which the guideline value is 38 crores, the market value is 78 crores. They want to sell it at 23 crores for their landlord. They are the tenant in respect of one of the premises held by him. But nonetheless, my lords, I am tendering a demand draft of 4 crores. Let them account for it. Whatever is the
difficulty is
interest payable, my lords, even to that auction purchaser, let them pay and then pay back the
ಈಗ
remaining.
ಆಕ್ಷನ್ ಆಗೋಗಿದೆಯಾ?
Sale has already been confirmed, my lord, and.
Only
bidder-
25% is paid.
Bidders paid 25%. And third party rights has already been created.
Hmm.
He has not been made as a party, my lord.
You will make him.
We'll make them as party.
ಈ 4 ಕೋಟಿ ಬೇಡವಾ?
But auction purchaser needs to be consented.
ಅವ್ರ ಹತ್ರನೇ ತಗೋಬೇಕು ಅಂತಿದ್ಯಾ?
Like he's
borrower
already
ಹತ್ರ ತಗೊಳ್ಳಿ.
paid, he also needs to be compensated, my lord. He,
That we'll see later. Yes. The petitioner heard the learned senior counsel, D.R. Ravi Shankar, appearing for the petitioner. The petitioner is before this court calling in question an auction that has taken place on ಯಾವತ್ತು?
on
On 11/12/2024. The learned senior counsel submits the valuation of the property. ಎಷ್ಟು?
Lords, valuation of the property, guideline value is 38 crores.
The guideline value of the property is 38 crores.
And the market value is, distress market value is 70 crores.
And the distressed market value of the property is at 70 crores. And the property is now sold at
23.5 crores.
23.5 crores to the landlord in which the bank is a tenant. The learned counsel submits that the valuation reports are appended to the petition, which would clearly demonstrate
there is no tenancy relationship, my lord.
our submission ಹೇಳ್ತಾ ಇದೆ. So and so. The learned senior counsel submits that the valuation report is also appended to the petition. The learned counsel for the respondent would seriously dispute any tenancy between the auction purchaser and the bank. Be that as it may, in the light of the aforesaid circumstance of the property being grossly ಎಷ್ಟನೇ ಸೇಲ್ ಇದು?
Fourth sale.
Grossly undersold as in terms of the figures quoted here and above, I deem it appropriate to, ಈಗೇನ್ ಬೇಕು ಸೇಲ್ ಪೊಸಿಷನ್ ಕೊಟ್ಟಿದಾರಾ? I deem it appropriate to stall all further proceedings pursuant to the auction, subject to the condition that the petitioner would pay 4 crores by way of demand draft. The 4 crores ಅಂತ ಹೇಳಿ. The learned senior counsel submits that a demand draft of rupees 4 crores is, strike out that. The learned senior counsel at this juncture submits that they're ready and willing to pay 4 crores by way of demand draft to the
Giving the details of the.
to the bank. The demand draft is handed over and is accepted by the bank. Since the auction purchaser has paid 25% of the amount, the petitioner shall at a later date pay solatium also to the amount that is paid to the petitioner, to the auction purchaser. With all the aforesaid, in the light of the aforesaid, further proceedings shall remain stayed.
Not addressed to the bank, my lord, it's addressed to the petitioner.
Petitioner,
Lords, I'll get it deposited within 2 days.
In
Lords, it may
favor
say within
of the properties, my lord, not.
It is in favor of the petitioner only. 4 crores DD is in favor of the petitioner.
why petitioner?
I'll get it deposited, Lords, within 2 days. I'll encash
ಎಲ್ಲಿ
it
ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀರಾ?
to the bank.
The learned counsel,
The loan account we will deposit.
the learned senior counsel submits.
This demand draft, I mean.
Learned senior, the counsel for the respondent on perusal of the demand draft submits that it is not in the name of the bank, but name of the petitioner.
Lords, this can be deposited by them in their loan account.
Therefore, the petitioner shall deposit the same into the loan account of the bank before the end of today.
Lords, the bank itself
ನೀವು
can
ಮಾಡಿ
encash it
ಅದನ್ನ.
in their loan, in the loan account.
The deposit in the account of the petitioner today, the bank is at liberty to encash it towards the outstanding loan dues
Please,
forth immediately.
Auction purchaser also needs to be included.
in the meantime.
Complete ಮಾಡಿ.
Lords,
Yes, next.
so Lords is my fixed date so that the matter could be closed this, because the entire dues is already paid, my Lords, as things stand.
What introduce?
Lords, 3.25 crores is the only entire amount.
All right, we'll see. Yes. List on 8th
Lords,
April.
My application got rejected,
Fine.
stating, my lord, 1 day delay. My lord, kindly come to page number 125, annexure C.
Natasha? ನೀವು petitioner ಈಗ? How come?
My lord, kindly come to, my lord, page number 133.
Yeah, what's the problem?
My lord, I filed an application before the DRT on, my lord,
You're the borrower.
I'm a tenant, registered tenant. It is not in dispute, my lord. I'm in a tenant, my lord, much before, my lord, the loan taken place. That's all the matter before the pending for the DRT.
Dispose.
Disposed, that's all.
Dispose, my lord.
My lord, I filed an application before the DRT on 13/2/2024 against the, my lord, the 13/4 notice on 2/1/2024 within, my lord, 43rd day.
ಎಷ್ಟಿದೆ ಡ್ಯೂ?
Due, my lord, I am not aware.
40.
ನಾಟ್ ಅವೇರ್.
Madam,
ಎಷ್ಟಿದೆ?
42 crore 50 lakhs, my lord. The OA has been filed.
My lord, kindly come to the reason.
ಈಗ ಏನ್ ರೀಸನ್ ಇರ್ಲಿ ಏನ್
My
ಹೇಳಿ?
lord, remand the matter for the DRT. That, my lord, because 43rd day, my lord, what under section 17 says, my lord, within 45 days, my lord, agreed by any measures taken by the secretary, I have to challenge. 43rd day, my lord, I approach the DRT.
ಡಿಲೇ ಮೇಲೆ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ.
One dina, my lord, kindly come to page number 36. Adu not even, that delay is not at all there. Lord, page number 135, my lord, page number 11 of the order. In the above facts and circumstances of the said case, in view of the discussion above, the delay of 1 day in presenting essay number 18 of 2024 cannot be condoned. My lord, I'll just point out, my lord, I filed an essay. It is not in dispute, my lord. Sale notice published on, my lord, 2/1/2024 annexure A. I filed a essay on, my lord, 13/2/2024. My lord, 43rd day. I have a right to, my lord, go before the DRT within 45 days.
43rd ಡೇಗೆ ಹೋಗಿದ್ದೀರಾ?
ಹೌದು, 43 ದಿನಕ್ಕೆ ಹೋಗಿದ್ದೀನಿ, 2 ದಿನ in advance. Similar circumstances, my lord, this honorable court, my
ಅದು
lord,
ಪರವಾಗಿಲ್ಲ. ಎಸ್.
remanded the matter.
Then we'll send it back.
Lord, page 129 para 10, my lord.
DRT da.
DRT order, if you
ಹಾ.
order.
ಕರೆಕ್ಟ್ ಆಗಿ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿದೆ, 50 ಪೇಜ್ ಬರ್ಕೊಂಡಿದ್ದಾರೆ. ಎಸ್.
Fourth line, the right to file an application before debt recovery tribunal accrues only when the measures or an action under section 13 subclause 4 of the act is taken by the secretary
ಆಯ್ತು.
or his authorized officer. The word
All right.
taken is the past principle of the word take, of which had already
ಅದೆಲ್ಲ
happened.
ಇರ್ಲಿ, ಕಮ್ ಟು ದ ಕಂಟೆಂಟ್. ಎಸ್. ಡೇಟ್ಸ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ.
Dates ಕೆಳಗಡೆ ಹೇಳಿದ್ದಾರೆ.
ವರ್ಡ್ ಟೇಕನ್ ಅಂದ್ರೆ ಏನು, ಅದೇನು, ಅದೆಲ್ಲ ಅಲ್ಲ. ವರ್ಡ್ ಡೇಟ್ ಹೇಳಿ.
Date 29/12/2023, my lord.
ಅಷ್ಟೇ. ಯಾವತ್ತು 13/4 ಆಗಿದ್ದು?
13/4 on 29/12/2023.
Published on.
Published.
Published 2/1/2023.
Correct?
2/1/20. That's
2/1. When did you file the essay?
essay on 13/2/2023.
ಎಷ್ಟು ದಿನ ಆಗುತ್ತೆ?
ಅಲ್ಲಿ 2 ದಿನ ಡಿಲೇ ಬರುತ್ತೆ.
2 ದಿನ ಡಿಲೇ ಹೆಂಗ್ ಬರುತ್ತೆ?
47
45 ದಿನ ಫ್ರಮ್ 2/1. ನೀವು 29/12 ಇಂದ ಲೆಕ್ಕ ಹಾಕ್ತಾ ಇದ್ದೀರಾ?
ಹೌದು ಸರ್.
ಎಸ್. ಆಮೇಲೆ DRT ಅದೇ ಮಾಡಿದಾರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ,
ಅದೇ ಮಾಡಿ ಒಂದಿನ ಡಿಲೇ ಅಂತ ಮಾಡಿದ್ದಾರೆ.
1 ದಿನ ಡಿಲೇ ಅಂತ.
ಅದೇ ಮಾಡಿ
29/12/2023, madam. And this covered by judgment of this honorable court, my
ಕೊಡಿ
lord.
ಸರ್.
Page 8, my lord. From bottom 8th line.
Yes, sir.
It is the policy of the parliament that one who wants to have a redressal has to knock at the doors of DRT within 45 days and thereafter.
Under 17(1).
That is in respect of delay, my lord, continuation of delay. I am not saying, my lord, I am not even 1 day, my lord, delay while filing application before the DRT. It is a matter where, my lord, when there is a continuation of delay power.
ನಿಮ್ದು ಯಾವ provisions?
I also filed an application under section 17(1) only.
17(1) only
My
ಅಲ್ಲ.
lord, I am not saying, not even 1 day, my lord, I am approaching the DRT. I gone before, my lord, 45 day only. In this, my lord, the honorable division bench considered where, my lord, DRT have a power to condone the delay. Here I am not seeking any continuation of delay. Within 45 days only, my lord, I was before the DRT. 2/1, my lord, it is not in dispute, my lord, 2/1, annexure A.
ಎಷ್ಟಾಗುತ್ತೆ? 2/1 ಇಂದ 13.
43 day.
31, 29 plus 10, 39, 3, 40. 43.
43.
Both BDI, both days
So general
inclusive.
clause section 12, my lord says that, my lord, 1 day I have to exclude and
According to me, it's.
We'll send it back. ಕರೆಕ್ಟ್ ಆಗಿ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿದೆ. ನೀವ್ ಹೇಳಿದಿರ ಅಲ್ಲಿ 29/12 ಇಂದಾನೇ ಆಗ್ಬೇಕು ಅಂತ. ಅದಕ್ಕೆ ಆಗಿರೋದು. ಡೇಟ್ ಆಫ್ ಪಬ್ಲಿಕೇಶನ್ ಅಂತ ಎಲ್ಲಿದೆ?
2/1, my lord, annexure A, page number, my lord.
130.
Subsect secure credit on sounds. 2/1.
ಹೌದು. ಅಲ್ಲಿ ಮೇಲ್ಗಡೆ ಇದೆ ಸ್ವಾಮಿ ಡೇಟು.
ಇಲ್ಲ 29/12 ಏನಾಗಿದ್ದು?
29/12 is a possession notice.
Possession
Which
notice.
published on, my lord, 2/1.
It was also affixed on the conspicuous place of the property, which is alleged to be a tenant, my lord.
No problem.
On that day, he has got the notice and I had.
On
produced all
2/1.
those documents.
2/1.
29/12, my lord.
Date ಅಲ್ಲೇ ಬರ್ದಿದೆ. ಅಲ್ಲೇ
The
ಬರ್ದಿದೆ.
day itself, I had produced the documents before.
ಎಲ್ಲಿದೆ ಇದು?
My lord, kindly come to, my lord, top of this thing, the sale notice, sorry, possession notice on published on 2/1. ಎರಡು
It was
ಜನವರಿ
published on 2/1 only, my lord. It was affixed on the conspicuous place on 29/12/2024. I had produced photographs also, my lord. On that date, itself, it came to his knowledge. And
Yes.
moreover, my lord,
The-
the borrower's essay also dismissed on merits, my lord. On the very same day, on 28/2/2024.
not on that. I'm seeking my lord my position. They can sell it.
And
They
it's
can,
the collusive
Where is it?
borrower's.
The order of the DRT is on delay.
my lord, now my lord, page number my lord 135.
Vignesh, ಪೂರ್ತಿ correct ಆಗಿ ಹೇಳ್ಬೇಕು ನೀವು.
My lord, page number 125 is the my lord order. Annexure C. My lord, operative portion, my lord 135.
Correct.
Para 19. In above facts of the circumstance of the case and in view of the
It is
discussion as above, the delay of 1 day in presenting essay number
It's all
18.
right, yes.
According to my lord DRT, my lord, 29th and my lord 13th.
The petitioner is before this court calling in question an order of the DRT dated 31/1/2025 rejecting SA 89 of 2024 on the ground that it is presented beyond limitation. The petitioner heard so and so. The petitioner is the borrower. The loan becomes sticky and the bank issues a notice under section 13(2) of the act, which is replied to by the petitioner, and later issues a possession notice on 2/1/2025. The petitioner approaches the DRT calling in question the said possession notice by filing a securitization application on 13/2/2025. The DRT rejects the application on the score that it is presented by a day's delay. The learned counsel, a day's delay, that is what is called in question in the case at hand. The learned counsel appearing for the petitioner Vignesh Shetty submits that there is no delay in the case at hand. The notification, the possession notice was published on 2/1/2024, 2/1/2025, and the
2024.
2/1/24 rather, 2/1/2024, and the essay was filed on 13/2/2024. He would submit that the essay is preferred within 43 days, which is preferred on the 43rd day, which is before 45 days as mandated under the statute. The learned counsel appearing for the bank submits that the possession notice under section 13(4) was affixed on the door of the petitioner, therefore, on 29/12/2024, therefore, it becomes the date on which the cause of action would arise, and 45 days should be calculated from 29/12/2024, which the DRT has done. He would seek to place reliance upon the judgment of the division bench dated 20th February 2025, which which upturns the order passed by, but dismissal either. In which the division bench holds that the limitation prescribed under section 17(1) cannot be condoned even for a day. Therefore, narrated facts are not in dispute. The petitioner files an application under section 17 of the SURFACE Act upon the publication of the possession notice under subsection 3 of section 13 of the SURFACE. The section 17 reads as follows. In terms of 17(1), measures taken by the bank, by the secured creditor to recover the secured debts as obtaining under subsection 4 of section 13, may make an application to the DRT within 45 days from the date on which measures had been taken. The measure in the case at hand is in dispute. The learned counsel for the respondent submits it is affixed on the door, but the notice in the newspaper with regard to the possession of the petitioner's property is admittedly issued on 2/1/2024. Therefore, I deem it appropriate to take the beginning of the cause of action in the case at hand for calculation of 45 days to be from 2/1/2024, as it was the date on which it was published. The learned published. If the date of 2/1/2024 is taken as the date of publication, 45 days will have to be calculated from the said date. And if calculated, it would come to 15/2/2024. The application is preferred by the petitioner on 13/2/2024, 2 days prior to the completion of 45 days. If 45 days, taking the date as 2/1/2024. In that light, the application ought to have been answered on its merit. What the DRT would do is as follows. Page 135 and 136 mark portion. The DRT goes on to observe that there is a delay of 1 day in preferring the application by the petitioner on an erroneous calculation of dates, taking the date as 29/12/2024 and not 2/1/2024. 29/12/2024, 25 other.
29.
29/12/20? 29/12/2024 and not 2/1/2024.
23. 29/12/2023.
29/12/2023 and not 2/1/2024. Therefore, the error has led to dismissal of the petition. The error is on the face of it miscalculated by the DRT. In that light, I deem it appropriate to grant the relief that the petitioner is seeking for. The so-and-so allowed quashed, the matter is remitted back to the hands of the
Time limit may be
DRT.
fixed, my lord, for disposal.
Huh?
Your liability is yours. Time limit may be fixed for disposal.
ಆಯ್ತು, ಒಂದ್ ನಿಮಿಷ. The matter is
After
remitted
2
back
weeks,
to
my
the
lord,
hands of
date
the
may be fixed. We all will appear before
One
the
nimisha,
DRT
sir.
and will assist.
The matter is remitted back to the hands of the DRT. The DRT shall consider the issue on its merit and expeditiously dispose the matter as sought. It is open for the petitioner or the respondent to file necessary application seeking such early disposal.
Great.
The aforesaid observation petition stands disposed.
Great.
I appear for the petition in this matter, my lords. My lords, this is a tender matter. The limited prayer is to consider my representation at page 10.
Yes, government. Single bid,
Thank
I
you.
will not grant also. The petitioner is before this court seeking the following prayer. The heard so and so. The petitioner is a participant in participant pursuant to a tender notification issued on 12/8/2024. The petitioner emerges as a successful bidder, not only as a successful bidder, but the sole bidder in the pursuant to the tender notification. Work order is not issued. Therefore, the petitioner is at the doors of this court seeking a direction to consider the representation of the petitioner. The representation of the petitioner is for issuance of a work order, inter-alia. If the petitioner is the sole bidder, the tender itself could not have been taken forward or cannot be taken forward by the state. Therefore, can be no direction to the state to commit an illegality by directing consideration of a representation. It is open to the petitioner to participate in any future tender that would be and if notified by the state.
An observation may be made regarding page 28, 15F condition.
Condition number 15.
15F.
ಅದು ಮಾಡಿದಾಗ ಮಾಡಿ. When new tender comes, you do it. Yes. So the aforesaid observation petition stands disposed.
Great.
For the petitioner in this case.
For the respondent bank, my lord.
Petitioner, my lord, is the grandson of the guarantor to the borrower. Now, these are all agricultural lands. Even the impugned notice itself admits they're agricultural lands.
So
we have produced photos, my lord, to show that there is.
what is under challenge?
Annexure A, my lord.
Auction notice.
Yes, my lord.
Auction ಆಗೋಗಿದೆಯಾ?
Illa,
No, my
illa.
lord.
It's not.
When is it?
There's no date, my lord, fixed date. It's just a notice to the borrower informing about the sale.
How
There is
much?
no-
How much is the amount in due?
I think about
My
10
lord.
crores or more, but I'm the grandson of the guarantor.
So
And
you're not
I'm-
enjoying the property.
Well, these are properties, my lord, they're agricultural lands, that's why.
My
ಈಗ what was the property under mortgage?
There, six scheduled items, my lords, they were mortgaged by the guarantor, my lords. Now,
Who is
there are
the
totally
guarantor?
8 items.
Guarantor ಯಾರು?
Guarantor is my grandfather, one A.N. Singh.
Now who's in possession of the property?
I'm in possession.
Yes.
My lord.
Hmm.
During the subsistence of the mortgage, the borrower has fraudulently gifted the property to her daughter-in-law.
Hmm.
And daughter-in-law in turn has gifted the property to his son Karan. He is the petitioner. The petitioner is neither a borrower nor a guarantor nor a mortgager, my lord.
Pay ಮಾಡಿ.
I'm not, there's no notice issued to me.
Then let them take action in accordance.
Sir, the agricultural matter under section, under the recovery of debts done under the Banks Act, RDB Act, they can take action. There's an OA pending. Now, if the Securitization Act doesn't apply to me, my lords, they can't, it's without jurisdiction. That's why I've approached this honorable court.
Agriculture lands ಅಂತ.
Agricultural land, that's all. I'm only on that aspect. Under 31I, the RTC show what is being grown. There's ragi and mango being grown. I've produced photos.
Continue at 2:30. Yes.
Serial number 21 ಅಲ್ಲಿ ಟರ್ನ್ಓವರ್ ನಮ್ದು ಕ್ವಾಲಿಫೈ ಆಗಲ್ಲ ಅಂತ ಹೇಳಿ ರಾಂಗ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರು. ಈ MSME incorrection. Annual turnover may not be.
ಆಯ್ತು.
For MSME.
Accepted. Yes.
My lord, serial number 50, I am for the respondent, my lord.
Madam, whatever time you want, ask.
My lord, one submission, my lord. My lord, the date was given for today, my lord. The matter is not listed. The position notice has been issued. The date was also given on 14th, my lord. It was not listed. But kindly take it.
Pending matter ಅಲ್ವಾ?
My lord, sir, it has come before the court once for non-compliance of officer objections. I will comply.
ಆಮೇಲೆ ಬಂದೇ ಇಲ್ಲ ಒಂದ್ಸರಿನು.
Please, my lord.
ನಾಡಿದ್ದು ಕೊಡಿ, day after tomorrow.
My lord, serial number 96.
One time take case.
My lord, for one submission, I have moved at 2:30, my lord. It's listed tomorrow, my lord. So auction sale is on tomorrow, my lord.
Madam, auction sale ನಾಳೆ 2:30.
Okay.
Listed tomorrow, why? Who said tomorrow?
It's listed
Tomorrow ಅಂತ ಬರ್ದಿತ್ತು ಮಾಡಿ. ಅಲ್ಲ, auction sale ಮಧ್ಯಾಹ್ನ ಇರೋದು. ನಾಳೆ ಇರೋದು. Auction sale ನಾಳೆ ಇದೆಯಾ?
ನಾಳೆ ಇದೆ ಸುಮ್ಮನೆ ಸೇಲ್ ಮಾಡ್ತಿದ್ದಾರೆ ಅದಕ್ಕೆ.
Where is your band? Your band? You're not an advocate?
Intern is an intern.
Intern?
Submission. Election matter.
Which election matter?
Election matter.
ಎಲ್ಲಿದೆ?
ಇವತ್ತಿಗಿತ್ತು ಅದು ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ. Maybe it's taken tomorrow.
ಅದು ಮೆಮೊ ಕೊಡಿ. We'll see. Give a memo.
Madam, ನಾಡಿದ್ದೀಗ.
96.
ಮೇಡಮ್ ಇದು ಕಂಟಿನ್ಯೂಯೇಷನ್ ಅಥವಾ 2:30 ಮ್ಯಾಟರ್ ಬರುತ್ತಾ?
96 matter. 2 weeks cycle ಇದೆ. ಅದಕ್ಕೆ ಎಂಟ್ರಿ ಮಾಡ್ರಿ, ಒಂದು ಡೇಟ್ ಕೊಟ್ಬಿಡಿ, ಎಂಟ್ರಿ ಮಾಡ್ರಿ.
96.
ನಮ್ದಲ್ಲ ಮೇಡಮ್, ಇದು ನಮ್ದಲ್ಲ.
Is it audible? Yeah, okay.
Is it audible?
Therefore, Supreme Court says it should, it's a matter of evidence, you can't do anything here.
Yes, I understand.
Because mere inclusion of the names in the RTCs
That's not
will
sufficient.
not
That's
amount
not
to it
sufficient.
having a status of agricultural land.
Could I suggest this? Now, if the bank officials were to come and inspect, and if there is no dispute there.
Not in, evidence is not inspection.
No, I understand. I understand. If I have to approach the DRT, I'll have to lead evidence and so on, of course. But Manoj, now I'm prima facie able to show, based on the RTC, of course, that is not sufficient. But in addition to that, I'm able to show that there are photographs which show what crops are being grown. And in fact, also, Manoj, they themselves in the sale notice say that it is agricultural property. They don't deny it's agricultural property. It says it is agricultural property.
See, even in para 33 and 34 of the judgment, the Supreme Court says burden is on the borrower to show that it is an agricultural land.
Can I request this, Manoj? Then let them file their objections. If they're denying that it's agricultural property, then I can, but if they're admitting it's agricultural property.
My lord, they are challenging the action notice, not the sale notice, my lord. We have proceeded, the action notice is given, that's all.
Yes, Amale. Any others?
My lord, they have.
We are on another point.
My lord, they have.
Agricultural, it's agricultural land or not?
Activities is not, they are not doing the agriculture activity, my lord, as per bank knowledge.
Bank knowledge?
Yes, my lord.
How correct is your knowledge?
That's all, only to that extent. If they come forward and say, then possible.
You inspect the property and see whether it is.
My lord, moreover, their conduct is also, my lord, when
that I will consider. During the subsistence to get over the debt you have changed
I'm
hands.
not the borrower. I'm the guarantor. I'm not
Then
the
whatever.
Not the guarantor also, my
You
lord.
are first to gift admel alla villa.
Gift, my lord.
Alla gift.
In either.
Anyway, now you can't contend that yes, I will not. You have taken the property through a gift deed.
Through a gift deed, yes.
The gift comes with the debt also.
With the burdens.
With the burden of debt.
My lord, the outstanding balance is more than 17 crores, my lord.
10 odd crores. According to their own notice recently, it says 10 odd crores. Even recent notice, what is it? 10 point something.
Nothing.
No, my lord, as per the.
10.7.
Whether you are doing agricultural activity or
That's the
not.
only question.
Otherwise, it's a matter of evidence.
I'll be ousted.
You just inspect the property and
Yes, my
get
lord.
a
I'll file
report.
the objection.
Heard the learned senior counsel Vikram Holigold appearing for the petitioner. The subject property coming within the purview of the SURFACI Act 2002 or otherwise. The learned senior counsel relies upon a judgment of the apex court in the case of K. Sridhar versus so-and-so, 2023 11 SEC page 169, with particular reference to paragraph 33 and 34 of the said judgment. The apex court holds that the plea of the land being agriculture and it being beyond the purview of the act is a matter of evidence. The sale on that score cannot be set aside by a writ court. Therefore, I deem it appropriate to direct the respondent bank to cause an inspection upon the land of the petitioner to and draw a report whether they are doing agricultural activities in the land or otherwise. The learned counsel, the submission of the learned counsel for the respondent that that during the subsistence of the mortgage, the borrower, the guarantor has deliberately changed hands of the property. The submission is also taken note of to be decided on the next date. Just in a way.
15 days, my lord.
List the matter on 4th April in the fresh matters list. Report be placed by then.
Grateful.
Yavat sale idea?
Not yet.
Please.
GM KEB.
That's 3 loans I take, 550 lakhs each for establishment of a solar rooftop.
550 lakhs or 5,50,000?
No.
5 crore 50 lakhs.
5 crores 50 lakhs twice on the same day, and another loan for a poultry business. Well, at that point of time when I availed the loan, an agreement with the BESCOM was there that they would purchase the 1 unit at 9 rupees 57 paisa. But there was some delay. So for the delay, I said 2,000 rupees I paid. They enhanced, gave the time for extension of time by another 6 months. Thereafter, I established. BESCOM insisted that I must enter into a fresh agreement. It was 5 rupees 97 paisa. Subsequently, they have reduced it to 3 rupees 97 paisa per unit.
Was the bank concerned with all your problems with
that's
BESCOM?
what I'm saying. No, my lord, the bank instead of lowering the interest rate, they increased it by another 2%, saying that you are in default. My lord, there was no intentional default in so far as I am concerned.
Yesterday,
ಈಗ
ಟೋಟಲ್ ಹೇಳ್ಬೇಡಿ ವಿಘ್ನೇಶ್, ಡ್ಯೂ ಎಷ್ಟಿದೆ ಹೇಳಿ.
7 crores ಇದೆ sir.
ಎಂಟೈರ್ ಲೋನ್ ಅಲ್ಲ, ಡ್ಯೂ ಎಷ್ಟಿದೆ?
Under the OTS scheme, it is 7 crores.
1 minute, OTS ಬೇರೆ ಕೊಟ್ಟಿದ್ರೆ.
ಕೊಟ್ಟಿದ್ದಾರೆ. That has now been cancelled.
Of course, if you don't comply, cancel it.
No. I wrote to them, your lordship may kindly turn to page 82.
ಈಗ what are you challenging, sir?
The cancellation of OTS.
My lord, prayer 2 and 3, not against me, my lord, against my lord, respond number 2 and 3.
That is B and C.
B and
Yes.
C.
KERC.
ಹೌದು.
ಆಮೇಲೆ
Cancellation of the OTS scheme.
ಅಷ್ಟೇ ಇವ್ರ ಮೇಲೆ.
85, yes.
Yes,
They will
sir.
reschedule with recalculated interest. I am ready to pay the. No, that.
When was the notice offered to you? When was it cancelled?
My lord, it was there on 29/2024.
When was it offered, Vignesh?
Lord, I have to take instruction in this matter, my lord. In fact, this.
Papers ಇಲ್ವಾ?
ಇಲ್ಲ,
ಕೊಟ್ಟಿದ್ದೀನಿ.
in fact,
ಹಾ.
ಕೊಟ್ಟಿದ್ದಾರೆ.
When was it offered? Tell me.
My lord, it was cancelled on 24/2/2020.
Offered ಯಾವತ್ತು ಅಂದ್ರೆ cancelled ಹೇಳ್ತಾರೆ.
I didn't get your lordship.
When was it offered to you? By what communication?
Communication, your lordship may kindly turn to page 85.
Date ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
20th September 2024.
24.
Yes.
By what time were you to comply with it?
My lord, I was given about 2 years time to do it.
OTS 2 years ಕೊಟ್ಟಿದ್ದಾರೆ.
Yes. Because it was 10 crores.
ಅಂತದ್ದು
12
ಯಾವ್ದು
crores it is.
Page, where is it?
85.
85 million. Except 12.75.
ಒಂದ್ ನಿಮಿಷ. Accept 12.7 settlement.
Full and settlement payable as follows.
Crore paid on or before so and so.
And I paid 5 crores I have paid already.
1 minute. First installment,
Yes.
1.5 crores within 20 days.
2 crores to be paid.
Second
upfront.
installment, 45 days after sanction convey. Third
Second
installment,
of
3
2 crores in
crores.
45 days.
Fourth
3 crores from
installment,
70
20
days.
days. ಈಗ ಯಾವ್ದು ಬ್ರೀಚ್ ಮಾಡಿದ್ದಾರೆ?
My lord, I'll take it. My lord, have
5
it tomorrow.
crores. I have given 5 crores now. 5 crores, 40 lakhs I have paid.
My lord, in fact, kindly come to my lord, page number 94.
Where is the cancellation order?
Your lordship may turn to page 88.
88.
Third installment will be paid in 70 days of conveying.
OT was sanctioned to the subject of the foreign border, etc., etc.
Notice as per se.
I requested them to release one property, commercial property, which is mentioned as second property. Lordship may kindly turn to page 86. I said, please release this property. I am going to pay another 2 crores. They have not done.
Was that the condition in OTS?
Lordship may kindly turn.
Was that the condition while offering the
They did
OTS?
not agree at the first instance. I requested by my letter requesting
I'm
them.
asking you, at the time of grant of OTS,
Yes.
did you say that it would be subject to the release of some
No,
property?
I didn't say.
Then
Because
leave
they don't accept anything what I say. I have to accept what they say, man.
Correct, sir, you are the borrower. Yes.
But no fault of mine.
No fault illa. Third installment, fourth installment, you have not paid.
ಕೊಟ್ಟಿಲ್ಲ.
ಕೊಟ್ಟಿಲ್ಲ.
No, your lordship may kindly turn to page.
ಕೊಟ್ಟಿಲ್ಲ.
ಕೊಟ್ಟಿಲ್ಲ. Page 86 for
ಯಾವಾಗ ಕೊಟ್ರಿ?
86 ನೋಡ್ಬೋದು.
ನಾನು 89 ಅಲ್ಲಿ ಇದ್ದೀನಿ.
ಅಲ್ಲಿ 86
Third
also.
installment 3 crores, fourth installment 4.2 crores.
ಈಗ 3 to 4 lakhs ಜನರೇಟ್ ಆಗುತ್ತೆ ಇದ್ರೊಳಗೆ.
ನೀವು
Power
ಏನ್
generation.
ಮಾಡ್ತೀರಾ ಅದು ಗೊತ್ತಿಲ್ಲ.
Power generation.
I am not on that.
No, if it is.
Why did you agree for a OTS of that kind and you have breached that OTS? There is no doubt about it.
My lord, I made a further request.
You may have 100 problems, but
Not that, my lord, one mortgage property be released so that I will pay another 2 crores.
where is that sub condition here?
It's not there. I am requesting.
Then on,
I requested them.
I
also.
will not enter into all this.
No, kindly turn to page. For a moment.
See,
kindly-
you have problems with the KERC. You have problems with BESCOM. And you have problems with they are not releasing the property.
Well,
That is
there-
not the condition in OTS at all.
No, there is a promissory estoppel by.
Yeah, by whom, sir?
By BESCOM.
Charge against BESCOM.
No, therefore they have made him the party also.
No problem.
Kindly turn to page.
You secure instructions. We'll have it after 2
No,
weeks.
my lord, kindly turn to page 84 for a moment. 84, my lord.
Yes, sir.
Third paragraph. We request you to recalculate the amounts payable as with interest reduce the trade. Deduct 17 crores 40 lakhs which we have paid so far. 17
That is
crores
up to you, sir. That is pre-OTS, sir.
Yes, in
ನೀವು
all.
OTS ಅಲ್ಲಿ ಏನ್ ಕಂಡೀಷನ್ ಒಪ್ಕೊಂಡ್ರಿ ಅದು ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ it goes out. It's as simple as that.
Let it be status quo so far the
No,
properties,
sir,
property is concerned.
nothing. You secure instructions and come. ಈಗೇನ್ ಸೇಲ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
Till then, sale notice ಕೊಟ್ಟಿದ್ದಾರೆ.
My lord, 94, my lord, sale notice. The sale date, my lord, is already spent itself, my lord.
94.
94.
94.
ಇನ್ನೊಂದು ಸೇಲ್ ನೋಟಿಸ್ ಕೊಟ್ರೆ ಮೂವ್ ಮಾಡಿ. Yes.
Right.
The learned counsel Vignesh Shetty to secure instructions and make submissions. On the
My lord,
next
notice to others, my lord.
emergent notice to the other respondents returnable by.
They have taken, I have served Descom and
R4 I take notice.
ಯಾರಿಗೆ ಸರ್ವ್ ಮಾಡಿದ್ದೀರಾ?
3, 4, 5, ಇಲ್ಲಿ ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ಗೆ ಸೆಂಟ್ರಲ್ ಗೌರ್ಮೆಂಟ್ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ಗೆ ಮಾಡಿ
R4 is the government, state government.
KRC.
KERC ಅವ್ರಿಗೆ ಮಾಡಿಲ್ಲ.
ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ಗ?
ಹೌದು ಸರ್.
ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ KRC ಸಪರೇಟ್ ಇದ್ದಾರೆ.
ಆಯ್ತು ಅಲ್ಲಿ ಸರಿ.
ಬೆಸ್ಕಾಮ್ಗೂ ಸಪರೇಟ್ ಇದ್ದಾರೆ. ಎಲ್ಲ ಗವರ್ಮೆಂಟ್ ಕೊಟ್ಬಿಟ್ರೆ ಆಗಲ್ಲ.
ಎಕ್ಸೆಪ್ಟ್ KERC.
KRC ಯಾರು ಮೇಡಮ್? ಪ್ರಕಾಶ್ ಅಲ್ಲ, ಯಾರೋ ಅಪೇರ್ ಆಗ್ತಾರಲ್ಲ. Viresh Budihal is directed to accept notice for the second respondent. Petitioner to serve set of papers upon the aforesaid council. List on 8th April. Next.
Obey.
37.
The petitioner in this case, my lordship, it's for parole.
Parole cannot be granted here because he's not completed 2 years. It's only 1 year and 1 month.
List after 4 weeks.
And there's one more connected
Make one
matter also.
submission, my lord. Make one submission. My lord, he has undergone angioplasty, my lord.
Where?
My lord, before going.
Parole ಬರಲ್ವಲ್ಲಪ್ಪ.
Now he's suffering from various heart issues, my lord.
Emergency parole apply ಮಾಡಿ.
Emergency madly, he's 70 years old.
Emergency parole apply ಮಾಡಿ will consider.
They're not regular parole.
ಯಾವ್ದು parole ಮಾಡ್ಬೇಕು ಅಂತ ಗೊತ್ತಿಲ್ವಾ?
Considered, my lord.
ಎಲ್ಲಿ ಅವ್ರ ಪೇಟೆಂಟ್ ಅವ್ರು ಕೇಳಿ. ಸಿರಾಜುದ್ದೀನ್ ಕೇಳಿ ಹೇಳ್ತಾರೆ. Yes.
Presentation has been given for.
Lordship,
general
serial
parole.
number 78 is also pertaining, that's the wife has filed it on behalf of the convict.
ಎರಡು
petition ಇದೆ.
ಎರಡರಲ್ಲೂ ಇದು ವಿಡ್ರಾ ಮಾಡಿ ಎಮರ್ಜೆನ್ಸಿ ಪರೋಲ್ ಹಾಕಿ. ಫೈಲ್ ಫ್ರೆಶ್ ಪೆಟಿಷನ್ಸ್. ಯಾವುದು 30?
That is 78, your lordship, 78 and 37.
The learned HCGP on verification of the records would submit that the convict has spent only 1 year and 1 month in prison, and for release on general parole, minimum of 2 years is what 2 years of imprisonment is what is required. The learned counsel at this juncture would submit that he would at this juncture would seek to withdraw the petition and file a fresh petition seeking emergency parole. ಎರಡು ಮಾಡಿ emergency parole ಆದ್ರೆ ಕೊಡೋಣ. Yes. 78 also.
78 also.
ಬೇರೆ ಅಡ್ವೊಕೇಟ್ ಇದ್ದಾರಾ? ಇರ್ಲಿ ನೋಡಿ ಮಾಡಿರಿ ಬರ್ಲಿ ಹೇಳಿ. Next.
38.
Petition, my lords. The loan borrowed was 70 lakhs, my lords.
Due est.
I'm
Outstanding
outstanding
115
is 1 crore 18 lakhs, what they say according to
Ah.
their own statement, my lords.
Yes.
I'm ready to pay the amount only before your lordship is, I need some more time. I'm ready to
Some
pay
more
the-
time.
Yeah, please, my lords.
How much time I have granted?
14 order ಅದನ್ನ ತಗೊಳ್ಳಿಕ್ಕೆ.
ಮೊನ್ನೆ ಬಂದಿತ್ತು, not to precipitate.
But they have requested, not, that is the reason we have waited and. so now-
Waited.
Lord,
ಆಯ್ತು.
we have considered their request, Lord. Now 14 order has been passed and it is going to be expired today.
No worries. We'll state only on condition, payment condition.
Please, my lord.
But 50%.
ಅಷ್ಟೊಂದೆಲ್ಲ ಕಟ್ಟಾಗಿದ್ರೆ ಅವ್ರ ಬ್ಯಾಂಕ್ ಇಲ್ಲಿ ಬರ್ತಾನೆ ಇರ್ಲಿಲ್ಲ.
After the order, I've paid around 12 lakhs, my lords, after the surface order.
But after deducting that also, now as on today, 115 is the, 1 crore 15 lakhs is the due. Please.
ಆಯ್ತು, ಎಷ್ಟು ಪೇ ಮಾಡ್ತೀರಾ? 15 lakhs.
Please, my lords.
3 weeks.
4 weeks, my lords. Please, my
Lord, on or before 31st, Lord.
ಅದೆಲ್ಲ
let
ಆಗಲ್ಲ.
me-
ನೀವು ಎಂಡ್ ಆಫ್ ದಿ ಫೈನಾನ್ಷಿಯಲ್ ಇಯರ್ ಕೇಳಿದ್ರೆ ಏನೂ ಆಗಲ್ಲ.
At least first installment, Lord, let them.
ಫಸ್ಟ್ ಇನ್ಸ್ಟಾಲ್ಮೆಂಟ್ 3 weeks, 15 lakhs. Same condition, madam, in the event of non-payment. Yes.
Grateful.
Next.
The date may kindly be.
I am for,
ಅದು ಬರುತ್ತೆ ಡೇಟ್. 3 weeks ಆದ್ಮೇಲೆ ಒಂದು ಡೇಟ್ ಕೊಡಿ.
Grateful.
I am for petitioners, my lord, as per section 19 of the Pharmacy Act, my lord. The first respondent, the government has power to nominate to the council, my lord, members. But here the second respondent, my lord, who is not competent authority, the commissioner, who has issued a publication for nomination.
Where is the
Washing of the paper publication.
act ಅಲ್ಲಿ?
Act, my lord, section 19, my lord, Pharmacy Act.
ಹಾ ಸರಿ,
Pharmacy.
ಎಲ್ಲಿದೆ?
The
ಏನಿದೆ ಅದರಲ್ಲಿ?
government has power to nominate.
ಪವರ್ ಟು
Here-
ನಾಮಿನೇಟ್.
Here the second respondent, my lord,
ಈಗ ನಾಮಿನೇಟ್ ಮಾಡ್ಬಿಟ್ಟಿದಾರ ಈಗ?
ಅಪ್ಲಿಕೇಶನ್ ಕಾಲ್ ಮಾಡಿದ್ದಾರೆ.
ಅಪ್ಲಿಕೇಶನ್ ಕಾಲ್
Application.
ಮಾಡಲಿ. ಕನ್ಸಿಡರೇಷನ್ ವಿಲ್ ಬಿ ಓನ್ಲಿ ಬೈ ದಿ ಗವರ್ಮೆಂಟ್.
ಅಲ್ಲ ಇವ್ರು ಮಾಡಿರೋದು.
ಮಿನಿಸ್ಟ್ರಿಯಲ್ ಆಕ್ಟ್ ಸರ್. ಎಸ್.
ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್
And the
itself
prayer
is
is
a
to watch the paper publication, my lord.
paper publication.
Pharmacy
is issued
council
by-
has issued it now. Allah, the
Allah, issue-
commissioner food,
Commissioner issue
food
ಮಾಡಿ.
protection and
He
pharmacy.
himself is a ex officio member to this farmer council.
Is all right.
He has no jurisdiction. my lord.
For
First
what?
respondent has to.
For nomination, he has
nomination.
no jurisdiction. He is not nominated.
He just issued an ad for paper.
Allah, paper publication,
Calling
calling for
Paper
applications.
publication has to be issued by the state mail. Because state is competent to nominate, not the second respondent
ಈಗ
commissioner. Who
the
is?
person who is in the committee which is constituted to nominate only should issue application calling for applications.
And in
Notification
the,
calling for applications.
and the, as
ಎಲ್ಲಿದೆ?
per annexure B, my lord, the conditions imposed are not in accordance with section 19, my lord.
ಅದು ಹೇಳಿ. ಅದು ಬಿಟ್ಟು
19.
ಇವರು ಇಶ್ಯೂ ಮಾಡೋ ನೋಟಿಫಿಕೇಶನ್ ಸರಿ ಇಲ್ಲ ಅಂದ್ರೆ.
ಎರಡು ಇದೆ.
Who are you?
We are the present councillors, my lord. I mean members of the council. The as per the.
What is wrong with the notification?
The notification, my lord, annexure B may kindly be take, my lord. Here, the eligibility criteria, my lord, serial number 4, my lord. Shall
Pharmacist.
possess a pharmacist license
ಆಯ್ತು.
and carried out business for the
Last
past
15 years.
15 years in the state of Karnataka.
All right.
As per section 19, my lord, there is no such condition, my lord. There is no such.
19 is a format, is it?
ಅಲ್ಲ,
Putting-
Degree ಇದ್ರೆ enough ಅಂತ ಹೇಳ್ತಾರೆ. ಇವ್ರು 15 years ಸರ್ವಿಸ್ ಕೇಳ್ತಾರೆ. ಆಮೇಲೆ
Composition of the council, 6 members, 3.
nineteen B ಮೇಲೆ 5 members of
Three or
whom at
diploma in
least 3 shall
pharmacy.
be.
Nominated by the, yes, sir. Why? Why is this? Or first really, then it's absurd, leave it, yes.
As regards to the condition, my lord, that
Yes.
we will verify.
The petitioner is before this court, calling in question a notification seeking applications from eligible candidates for the purpose of appointment, for the purpose of nomination to the State Pharmacy Council. The learned council takes this court through clause 4 of the said notification, which reads as follows. The notification depicts that a person who is wanting to be nominated should have a pharmacist license and should have carried out business on such license for 15 years in the state of Karnataka. The eligibility, constitution, composition of the State Pharmacy Council is depicted under section 19. Section 19 reads as follows. Section 19 nowhere mandates that one should have 15 years of business experience of holding a pharmacist license and having business in the state of Karnataka. Therefore, the condition runs counter to the statute. The learned AGA to secure instructions on the issue, there shall be an interim order of stay as spread for. List on 4th April in the fresh matters list.
So I appear for the respondent bank.
Appearing for petitioner.
The sale was slated yesterday.
What happened?
It did not happen. Therefore, the writ is rendered infructuous. The sale notice has spent itself. Now, insofar as the other prayers that they have made in this writ petition.
All will be considered in this next sale notice.
Next sale notice alla. It is already sub judice before this court. Then I filed a memo. Kindly see.
ಇನ್ನೊಂದು ಹಾಕಿದಾರಾ?
ಇನ್ ಮೂರಿದೆ. ಒಂದಲ್ಲ.
ಯಾವ್ಯಾವ್ದೆಲ್ಲ ಕೊಡಿ.
ಎಲ್ಲಾನು ಹಾಕಿ ನೆನ್ನೆ ಮೆಮೋಸ್ ಸಮೇತ. ನೆನ್ನೆ ಫೈಲ್ ಮಾಡ್ರು ಮೆಮೋ. Kindly turn to ink page 8 of my.
ಈಗ ಇದ್ರಲ್ಲೇನ್ ಸೇಲ್ ಆಗಿಲ್ವಲ್ಲ?
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಸೇಲ್ ಆಗಿಲ್ಲ.
ಆ ಮೂರು ಕೊಡಿ, ಮೂರು ಸೇರಿಸಿ will pass an order.
Please.
Tag this petition along with
All three writ petitions are there. in that
listed
memo.
today.
ನೆನ್ನೆ ಫೈಲ್ ಮಾಡ್ರು ಮೆಮೋಲ್ ಇದೆ.
Memo ಇದೆ. ಇವತ್ತು ಲಿಸ್ಟ್ ಆಗಿಲ್ಲಲ್ಲ?
List ಆಗಿಲ್ಲ.
List them all on Monday in the fresh matters.
Lordship, can I make one submission?
On Monday.
All writ petition is for the different cause of action.
I will see.
And,
Yes. We'll see. Yes, madam.
I got the
Monday,
instruction from.
madam. Monday. Yes. ಈಗೇನ್ ಸೇಲ್ ಆಗಿಲ್ಲಲ್ಲ ಬಿಡಿ Monday.
Sale ಆಗಿದೆ.
Next. First,
Lords,
Possession notice and section 14 order.
six
Yes, Lokesh.
6 crores, my lords.
ಏನ್ ಪೊಸಿಷನ್
use.
ನೋಟಿಸಾ?
section.
Yes, my lord, position notice.
6 crores ಇದೆಯಾ?
10%
Yes,
within
madam.
4 weeks, another 10%.
10,
within
10.
My lord,
4, 4.
30th ಒಳಗಡೆ at least ಒಂದು 5% ಅದ ಕೊಡ್ಲಿ.
30th ಒಳಗೆ ಕಲೆಕ್ಷನ್ ಆಗಲ್ಲ ಬಿಡಿ ನಿಮ್ಗೆ. ಎಸ್.
4 weeks,
5%
3
30th
weeks.
ಒಳಗೆ ಕೊಡಿ. ಹೆಂಗ್
ಒಂದು
ಮಾಡಿ?
5% 30th ಒಳಗಡೆ ಕೊಡಿ.
1 minute, Lokesh. The learned counsel petitioner is before this court calling in question an order under section 14 of the SURFACE Act. The learned counsel KV Lokesh submits that the amount in due is more than 6 crores. Therefore, the petitioner shall, there shall be an interim order of stay of further proceedings, subject to the condition that the petitioner would deposit 5% of the amount on or before 30th of March, and another 5% of the amount on or before the 15th of April, and another 10% after 4 weeks, within 4 weeks after the completion of the second chunk. Any deviation, same. Next.
42.
42, I paid for the petition minutes in this matter.
ಏನಿದು? ನೆನ್ನೆದ?
Nene,
ಅವರಲ್ಲಿ ಇನ್ನೊಬ್ರು ಇನ್ನೊಂದಿತ್ತಲ್ಲ?
44.
ಹಾ. 44 ಇದ್ದೀರಾ?
There is already an order.
By whom? Stay ಆಗಿದೆಯಾ?
Civil court, no, by the civil court in their case, by this honorable court in the present petitioner. The only question which was invoked was Article 21.
Correct.
However, larger questions what lordship may have to hear it.
No, ಈಗ ಏನ್ the
meanwhile-
media house is not stopping, is
Not
media
stopping.
houses.
Government of India's intervention is sought for. Last occasion was in similar case, the court directed the government of India to communicate the orders and see that.
ಅದು ಕೊಡಿ.
We have, it's already in the file.
ಇದೆಯಾ?
Yes.
Delhi.
What is the operation?
Delhi ಕೊಡ್ತಾ?
ಯಾವ ಮಹೇಶ್ ನೀವ್ ಹಾಕಿದ್ದೀರಾ? ಪೇಜ್ ನಂಬರ್?
I given separate copies. Out page on
Number of
internal page 2. Internal page 2. Order of lordship.
ಶಾಂತಿ ಭೂಷಣ್.
Please.
Same order will pass.
Lord, there's the
ಕೊಡಿ. ಕೊಡಿ ಕೊಡಿ.
Union of India has already passed such a direction, my lord, in other cases, my lord. Madam,
This is old.
with regard to the Delhi High Court matter, my lord, the Union of India has already passed such an order directing all the media houses to stop. The first is, first. No, my lord, the first.
Oh, yes, yes.
No, no.
What it is.
We will observe everything.
Please.
That is all necessary. Dispose it or keep it?
That is all necessary, but in my petition, at least I have prayed for a certain guidelines to be framed, because the petition is matched with the lady. Ultimately, those is subject matter of, a case is pertaining subject matter of investigation. Every day being named names, when at least women are involved, certain guidelines have been passed to protect her dignity. So that is the only thing I have prayed for.
ನಿಮ್ದ್ರಲ್ಲಿ ಅಷ್ಟೇನಾ? ಬೇರೆ ಏನಿಲ್ಲ?
Stay ಇರೋದು.
The guidelines, my lord,
To keep it pending.
We'll keep it pending. That's fine.
The orders.
We'll pass these orders and keep it pending. Yes, sir. The heard the learned senior counsel appearing for the petitioner and Mahesh YL in separate writ petitions ಹಾಕ್ಬಿಡಿ madam. 44 and 46. And the learned DSGI Shanti Bhushan. Unikrishnan ಯಾರಿಗೆ?
44, R1 in 44.
For Unikrishnan in 44 and Shanti Bhushan in 46.
42.
42, oh sorry, 42 na?
42 and 44.
Sorry, 42 and 44. First to 42.
For respondent number 2, DRI.
DRI.
Madhu and Rao.
DRI party ಮಾಡಿದ್ದೀರಾ?
DRI party.
You are Madhu?
Madhu and Rao.
Yes, Madhu Rao. And Madhu and Rao representing the Directorate of Revenue Intelligence. The petitioner in the case at hand is the mother of one Ranya Rao, who is said to be investigated into certain allegations by the second respondent Directorate of Revenue Intelligence. She is before the court seeking a direction to lay down certain guidelines with regard to the publication by the electronic media in particular about the accused when the accused is a lady. The learned counsel Mahesh, taking this court through the documents appended to the petition, would seek to demonstrate that the civil court, tell the order,
For 88,
80,
page number 90, 90,
98,
98.
that the civil court has ordered, has passed restraint orders against the media houses, restraining them from publication of any material that would touch upon the dignity of the petitioner, as it would be in violation, as any publication of the kind would be in violation of Article 21 of the Constitution of India. Despite the said order, it is the submission of the learned counsel for the petitioner that the media houses are not encouraging restraint or not complying with the directions of the civil court. In such circumstances, the learned counsel would submit that the coordinate benches of the court have directed the Union of India to communicate that such to the media houses that they should not violate the orders passed by the concerned court in identical circumstances. The learned DSGI, Sri Shanti Bhushan, places an order on record communication. Learned new ಕೊಟ್ಟಿದ್ದ. Learned counsel Mahesh places a communication of the Government of India to all the media houses, be it print or electronic, to encourage restraint when court or courts pass certain orders. The communication reads as follows. This was in furtherance of a direction issued by the High Court of Delhi to High Court of Delhi directing the Union of India to direct the media houses by appropriate orders from publishing, printing, disseminating confidential information contained in the charge sheet therein. However, the issue in the list is with regard to investigation. Information about the investigation is not disseminated by the media house, but the learned counsel submits that the character of the accused in the DRI case is being painted in all colors. The learned counsel would therefore seek identical orders to be passed as is passed by the coordinate benches of this court. The coordinate bench in writ petition 24836 of 2024 concerning Darshanda. Concerning the accused therein has passed the following order. Quote all the orders, madam. Here. The respondent here, the respondents are all the media houses in the case at hand. In the light of the order of the civil court and also the direction of the Government of India to all media houses, print and electronic, they are required to follow and comply with the directions, required to follow and comply with the directions of the courts that have granted injunctory orders against the print and media houses. The Mathin communication, so and so. The respond, they're all respondents. Notice ಮಾಡಿದೀವಾ? Emergent notice to the respondents, to all the respondents.
3 to 30.
3 to 32, 34, 3 to 34, returnable by the 8th of April. Are the separate order ಬೇಕಾ sir? Problem sir.
Separate facts may differ slightly.
Facts would differ. I'll dictate it.
The father of the
This father of Ranya Rao, right?
Ranya.
Yes.
And the order is that of this honorable court.
Order of
Civil court.
the civil court. Idರಲ್ಲಿ ಇದೆಯಾ?
That is the only two.
ನಿಮ್ಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ?
He is a police officer. They are linked him to the investigation.
You have not gone before the civil court.
No, I had gone to civil court as well. Civil court did not grant an ex parte injunction. So we filed a miscellaneous first appeal and this honorable court granted it.
Where is that order?
That order is at page 38.
30?
8.
Heard the learned senior counsel Prabhuling Nawadgi appearing for the petitioner. The petitioner is the father of one Ranya Rao, a police officer of the state of Karnataka, in the state of Karnataka. He is at the doors of this court seeking a direction to the respondent media houses from publishing, telecasting any defamatory, unverified information. The petitioner had knocked at the doors of the civil court. The civil court refuses to grant an ex parte injunction against the media houses, which comes to be challenged before this court in MFA, page ಹೇಳಿದ್ರಲ್ಲ?
Writ petition of GMC.
GMCPC, page.
Page 38, writ petition 6922 of 2025.
In WP 6922 of 2025.
Order 10th March.
The coordinate bench grants an order of injunction, which reads as follows. The allegation is the same in the case at hand, that despite the order of injunction, the print and electronic media have not stopped publishing, not stopped telecasting, publishing, or any or letting out any information in the television channels or the print, as the case would be. The same order, as the case would be. The learned senior counsel would submit that the Union of India should be directed to communicate to all the media houses that the orders of the court should would be adhered to, and the media, print and electronic media, should encourage restraint. Continue.
Only one change. In this case, my lord, unlike mother, his name also is being drawn. Lordships dictated that only the daughter's name.
I'll correct.
Okay.
Petitioner's name and
Deeply obliged.
ಎಲ್ಲರಿಗೂ notice, madam. ಎದರಲ್ಲೂ madam, notice to all private other respondents. ನಿಮ್ದು ಎಲೆಕ್ಟ್ರಾನಿಕ್ ಮೀಡಿಯಾನಾ? ಇಲ್ಲ. ಎಷ್ಟಿದೆ? DRT ಹೋಗ್ಬಿಡಿ. ಅಲ್ಲೇ ಹಾಕಿ. ಅಲ್ಲೇ ಹಾಕಿ.
SSLC ಎಕ್ಸಾಮ್ ಇತ್ತು ಅಂತ ಹೇಳ್ಕೊಂಡು ಇವತ್ತು ಹಾಲ್ ಟಿಕೆಟ್ ನಿನ್ನೆ
ಕೊಟ್ರಾ?
ಅಲ್ಲಿ ಏನೋ ಆರ್ಡರ್ ಟೆನೆಂಟ್ಸ್ ಗಳಿಗೆಲ್ಲ ನಾವು ಆರ್ಡರ್ ಆಗುದಿಲ್ಲ.
ಆಗೋದೇ ಇಲ್ವಾ?
ನಾನು ಅಂಡರ್ಟೇಕಿಂಗ್ ಟು ವೆಕೇಟ್ 1 undertaking to vacate within 2 months.
Where is the lease deed? Lease deed subsisting lease ಇರೋದು ಎಲ್ಲಿದೆ? ಎಲ್ಲಿದೆ ಕೊಡಿ ಮೇಡಮ್. ಓರಲ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡಿಂಗ್. ನೀವೇನು ಮಾಡಬೇಡಿ. ಓರಲ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡಿಂಗ್.
25 ವರ್ಷದಿಂದ ನಾನು ಅಲ್ಲಿದ್ದೆ. ಐ ವಾಸ್ ಓನರ್.
ಎಲ್ಲಿದೆ ಲೀಸ್ ಡೀಡ್ ಕೊಡಿ ಮೇಡಮ್.
ಇವ್ರಿಗಿಂತ ಯಾರು ಬಾರೋರ್ ಇದಲ್ಲ ಅವ್ರಿಗಿಂತ ಮುಂಚಿನವರು ನನಗೆ ಕನ್ಸೆಂಟ್ ಮಾಡಿದ್ರು.
ಎಲ್ಲ ಓರಲ್ ಸಬ್ಮಿಷನ್ ಇದ್ರೆ ಓರಲ್ ಆರ್ಡರ್.
ವೆಕೇಟಿಂಗ್ ವಿದಿನ್ 2 months ಮಿಲಾಡ್. ನಾನು ಆಧಾರ್ ಕಾರ್ಡ್
show me the lease deed, otherwise go before the DRT.
I'm already before the DRT ಮಿಲಾಡ್. DRT ಅಲ್ಲಿ ನಮಗೆ ರೀಡೆಲಿವರಿ ಸಿಗ್ತಾ ಇಲ್ಲ ಅಂತ.
ಕರೆಕ್ಟ್. ಈ ತರ ನೀವು ಗಾಳಿಲಿ ಹೇಳಿದ್ರೆ ಏನು ಸಿಗಲ್ಲ. ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಡ್ಬೇಕು. ಎಲ್ಲಿದೆ? ಆಧಾರ್ ಕಾರ್ಡ್ ಇಸ್ ನಾಟ್ ಲೀಸ್ ಡೀಡ್.
ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಮಿಲಾಡ್. ಅಡ್ರೆಸ್ ಎಲ್ಲ ಸೇಮ್ ಸೋನ್. I've been in the position, my lord. I was disposed on 8th, my lord. 8th of March.
ಈಗ ಸ್ಟೇ ಇದೆಯಾ? ಇಲ್ಲ ಅಲ್ಲ. DRT ನಾಳೆ ಇದೆಯಲ್ಲ ಮ್ಯಾಟರ್.
My lord.
ಈಗ ಹಾಲ್ ಟಿಕೆಟ್ ತಗೊಂಡಿದ್ದೀರಲ್ಲ?
That itself proves, my lord.
ಏನಂತ?
ಮನೆಯಲ್ಲಿ ಇರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಹಾಲ್ ಟಿಕೆಟ್ ಯಾಕೆ?
ಈ ಸಬ್ಸಿಸ್ಟಿಂಗ್ ಇದೆಯಾ ಇಲ್ವಾ ಅಂತ ಅದಕ್ಕೆ ಹೇಳ್ಬೇಕಲ್ಲ.
I will vacate within 2 months. ಬೇರೆ ಅರೇಂಜ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡು ನನ್ನ ಐಟಮ್ ನಾನು 20
ಮೇಡಮ್ ಆ ತರ ಆರ್ಡರ್ ಕೊಡಕ್ಕೆ ಐ ಶುಡ್ ನೋ ದಟ್ ಯು ಆರ್ LSC ದೇರ್. ಅಲ್ಲಿ ಹಾಲ್ ಟಿಕೆಟ್ ಇತ್ತು ಅಂತ ತಕ್ಷಣ ಸರ್ಕಮ್ಸ್ಟಾನ್ಸ್ ದಟ್ ಯು ಆರ್ LSC. ಅದಕ್ಕೆ ಎಲ್ಲ DRT. posted on 11, next on Contempt. Then the wife files an OS in Davangere again paying instrumentally rights. Then my lord, C files is petition here. Alternatively, husband and wife my lord, case to be that
Writ petition,
as a
yeah.
warrant for the borrower,
Writ
they are
petitioner,
filing.
hall ticket of the daughter, my lord,
ಅಲ್ಲೇ
it was very much required. at
DRT,
that time.
DRT, ಈಗ ಹಾಲ್ ಟಿಕೆಟ್ ತಗೊಂಡಿದ್ದೀರಲ್ಲ DRT,
ಮಾತಾಡ್ಬೇಡಿ.
DRT definitely. Yes. Yes, go before the DRT.
2 months ಅಲ್ಲಿ vacate ಮಾಡ್ತಾರೆ, undertaking affidavit ಹಾಕಿದ್ದೀನಿ.
Please deed ತೋರಿಸಿ.
Please deed ಇಲ್ಲ.
Where is that lease deed?
I'm not,
ಮಾತಾಡಿ.
he did not get it to my.
Get the lease deed, we will do something. Get the lease deed.
I've undertaken affidavit file ಮಾಡಿದ್ದೀನಿ.
Madam, lease your lessee ಅಂತ ಯಾರಿಗ್ ಗೊತ್ತು? How can we pass orders on the undertakings like this?
Borrower and the previous, my lord, predecessor and title.
No, you should sit with the bank and decide it. I am not going to enter.
From the date, my lord.
No, madam,
I
nothing.
purchased the property. my lord.
No, that's what borrower is shooting from your shoulder, no? No, madam, not in this case.
I'll
Yes.
have this matter on Monday.
All right,
Please.
whatever time. ಯಾವತ್ತಿದೆ ಅಲ್ಲಿ DRT? Monday ಇದೆಯಾ? Let's the matter on Wednesday. Yes. Next. ಎಲ್ಲ ರಿಜಿಸ್ಟ್ರಿ ಹಾಕಿ. Yes. Next.
Please.
45.
But the license was granted in favor of the petitioner.
What license?
The running a retail fertilizers business man.
Hmm?
Retail fertilizers business man.
ಹಾ ಆಯ್ತು, ಏನಾಯ್ತು ಈಗ?
My lord, I am running the shed shop from 1986.
ಹಾ.
Now they permanently cancelled my license in the 27/1/2025. my lord.
Why?
My lord, only allegation is that I have sold 200 rupees excess one urea bag. That is only allegation. They have cancelled the permanently my license. Then
Heard-
my lord,
Heard the learned counsel appearing for the petitioner. Petitioner is a holder of a license granted to sell fertilizers. He has been doing this business for the last 36 years. The learned counsel for the petitioner submits the license of the petitioner is all of a sudden cancelled on the score that 200 rupees, a bag of 200 rupees urea is sold in excess of the permitted quota, and therefore the permitted quota. If this be the reason as projected by the petitioner, it would on the face of it become illegal. Therefore, there shall be an interim order of stay as prayed for till the next date of hearing. One learned HCGP is directed to accept notice. All respondents. Yes.
Okay.
Next. 2:30 minutes.
46.
Madam, 46. ಇದ್ಯಾವ್ದು? ಇನ್ನೊಂದು ಇದೆಯಾ?
46, I'm appearing for the.
ಇದು ಗುಲಾಂ ಮುಸ್ತಫಾ ಎಂಟರ್ಪ್ರೈಸಸ್ ಅಂದ್ರೆ he is ಗುಲಾಂ ಮುಸ್ತಫಾ that borrower is
Not
it?
say, Ghulam Mustafa is the borrower, but here,
ಅದು ಅದಕ್ಕೆ ಲಕ್ಷ್ಮೀನಾರಾಯಣ್ ಸರ್ ಅಪೇರ್ ಆಗ್ತಿದೆ, ಅದೇ ಕೇಸ ಇದು?
no, my lords, this is a matter where,
Hmm.
I'm not sure, my lords. This Ghulam Mustafa
100%
Enterprises,
He only.
lords, shareholding pattern is completely different.
No,
I've got
Gulam
the-
Rasool is his father's name, same.
Yes, lords,
Yes,
what
sir.
I am submitting is the property in question
Ah.
is held by a company by name Ghulam Mustafa Enterprises.
ಈಗ
Private Limited.
ಏನಾಗ್ಬೇಕು ಹೇಳಿ?
Lords, the attachment order is issued against,
By whom is the attachment order issued?
lords, it is by the pursuant to the recovery certificate, the, lords, the question is only this, my lords. Decrees against A, the property of B is attached. That is the only
I
question.
have passed 10 orders directing this man to be GM Infinite Dwellings, same.
Against him, there is no difficulty, my lords. What they are now doing is, they are proceeding against an entity called as Ghulam Mustafa Enterprises Limited. Now the shareholding pattern is completely different. It's not even a holding company.
Well, see, let the respondent come.
Lords,
Who's the
now,
respondent?
now the difficulty is this, my lords. I wanted to say this.
No,
to
sir,
you.
not to this man.
No, it's not about the man. Lords, the RERA appears to have literally understood as to what is this attachment all about. Lords, attachment means that there will be an embargo on a person who owns the property not to sell or create any third party rights which would affect the recovery procedure.
We'll see, we'll hear the respondent.
There is a reason why I'm submitting this. What they are doing is they are putting up the barricades and then putting up hoardings and boardings saying that this is their property which we are keeping it under attachment. Not the reason why I'm submitting this is something which is never contemplated and under any procedure. That should not be done. If an order of attachment is there, let it be there. I am myself making a statement, I will not sell
Who
this
would know?
property.
Who would know it is attached?
Milords, the question is this, Milords, once the attachment operates, then automatically, Milords, the property is secured. The loan is secured. That is the object. I am now making a statement before the court. I will not sell this property. I am not going to create third-party rights in respect of this property.
Ravi Shankar sir, not to this man at all.
No, it's not.
I have myself dismissed 10 writ petitions.
Shareholding. Milords, I just-
Senior counsel Lakshminarayan ಎಲ್ಲದಕ್ಕೂ ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ.
Lords, I just share the shareholding pattern of these two companies. Lords, the question of respondent appearing, respondent doesn't know anything about this. It is only, Milords, between me and the Tehsildar. Tehsildar intends to attach a property in respect of a decree which has been passed against.
Let him go through it, yes.
GM Infinite Dwellings. Lords, that question has to be addressed, Milords.
We'll address it, sir.
I'm
Not by way of an interim order at all to this man.
Lords, I'm not saying that your lordship should stay the attachment order. I'm not come here for the stay of attachment order.
You ಕೇಳಿಲ್ವಾ?
Lords, I have sought for, but now I'm making a statement. I'm not saying that your lordships may stay the attachment order unconditionally. I'm making a
No
statement.
condition also. I'm not staying it at all.
No, I'm making a statement, my lords. Let that order of attachment be enforced, no difficulty. But let them not do all this. This
That
is
we'll
not
see,
something
we'll
which is contemplated under law. Where are they getting this?
We'll see, yes.
No, that is something which has to be prevented.
That
my lords.
we'll see.
Now your lordships, my lords, I'm not seeking stay of the attachment order. Attachment, I'm making a statement that I'm not going to sell the property. The decree, if at all it can be enforced against me, is secure because that's a point which your lordships will have to consider. Then where is any question of this entire exercise? Kindly have a look at Order 21, Rule 54 for a minute, my lords. What is meant by attachment? Order 21, Rule 54 says that the dealing with the property is completely prohibited. That is an order which will be proclaimed. Notice how the proclamation has to take place. Kindly, because this is a procedure which is not explicitly contemplated or provided for under the RERA Act.
We'll hear the respondent.
But I'm not saying, Milords, that your lordships will not have to hear the respondents and grant an interim order. That's not what I'm submitting. But the manner in which they are undertaking
Then
order of attachment.
we'll hear the respondent.
But by the time if they do it, Milords, the whole purpose, they will
Yes.
put that barricades. Milords, I just wanted to show some photographs, what they are doing. I don't know where they are getting this procedure. Milords, even the income tax attachments are not done like that.
Income tax attachment, the polished attachment.
Milords, income tax attachments are.
ಅದ್ರಲ್ಲಿ ಏನ್ ಮಾಡೋದೇ ಇಲ್ಲ.
Milords, income tax attachments is merely communicating to the concerned authorities,
Correct.
Milords.
ಅಷ್ಟೇ.
That is how it should be done, but that's not what they are doing here.
We'll see. We may have to lay down something. We'll see. Yeah. Yes, government. Learned, heard the learned senior counsel, Dr. Ravi Shankar appearing for the petitioner. The allegation of the petitioner is with regard to the manner in which the orders of RERA are sought to be executed. The RERA appears to have granted recovery certificate.
Milords, the recovery certificate is issued.
RERA, is it?
Yes.
The recovery certificate is said to have been granted
Against a different entity.
against
GM Infinite Dwelling India Private Limited.
against GM Infinite Dwelling so and so. The property of the petitioner has now become subject matter of display of attachment. The learned senior counsel submit attachment should be by way of passing certain orders and
And proclaiming it in accordance with law.
Passing certain orders and proclaiming the same in accordance with law. Here, the proclamation is alleged to be by way of putting up hoardings.
Barricades and
hoardings or barricades on the property, displaying it that the property has been attached in a particular case. The learned HCGP is directed to accept notice, secure instructions in this regard, and make submissions on the next date. List the matter on
Milords,
28th.
Principal contention, lordships may note because they should not say that I have restricted my prayer. Principal contention, Milords,
Principal contention
is that GM Infinite Dwelling India Private Limited is the judgment debtor. It is against them the recovery certificate is issued. And the property.
Why
which
is
sought
Ghulam
to be-
Mustafa Enterprises now sorted?
That is the reason,
The
Milords.
learned senior counsel would further contend that the recovery certificate is issued against one GM Dwelling Infinite Private Limited. And Ghulam Mustafa Enterprises is now sought to become the subject matter of display of attachment. The answer shall be, the respondent, CGP shall answer the same on the next date, list on 28th.
Let them not.
Sorry,
precipitate-
28th, 25th in the
let
fresh
them not
matter.
precipitate till then.
ಏನ್
because
precipitate?
ಅಲ್ಲೇ ಅದೇ ಹೇಳ್ದಲ್ಲ ಅಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟು ಅಲ್ಲಿ
ಅದು ಮಾಡ್ಲಿ ಅವರು.
ಅಲ್ಲ ಅವ್ರು ಮಾಡ್ಬಿಟ್ರೆ ಅದೇ ಹೇಳ್ದ
ವಿಲ್ಸಿ ಮಾಡಿ ತಗ್ಸಿದ್ರಾಯ್ತು.
ತೆಗ್ಸೋದಕ್ಕೆ ಸರಿ ಬಟ್
That's all.
ಯಾವ್ದೋ ಒಂದು ಕೇಸಲ್ಲಿ ಹೇಳ್ತಿದ್ರು ಏನಾಯ್ತು ಏನೂ ಆಗಿಲ್ಲ ಬಿಡಿ ಅಂತ. ಇಲ್ಲ ಮಾನ ಹೋಯ್ತು ಅಷ್ಟೇ ಇನ್ನೇನು ಆಗ್ಲಿಲ್ಲ.
ಅದು
ಆ ಥರ ಆಗೋದು
ಹತ್ತು
ಬೇಡ.
ಪೆಟಿಷನ್ ಹಾಕದಾಗೆ ಗೊತ್ತಾಗಿದೆ ಬಿಡಿ.
ಅಲ್ಲ
ತೊಂದ್ರೆ
this
ಇಲ್ಲ.
is this is a different entity where the shareholders are different, directors are different. It's already taken over by another
We'll see,
entity.
we'll see. Yes.
Let them not precipitate, Milords. This Milords, this
They will
becomes
not put
a
up,
huge
Milords.
embarrassment, Milords.
They will not put up.
Very well.
Yes. Because this petitioner, I have seen 10 petitions.
But that is
Same
why that
Ghulam
Ghulam Mustafa. Now the shareholdings, Milords, is not the same
ಶೇರ್ ಹೋಲ್ಡಿಂಗ್
person.
ಚೇಂಜ್ ಆಗಿರ್ಬೋದು, ನೇಮ್ ಅದೇನೆ.
ಅದೇ ಅವ್ರ ನೇಮ್ ಚೇಂಜ್
ಎಲ್ಲ ನೇಮ್
ಮಾಡ್ತಾರೆ.
ಚೇಂಜ್ ಮಾಡ್ಕೊಂಡು ಮತ್ತೆ ಅದೇ ಕೆಲಸನೇ. 10 ಪೆಟಿಷನ್ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದೀನಿ, ಕಾಸ್ಟ್ ಇಂಪೋಸ್ ಮಾಡಿ. And man had gone to Supreme Court also against those orders.
Of course, Milords. Some persons do not deserve.
Yes, that is why I have not. Otherwise, we will give it, yes.
But
To that, as well as somebody.
Further hearing, 102.
ಈಗ ಹೇಳಿದ್ರೆ ಗೊತ್ತಾಗಲ್ಲ, ಇರಿ ಆಮೇಲೆ ಹೇಳಿ.
ಕರೆಕ್ಟ್ ಕೊಡ್ಬೇಕು.
ನೀವು ನೆನ್ನೆ ಇರ್ಲಿಲ್ಲ? ಎಸ್ ಎಸ್, ಸ್ಪೆಷಲ್ ಕೋಡ್. Yes, sir. Yes. Before you commence, sorry for yesterday. I was a little harsh in telling finish it. Because
Please.
I have myself indicated that it should be completed in a time frame. So I was a little
ಸ್ವಲ್ಪ
anxious about it.
ಸ್ವಲ್ಪ leverage ಕೊಡು.
That's all. No.
ಯಾಕಂದ್ರೆ
ಅದಕ್ಕೆ sorry for yesterday.
ಅಯ್ಯಯ್ಯೋ.
Yes. We'll continue. Yes.
ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ, some serious and important question.
All right.
Probably ultimately, my lord may have to lay down a law on the point. And I'm going to take your lordship because as I could make out, my lord, what is working in your lordship's mind is, could this be taken that he making an application, number one, seeking for
Sir,
pardon?
if I am permitted, I'll clearly tell what is running in my mind.
Well, is it a deemed acceptance or not?
Three things are running in. Of course, they have deciphered a little, but one is whether these contentions can be advanced by you in the appeal, in case the proceedings go against you. In the sense you are convicted or whatever, or otherwise. One, or these things can be looked into under 482, because direct judgment I'm not getting on that, whatever they have
But
given.
482, my lord, is a writ petition.
226 read with 482. There are criminal petitions also here. Is it? One writ petition, ಮಿಕ್ಕಿದೆಲ್ಲ criminal petition.
My lord, Ashok Kumar Agarwal is 482.
Fine. ಅಲ್ಲ ಕರೆಕ್ಟ್, ಅದಕ್ಕೆ ಒಂದು. ಆಮೇಲೆ ಇನ್ನೊಂದು, the procedure that you are saying under 306, 3 and 5, say it is mandatorily to be followed. Now he is the applicant. He says, yes, I am seeking pardon for reason so and so, so and so. The court says, yes, we will consider your application, accepts the application, records evidence. Even then, whether 306, 3 and 5 should be followed when he has himself offered to, to come as an approver. is what is again running in my mind. Whether it is, his action is deemed acceptance is what? One thing. And these two, yes, primarily are running. Incidental questions I'll ask.
Please, my lord, we are
That's
bound
all.
to, we are bound to clarify, my lord's doubt.
If the other then arguments I have heard, no problem. That is what the summary of the arguments is what is running in my mind like this.
But my lord, the judgments on which we are placing reliance are all
482.
482 only.
Yavado
And under section 397 as well.
397, yes.
397 as well.
ಅಲ್ಲ ಈಗ ಅಶೋಕ್ ಕುಮಾರ್ ಅಗರ್ವಾಲ್ ಅಂತ ಹೇಳಿದ್ರಿ.
ಅದರಲ್ಲಿ ಪಾಸ್ಕಲ್ ಫರ್ನಾಂಡಿಸ್ ಅನ್ನ ಫಾಲೋ ಮಾಡ್ತಾರೆ. ಪಾಸ್ಕಲ್ ಫರ್ನಾಂಡಿಸ್ is again under section 300.
Pascal Fernandez is under
397.
397. Revision.
Revision.
So
And then,
according to you, if,
2013, my lord.
no, according to you, sir, that if revisional court has such power to entertain all this, inherent jurisdiction under 482 apparently would have.
Obviously, my lord, an accused or anyone else, as a matter of fact, cannot claim as a matter of right that he has a right of revision.
Correct. That's,
May.
yes.
The court may
Right,
call for.
right of revision is under the statute.
Yes. So, if
It's
a revisional court can,
unlike an appeal.
yes, if a revisional court can exercise its jurisdiction, my lord, to correct the error that has been committed, my lord, then why not the court?
No, that's what I have held in the other case.
Under,
To add to it, my lord, Asian resurface. My lord, that's just the issue, irrespective of the title, whether it's division 482 or 226. Court's power, my lord, that's all we are concerned.
The latest Asian resurface.
My lord, three judgments in Asian resurface.
That is
very
reverse.
same point.
That is reversed on that point.
No.
No, 5 judge bench, what did they do?
Not on the aspect of the no, my lords.
Limitation. Limitation.
Yes, my lords. That's only insofar as the direction
months
is concerned. Otherwise, my lords, Asian resurfacing, they said irrespective. In Asian resurfacing, the point was the rejection of discharge application. Can you prefer a revision? Same
that is-
interlocutory,
yes.
intermediatory order. While dealing with this, His Lordship Justice Nariman would say, irrespective of the title, whether it is going to be a revision, whether it is going to be inherent powers, or whether it is going to be exercising
No,
your
the
writ
5 judge,
powers.
5 judge bench only clarified with regard to 6 months period.
Yes, my lord. 6 months period, they said the court ought not to be fixing a period for the completion of it. That's the only clarification. Otherwise, my lords, so far as 482 powers are concerned, my lords, if revisional powers are there, my lords,
No, I
quite
think in the same,
obviously-
in this, between the same parties I have held so in the
my
earlier
lords.
case. Yes.
and my lords dealt with this in this very same matter, my lords.
That's
where
what
my
I
lords
said,
has
between the same
exercised
parties in the
powers.
earlier case I have said so.
And that too in Asian resurfacing,
My
they
lords-
say generally the court will not direct. Generally, my lord, that even the power to give such a direction is also not taken away. The change was only to that extent. Generally, the constitutional courts will not direct, that's all.
And my lords, in the present litigation, when A17's application was rejected, my lords, they had challenged it here, and here it was allowed. His coordinate bench, Lordship Justice Natarajan, allowed the petition, allowing him to become an approver. Different matter that he turned hostile thereafter. After that, my lords, insofar as the very same A1, it was before my lords in a 482
Yes,
and
that I
226.
quashed it, yes.
So, my lords, I think the aspect of,
Okay,
sorry, my lords.
So we'll go to the next point. Yes. ಅದು ಗೊತ್ತು.
Our case is the discharge application will not taking order. Is abuse of process of court. Then it is not, that's not happening.
ಎಲ್ಲ ಹೊರಟೋಗುತ್ತಲ್ಲ ಯಾಕೆ?
All right. Yes.
My lords may hold my lord, it is whether abused or not, but our case, the petitioner case is.
No, every petitioner's case is the abuse of the process of the law.
ತಗೊಳ್ಳಿ.
Whoever invokes 482 says it is abuse of the process of the law. Yes.
307 ಆಗಿರೋದು 306 ಕಂಡೀಷನ್. Yes, ಸರಿ, ಒಬ್ಬ ಸಲ.
Yes, sir. And Sandesh, sir, idrallu you have given those points, is it? ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ? ಅಲ್ಲ ಒಂದು, yes, yes. Yes, sir, yes.
Lord, the submission from the respondent the other day was that this is a pardon given by the Court of Sessions while exercising its jurisdiction under section 307 and not under section 306.
So in 307, there is no condition
Yes.
of 3 and 5 compliance is what is.
I'm grateful, my lord.
That's
I was
what
about-
submission was that.
I was about to answer that.
Submission was
In
that.
view of the fact that 307 does not mandate the imposition of any conditions, therefore 306 will have absolutely no application whatsoever, because 306 is applicable only to a tendering of pardon by a magistrate. Magistrate. But straight away I can invite my lord's attention to Abu Salim's case, what the Supreme Court has said. But still, my lord, my endeavor is to draw my lord's kind attention to first 306. But I think we might have invited my lord's kind attention 100 times, 306, 307, and 308. Kindly go to 306 first.
Yes, sir.
Probably it may, to some extent, clarify the doubt which my lord has also entertained, whether is it a deemed acceptance or not.
Yes.
Your lordship would certainly get it here. With a view to obtaining the evidence of any person supposed to have been directly or indirectly concerned, in or private to an offence to which this section applies, the Chief Judicial Magistrate or a Metropolitan Magistrate at any stage of the investigation, inquiry into or trial of the offence, and the Magistrate of the first class inquiring into or trying the offence, at any stage of the inquiry or trial may tender pardon to such person on condition of his making a full and true disclosure of the whole of the circumstances within his knowledge relative to the offence and to every other person concerned, whether as principal or abettor in the commission of the offence. Well, and if at all there could be any change in circumstance, it should be in or in relation to the evidence relating to the offence, not with regard to the threat perspective, but which he would allege in his complaint, in his petition.
Yes.
This section applies to any offence triable exclusively by the Court of Sessions or by the Court of a Special Judge appointed under the Criminal Law Amendment Act 1952. Any offence punishable with imprisonment, which may extend to 7 years or with more severe sentence. Well, this would be very, very important now. Every magistrate who tenders a pardon under subsection 1 shall record A.
Reasons for so doing.
Reasons for so doing. Kindly pass for a minute.
Yes.
He has
recorded
elaborate
reasons.
it. Now this would be important. B, whether the tender was or was not accepted by the person to whom it was made. And, my lord, may kindly mark this, and shall, on an application made by the accused, furnish him with a copy of such record.
Now,
My lord, if it is a deemed acceptance, there can't be a record at all.
no, 1 minute. Sir. Now, subsection 3 says, every magistrate who tenders a pardon under subsection 1 shall record. So it should be in writing. What should be in writing is his reasons for granting pardon.
Yes.
And he should also record that tender was
Yes.
the pardon was accepted or not by the person to whom it was made.
Yes.
So whether he has to communicate that
Adalla.
he should record it that he has accepted the tender.
Adu illa.
How does one know that he has accepted the tender?
Exactly, that exactly. Now, my lord, and shall on an application made by the accused furnish him with a copy of such record.
Correct. If
My lord, suppose I make an
he files an application, he should give a copy.
When it is not there at all.
That's
It's
what
just
I'm
that building
saying.
cannons
Now,
in the air.
that's exactly what I'm trying to
Therefore, my lord, he is required to record the acceptance or otherwise, without which he can't furnish the record at all.
Yes.
Can't be deemed one. If it is a deemed one, my lord, where is the question of he furnishing to me the record of acceptance?
Yes.
Well, then kindly go to 4 now. Every person accepting a tender of pardon made under subsection 1 shall
be examined as a witness.
No, my lord. Every person accepting a tender, the condition precedent
That he should accept the tender.
that he should accept. There should be a record of acceptance, without which he can't be examined at all under subsection 4, subclause A of section 306.
Yes.
Every person accepting a tender of pardon made under subsection 1 shall be examined as a witness in the court of the magistrate taking cognizance of the offense and in the subsequent trial, if any. B, shall, unless he is already on bail, be detained, etc. Where a person, kindly go to 5, where a person has accepted a tender of pardon made under subsection 1 and has been examined under subsection 4, the magistrate taking cognizance of the offense shall, without making any further inquiry in the case, commit the case for trial, etc. But what my learned friend submitted to your lordship the other day is, all these conditions are found not under section 307, but it is only under section 306 in as
That was submissions. 306 imposes 3 and 5.
3 and 5.
That is
Whereas
by,
in
that is by the
307,
magistrate.
it
Now
is not
307 is tender by a court of session, where there is no such condition. It is plain and simple.
Yes.
That any
Well,
time after commitment, before just court commitment is made, with you have obtained trial evidence, any person supposed to have been directly, indirectly
Quite right.
concerned, privy to such offense, tender a pardon
Yes.
on the same condition to such person.
Which
So
is
it
the
is,
condition?
it is deemed that it condition is in 306.
Well, there is a direct judgment of the Supreme Court in Abu Salim's case. May I just pass on this judgment, Mal?
Okay.
Court has. May I request your lordship to kindly turn to para 16 at internal page 186 of the judgment. In fact, my lord,
Give the citation. Kindly
Sir,
give us.
it is 2010
This is in
10
the
SCC 179.
but in fact, what the trial courts are doing, well, that I don't know whether I'm afraid whether I could bring it to your lordship's notice,
Which
the
one?
practice that is being followed by the trial courts,
Huh.
other than this court. May I just-
In pardon ವಿಷಯದಲ್ಲ.
ಹೌದೌದು ಮಾಡಿ ಆ ಪಾರ್ಡನ್ ಮಾಡಿರೋದು ಒಂದು ಕಾಪಿನ ಅಕ್ಯೂಸ್ ಕೊಟ್ಟು ಆಮೇಲೆ ಅವ್ರು ಎವಿಡೆನ್ಸ್ ಮಾಡೋದು. ಹಾಳಿ ಸರ್ ಸುಮ್ಮನೆ ಮತ್ತೆ ಯಾವ್ದು ಕಾಪಿ ನೀವು ಕೊಡ್ತಾರೆ
This is an order, accepts.
ಕೊಡಿ ಯಾವ್ದೋ ಕೊಟ್ಬಿಟ್ರೆ ನೀವು ಹೆಂಗೆ
Yes.
ಕೊಡಿ ಅದೇ ಕೊಟ್ಟರು
ಇಲ್ಲ, same.
ಸೇಮ್ ಥಿಂಗ್ ಸೇಮ್
So there is an order
ಆರ್ಡರ್
recording that he has accepted the pardon and then evidence.
then send a copy of this and then he would be examined.
So
as a-
that's perfect procedure.
Idrili, may I request your lordship to kindly turn to paragraph 16 at internal page 186 of the judgment.
Abu Salim's case.
Abu Salim's case.
Yes.
The magistrate of the first class under section 306 is also empowered to tender pardon to an accomplice at any stage of inquiry or trial, but not at the stage of investigation, on condition of his making full and true disclosure of the entire circumstances within his knowledge relative to crime. Section 307 vests the court to which the committal is made with the power to tender a pardon to an accomplice. The expression on the same condition, which my lord has just now
Yes.
pointed out, the expression on the same condition occurring in section 307 obviously refers to the condition indicated in subsection 1 of section 306, namely on the accused making a full and true disclosure of the whole of the circumstances within his knowledge relative to the offense and to every other person concerned, whether as principal or abettor in the commission thereof.
Yes.
Well, and now kindly go to 308 for a second, my lord.
Yes. He will himself become an accused if he
Yes, my lord. My lord, here, as the Supreme Court has said,
breaches the
well, the
tender.
Supreme Court has said in the earlier judgments, my lord, which I am going to point out to your lordship a little later. Well, my lord, pardon is given to him. Pardon is accepted by the accused. He is examined in chief. But that is not the evidence alone in the case. The evidence, my lord, is examination in chief,
Cross-examination
cross-examination and re-exam. All
Yes.
put together, my lord,
is
it
evidence.
is
yes.
evidence. Well, he supports the case of the prosecution when he came to be examined
Examination in
under
chief.
section 306 in examination in
Yes.
chief. My lord, while accepting the pardon, my lord, he virtually gets discharged of the offense that is complained against him. He be a principal offender
Yes.
or a companion accused of the principal offender.
Accomplice.
He gets the benefit of virtually an order of discharge.
Yes.
Well, he enjoys the benefit of an order of discharge. Examination in chief is done.
In
In
cross-examination,
examination, my lord, he gives a total go by, or my lord, he gives certain vital admissions which is favorable to the accused in the case.
then comes 308.
Then, my lord, 308 comes into play. But once the 308 comes into play, he becomes liable for prosecution in the case in which he was given the pardon.
Pardon.
In other words, he gets relegated back to the
As a
status of
status
the
of
accused,
accused.
in addition to his
Facing
prosecution,
prosecution
for
for
having
this.
giving false evidence in the case. Well, in that case, in the Bombay case, which I invited your lordship's attention, well, he came to be prosecuted. He was sent back to his original status. Well, the accused took a plea. I'm sorry, I have not accepted the pardon at all.
Pardon at all.
The court could do nothing.
Yes.
If he has accepted the pardon, then, my lord, he could have been prosecuted or sent back to his original state. I did not say so. I did not accept the pardon. Whatever the truth of the incident, which is well within my knowledge, I have deposed before the court. Merely because I give some admissions in the cross-examination, it does not mean that I am reconciling myself. But that was it. Now, my lord, kindly go to 308 and have a look at section 308 number
Yes.
second.
Yes.
Where in regard to a person who has accepted a tender of pardon, where in regard to a person who has accepted a tender of pardon made under section 306 or under section 307, the public prosecutor certifies that in his opinion, such person has by willfully concealing anything essential or by giving false evidence not complied with the condition on which the tender was made, such person may be tried for the offense in respect of which the pardon was so tender, yet goes back to his original status as an accused and not as a witness. For the, well, all these years we have seen these things happening in real life. Accused becoming the witness and the witness becoming the accused.
Yes,
One
yes.
fellow during trial, he comes running, no, he is not the accused, I am the accused. And he says, no.
No, real life.
Real life. But this could also happen in real life.
Yes.
That is why, my lord, he is sent back to the status of an accused and he is required to take his trial in the case. So was there, or for any other offense for which he appears to have been guilty in connection with the same matter, and also for the offense of giving false evidence. Well, as far as prosecution of the person who gives a go-by to the pardon that was given, well, it could be done only with the approval of this honorable court, otherwise it can't be done. That is the law on the point. So therefore, my lord, acceptance of pardon is a condition precedent for the court to examine him as a witness on behalf of the prosecution.
Even before the examination in chief.
Otherwise, he can't be made to step into the witness box at all.
Yes.
Well, that is the object. That is the purpose.
No, correct. Tomorrow, if you say, I have not accepted this at all.
Yes, I have not accepted the tender means. Well, kindly have a look at page number 94, my lord. Nanda idu. Put it, Nanda.
94 of the petition?
Memo of authorities which are given. Adena, 15. Well, kindly go to paragraph 15.
The Bombay High Court.
Bombay High Court. Otherwise, the very purpose of the object of giving him tender gets defeated.
Last 7 lines of paragraph 15. Once the pardon is tendered on such conditions and conditions are accepted, that's what you want to read? Yes.
But once the pardon is tendered on such conditions and the conditions are accepted by the accused, then the said accused under law gets discharged from the case. The accused then becomes an approver/witness for the prosecution. The approver at the stage of trial may support or may not support the case of the prosecution. However, once the pardon is tendered, the approver has no choice than to give evidence before the court as an approver. It needs to be stated that once the approver steps into the witness box, the approver has prerogative to depose according to his or her wish. In this manner, nobody can compel the approver to give a particular evidence before the court.
Yes.
But this is, in this case, the trial court passed an order under section 308 for his prosecution and relegating him back to his original status as the accused. That came to be quashed.
Yes.
My lord, may kindly go to paragraph 22.
Yes.
The latter additional sentence, consistent with the pardon tendered to the approver and accepted by the approver on terms and conditions, shall examine the approver as and when she is presented before the court. As for the application made by, I'm sorry, earlier, Abu, while following
Abu Salam is followed.
Yes, while following Abu Salam, learned judge has completely misdirected himself in addressing the question. Therefore, the order is required to be quashed and set aside. Accordingly, the petition is allowed.
Yes.
This should answer. Lord, I'll go back now, my lord. I was inviting my lord's kind attention as far as the deemed acceptance is concerned in Bipin Bihari also, my lord.
Yes, yes.
It is said. May I request your lordship now to kindly go to whether acceptance of pardon is a condition precedent for examining him as a witness in the case.
That also I have taken through. It is a condition precedent.
Any number of judgments, I'll just.
ಅವರು ಹೇಳಿದ್ದಾರೆ. Acceptance conditions 3 and 5. Conditions 3 and 5 are condition precedent before examination in chief itself is what he has said.
Please. Well, now we will go to his application first. This is the third application. Well, although my lord has said in the earlier order.
First rejected. Second was not in accordance with law because 164 statement was recorded. That is quashed. Now the third is this.
Well, the third is this. Well, allowing my criminal petition, by allowing my criminal petition and quashing the order, well, this honorable court would virtually dismiss the second application which came to be filed. It is not a case of remanding of.
No, I did not remand it. Liberty was reserved to file a fresh application if needed.
No liberty was given to give a fresh application.
No, I've said liberty is reserved. If he wants to file an, no, not even that liberty. What is?
No, my lord.
Yes, Nagendra Naik.
Well, it has not. This honorable court is not tying the hands of.
That's what I've
said. Hands are not tied. Well, if that is granted, well, till the disposal of the case, the conclusion of trial, each event comes to an end. Till such time the judgment in the case is pronounced. Conclusion of trial means judgment of the case. He can go on and keep making application after application. That was not the intention of this honorable court.
No, I said hands are not tied, unchanged circumstances.
Yes. Well, that came to be made use of by the accused to make the application. Well, this honorable court would pass the order. While doing so, my lord, this honorable court would say, yes, I am not tying your hands, provided there is some change in circumstances is the order which came to be passed by this honorable court. Well, the order came to be passed by this honorable court on 4/12/2024.
Yes.
Yes, ma'am. Well, on 6/12/2024.
Third application.
Third application is filed. 4/12 order. What remained to the accused was only 1 day. In 1 day, my lord, what was the change in circumstance? He ought to have brought it to the notice of the trial court, which he has not done. On 6/12, no sooner he makes the application, the trial court would say, ask the state, what have you got to say on this application? Well, the state will say, we have no objection. Come on, you do it. Very next day itself, then and there.
State and the CBI.
CBI. Well, now, what he would mention in the third application is what has been mentioned in the second application itself. Well, I say so For this reason, in fact, this has been referred to also by your lordship in the earlier order.
No, there was no full disclosure earlier. Now he is tendered full disclosure in the third application.
No, my lord, in the second application, it is there.
Disclosure was there.
Yes, my lord, it is there.
All right, all right. Yes, yes.
ಹೇಳ್ತೀನಿ ಸರ್ ನೋಡಿ ಸಿಬಿಐನವರು ಗರ್ಭಗುಡಿ ದೇವರು ಗರ್ಭಗುಡಿ ಕೂತಂಗೆ ಅಲ್ಲಾಡ್ದಾಗ ಈ ಶಾಕ್ಡ್ ನಾವು ವೈ ಐ ಡಿಡ್ ರೆಕಮೆಂಡ್ ಯುವರ್ ಅಪ್ಲಿಕೇಶನ್ ಅಂತ ನೀವು ಒಂಥರ ಉತ್ಸವ ಮೂರ್ತಿ ತರ ಬೀದಿ ಗಲ್ಗಲ್ಲಿ ತಿರುಗ್ತಾ ಇದ್ರು ಒಂದು ಹೇಳ್ತೀನಿ ನಾನು ತೋರಿಸ್ತೀನಿ ಹೆಂಗಿದೆ ಅಂತ ಅನ್ಬಿಟ್ಟು ಅಂತ ನಾನು ಹೀಗೆ ಮಾಡಿದ್ರೆ ನಿಮ್ದ ಪೆನ್ ಡ್ರೈವ್ಗೆ ಇವತ್ತು ತೋರಿಸ್ತೀನಿ ಇನ್ನೂ ಅದನ್ನ ಇನ್ ದಟ್ ಪೆನ್ ಡ್ರೈವ್ ಈ ಮೇಕ್ಸ್ ಎ ರೆಫರೆನ್ಸ್ ಟು ದ ಜಡ್ಜ್ ತೋರಿಸ್ತೀನಿ ನಿಧಾನ ತೋರಿಸ್ತೀನಿ ಸಾಹೇಬ್ರು ಟೆಸ್ಟ್ ಕೊಡ್ತಾರೆ ಏನ್ ತೊಂದರೆ ಇಲ್ಲ
Of the
Yes, my lord, the trial court judge. ತೋರ್ಸಕ್ಕೆ ಹಾಕಿರೋದು ಅದನ್ನ ಇವತ್ತೇ ಇನ್ನು ಗೊತ್ತಾಯ್ತು ಸುಮ್ಮನೆ ಬಿಡಿ ಒಂದು 10 ನಿಮಿಷ ತಾಳ್ಮೆಯಿಂದ ಇದ್ಬಿಟ್ರೆ ಆಗತ್ತೆ
ಪೆನ್ ಡ್ರೈವ್ ಕ್ಯೂರಿಯಾಸಿಟಿ ಅವರಿಗೆ
ಹೇಳ್ಬಿಡ್ಲ ಮೊದ್ಲಾಗಾದ್ರೆ ಅಲ್ಲ where you
No, no, no.
so touchy, don't feel touchy,
No, like
nervous also.
no, like always, pen drive curiosity ಜಾಸ್ತಿ
ಅವ್ರಿಗೆ But your lordship posed a question to me that in the second application, all these details are not there. It is only in the third application he would incorporate the details of the evidence which he has got deposed before the court, or of the facts that are well within his knowledge, or of the role played by him in addition to the role played by his
yes
companion accused in the case. For the first time he would disclose is what my learned friend also said by way of interruption. May I request your lordship to kindly turn to the second application.
So the submission is third application is verbatim similar to the second application, no change.
Absolutely no change. I shall show to your lordship now. Page 130. Order sheet record ಆಗಿರುತ್ತೆ ಇದನ್ನ ಇದನ್ನ ಕ್ಲೋಸ್ ಮಾಡೋದು. My lord, to the second application. Third application. Well, have a look at the second application now. Page 248. CBI enclose ಮಾಡ್ತಾರೆ ಅದರಲ್ಲಿದೆ. ಇದರಲ್ಲಿ
Yes, sir. I have it.
248. Your lordship would get this application. This is the second application of 19th of October.
ಇದರಲ್ಲಿ ಏನು ಇರಲೇ ಇಲ್ಲ.
ಬಂದೆ ಅದಕ್ಕೆ ಹೇಳ್ತೀನಿ ಈಗ ನನಗೆ ಅದಕ್ಕೆ ಹೇಳ್ತೀನಿ. It is on this application that the court would call for objections.
And direct recording of statement under 164 because he has not said anything there.
No, they would call for. Well, what the CBI does is, have a look at page 257. At page 257. Order sheet ತೋರ್ಸಪ್ಪ ಅಂತ ತೋರಿಸ್ತಾನೆ.
Para 15 and 16.
My lord, in addition to this, they would also produce before the court the statement of the second accused.
Yes.
In fact, your lordship has referred to this also in the earlier order. An undated application has been filed before the CBI, which has also come on record in the case. Well, this is nothing but, in the third application, it is nothing but the carbon copy of the statement made by him before the CBI, or a representation or an application which came to be filed by the first accused before the CBI. And this forms part of the statement of objections filed by the CBI to the second application.
That's what I have said in the earlier.
What your lordship also has said. Now, my lord, the third application is carbon copy. That is why, my lord, I submitted to your lordship. Your lordship has not remitted the matter back to the trial court for first consideration on the score that these details of the evidence which he has got to give is not made available to the court in the application filed by him. Instead, my lord, your lordship would allow the petition and quash the order which came to be passed by the trial court. Therefore, is it open to the respondent CBI or is it open to the first accused to contend before your lordship that the evidence which was to depose before the court is made available to the court for the first time in his third application? Because this formed a part of the proceeding sheet of the case. It has been recorded and this is available. Well, now we will keep this application or the statement of the first accused in juxtaposition with the third application. Well, your lordship would get the third application at page 142.
Disconnected.
If my lord were to keep in juxtaposition and read this third application along with
The objections,
the objections that are filed
then
by
it is the same.
verbatim reproduction, ಇಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಸಿಂಗ್ಯುಲರ್ ಪ್ಲೂರಲ್ ಆಗಿದೆ, ಪ್ಲೂರಲ್ ಸಿಂಗ್ಯುಲರ್ ಆಗಿದೆ. ಅಷ್ಟು ಬಿಟ್ಟರೆ ಫಸ್ಟ್ ಪರ್ಸನ್ ಏನಾಗಿದೆ, ಥರ್ಡ್ ಪರ್ಸನ್ ಆಗಿದೆ, ಥರ್ಡ್ ಪರ್ಸನ್ ಏನಾಗಿದೆ, ಫಸ್ಟ್ ಅಲ್ಲಿ ಐ ಅಂತ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಇಲ್ಲಿ ಫಸ್ಟ್ ಥರ್ಡ್ ಪರ್ಸನ್ ಆಗಿದೆ ಅಷ್ಟೇ. ಅಷ್ಟು ಬಿಟ್ಟರೆ ಬೇರೆ ವ್ಯತ್ಯಾಸ ಇದೇನು ಇಲ್ಲ. ಸೊ can they contend, my lord, that in the second application which they had filed, the details of the evidence which he would be required to give or which he is going to give was not made available to the court, and that this was made available to the court for the first time in his third application cannot be accepted, would be my respectful submission. This was very much available. The second application stood rejected, virtually stood rejected, consequent to the order which came to be passed by this honorable court. Well, now, what is it that he would say in the third application? Let us see now. Well, may I request your lordship to kindly, yesterday I invited your lordship's kind attention to a couple of judgments of the High Court, that unless and until the prosecution certifies that without the evidence of the approver, it is just not possible for them to bring home the guilt of the accused who are put on trial in the case, or well, it would certainly lend credence to the evidence with the investigators collected during the course of the investigation of the crime. May I just invite my lord's kind attention to the chart of evidence which they have filed. This is the chart of evidence which they have filed before the trial court by the prosecution.
Yes, sir.
Well, if this came to be filed, this would indicate, my lord, the evidence with the investigators collected in the course of the investigation of the crime. This came to be filed on 7th of December 2024. Well, kindly permit me to take your lordship to the caption. Number one, the first caption is in the first page, motive. Well, they have cited 6 witnesses to speak to the motive. But this is by the CBI. This is by the CBI.
Yes, CBI.
Number 2, preparation and supply of 3 country-made pistols by A16 to A15 and other events. Well, they would cite about 13 witnesses. Number 3, change of motive as to the alleged murder of Yogesh Gowda. 5 witnesses.
So, if I may say, your suggestion is that ಬೇಕಾದಷ್ಟು ಎವಿಡೆನ್ಸ್ ಇದೆ, ಇಲ್ಲದೆ ಇದ್ರೆ ಮಾತ್ರ ಪಾರ್ಡನ್ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಕೋಬೇಕು. That's all.
That is not, ಇಲ್ದೇ ಇದ್ರಂತ ನಾನು ಹೇಳ್ತಾ ಇಲ್ಲ ನಾನು.
ಅಲ್ಲ,
It is difficult. Without the evidence of this.
difficult to convict someone with the evidence that is available. So pardon should be accepted. He would make full disclosure, which may lead to the logical conclusion of the trial. What you're saying is there are so many witnesses here, there are eyewitnesses, any evidence is there.
No, ಇಷ್ಟು ಬಿಟ್ಟರೆ ಅಪ್ಲಿಕೇಶನ್ ಏನಿಲ್ಲ, ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ ಇಷ್ಟು ಬಿಟ್ಟರೆ ಬೇರೆ ಏನಿಲ್ಲ.
ಅದಕ್ಕೆ ಹೇಳ್ತೀವಿ, ಎಲ್ಲ ಎವಿಡೆನ್ಸ್ ಇರ್ಬೇಕಾದ್ರೆ ಪಾರ್ಡನ್ ಕೊಡೋ ಅವಶ್ಯಕತೆ
ಇಲ್ಲ. But he is discharged. And others are going to sent to gallows. Yesterday, I invited my lord's kind attention to the charges that are framed against him.
Yes.
It can't be said that he is not the principal offender in the case. He is the man who would take a club and hammer on the head of the deceased.
In the state charge sheet.
In this, no.
Alla, charges that is also alive still.
That is also alleged, the additional charges which came to be framed.
That is also alive.
Yes. 302 read with 120B. But I even placed on record in the case, in the form of the postmortem report, that his skull has been broken into pieces.
Yes.
But the additional charge against him is under the provisions of the Arms Act.
Now, by the CBI.
By the CBI. But he is the man from whose possession some country-made pistols came to be recovered by the CBI during the course of the further investigation.
So ಅದಕ್ಕೆ Arms Act.
ಅದಕ್ಕೆ Arms Act. So our possession ಇಂದಾನೆ ತಗೊಂಡ್ಬಂದಿರೋದು. What happens? ಅದಕ್ಕೆ evidence. Now kindly go to the next chapter. Kindly go to the next chapter. But first, number 2, just now I read to your lordship, number 2, preparation. But first page. Preparation, supply of 3 country-made pistols, A15 to A16 and other events. Possession ಅವ್ರದ್ದು, ಅವರಿಂದಾನೆ ರಿಕವರಿ ಆಗಿರೋದು, ಅವನಿಂದಾನೆ, ಅವನದೇ ಜಾಗ, ಅವನ ಮನೆ.
So he wants to walk away now free.
Walk away now? And but ತಂದು ಕೊಟ್ಟವನು ಮಾತ್ರ send him to gallows. Then my lord, ಅಲ್ಲಿ 13 ಜನ ಇದ್ದಾರೆ ಅದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ ಹಾಗೆ. Then my lord, change of motive. Original motive was something different. That the motive was in relation to certain land dispute. Now that is not the motive now. The motive is political rivalry. For political rivalry, my lord, to speak to the motive aspect of the case of the prosecution, 5 witnesses have been examined. But they have cited several witnesses, including the chief executive officer of the Jilla Panchayat, who is a senior IAS officer. Well, next, my lord, eyewitnesses. 8 eyewitnesses they have cited. Then, my lord, stay of Basavaraj Muttagi and his associates in various hotels. That is what he wants to speak. Nothing more and nothing less. Then, my lord, subsequent events of murder, 11 witnesses. Influencing Mallava Gaudar, 8 witnesses. Intimidation of witnesses, 10 witnesses. Seizure of black color bag with weapons, 10 witnesses. Same thing he speaks in his application and in his deposition. Then, my lord, travel of A15 to Delhi and Bangalore and the tour program submitted by A15 for the month of June 2016, 6 witnesses. Transfer of the public prosecutor, let it be there, my lord, in respect of Yogesh Gaudar murder case trial held in Dharwad court at the instance of A15. 3 witnesses. Expert witnesses, 5 witnesses. Witnesses relating to the news footage publication as to Yogesh Gaudar's murder case. There are 2 witnesses. Receipt of bribe amount by the accused Tinglekar, that is an inspector, my lord, 2 witnesses. Attempt made by A15 to settle the differences with Gurunath Gaudar, 3 witnesses. Meeting between A15 and other persons in the diary of A15 relating to the involvement of the vehicle, black color Hyundai car in Yogesh Gaudar murder case.
There are 158 witnesses. Out of them, 8 witnesses are eyewitnesses. When there is copious evidence to continue the prosecution, why you need his evidence is the submission.
Why should, well, the trial court ought to have admitted to these things before exercising its jurisdiction allowed under section 306 or under section 307 of the CRPC. The trial court ought to have adverted to this. No, well, actually, invite my lord's kind attention to the finding of the trial court. Well, the finding is in my favor.
Finding is in a favor.
Yes, my lord. Result is against me. May I request your lordship to kindly turn to page number.
I hope I'm audible, my lords.
Yes, sir. Yes, sir.
My learned friend is making elaborate arguments in the guise of rejoinder. So it is as good as fresh arguments. I may be permitted to rebut these arguments because there are several points which are, according to me, not correct and not properly placed.
My lord, it is not a rejoinder, a replay. Halfway through, I had stopped my arguments, and your lordship said, all right, you can continue your arguments on the next day.
After
continue his
Therefore,
arguments, was your lordship
I will have my chance to rebut these arguments, my lord, because now
Yes. It is not a rejoinder argument.
Original arguments.
ನಿಮ್ದು rejoinder ಆಗತ್ತೆ.
Because we have not given reply, my lord, member, senior.
These are all fresh arguments, fresh documents produced over
No,
the
senior-
counter, unheard of. He must give us copies.
No,
Like
sir,
evidence,
senior
etc.
CV
I'm not-
Nagesh sir had not completed his submissions. That is why I am permitting him to complete his
But on that day, I was unwell.
Then, my lord, I may be permitted to reply
I
to
went
those.
to
Yes,
Gulbarga.
yes, no problem.
Yes.
After obtaining your lordship's leave, I went to Gulbarga. After I came back, my lord, I fell sick. Then, my lord, your lordship said.
You
"No,
had
it's not
stopped
right.
your argument in
You
the
can,
middle.
continue your argument.
In fact, the
Sandha.
Shyam Sundar sir and Chowta sir have finished it. ಈಗ
ಎಲ್ಲೆಲ್ಲೋ ಮಾಯ ಮಾಡಕ್ ಬರ್ತೀರಲ್ಲ.
ಇಲ್ಲ, I said you have finished. You are finished ಅಂತ ಏನ್ ಕೇಳಿಸಿಲ್ಲ ತಾನೆ. ಅದು ಸಾಧ್ಯನೇ ಇಲ್ಲ ಅದಕ್ಕೆ. Yes.
My lord, in his, please go.
Give a reply to the argument of the learned.
ಬೇಡ ಸರ್ ಮುಗಿಸ್ಲಿ.
ಅಲ್ಲ, ASG, we are ready, my lord.
Yes, yes. ಈಗ I'll let Nagesh sir complete. ಆಮೇಲೆ reply to the learned ASG's argument. Then I'll permit the ASG to reply to Nagesh sir's argument.
Grateful, my lords.
Sorry?
I said grateful, my lords.
ಎಲ್ಲ ಆದ್ರೆ where will I be able to take other cases?
Hornbill ಅಲ್ಲ?
Correct. ಆಯ್ತು. Yes,
My
sir.
lord, in his third application, the first thing he would refer to is about the stay in Hornbill Resort. One of the sentence, ಜಾಸ್ತಿ ಹೇಳೋದಿಲ್ಲ ನಾನು. My lord, in relation to the stay in the Hornbill Resort, either of the first accused or his other companion accused in the case, the prosecution during the trial has now examined PW 17 and PW 18. A certain Upendra Rao and Yogesh Kumar. But the second statement which he would make in his application is that I would like to speak about the stay in Panchavati Hotel after this Hornbill Resort. Well, for and in connection with the stay of either the first accused or his other companion accused in the case, the prosecution during trial now would examine 3 witnesses. My lord, they are Bharat, CW 9, Anup, CW 10, and Girish, CW 11. But the next event which he wants to depose before the court is about the movement of a black color Chevrolet car. But for and in connection with the movement of this car, a certain witness by name Chandrasekhar Pujar is examined by the investigator as CW 15. But sir, with regard to the certain land dispute, but the investigator would examine the 2 witnesses, they being CW 13 and CW 50, Pramod and Mahesh.
Yes.
Well, the next piece of evidence which the prosecution wants to get from the mouth of the approver is with regard to the transfer of the country-made pistols and its possession my lord, the investigator would examine CW 56, 57, and 43. They're examined, they're already examined during the trial of the case as PW 25, PW 26, and PW 9. Well, the next piece of evidence which he wants to give is with regard to the political rivalry. Kindly pause for a minute. It would be useful for me to invite my lord's kind attention. Well, at the few days earlier or few months earlier to the date of the commission of the crime, there was a Jilla Panchayat meeting. But in that meeting, the persons who were invited to participate in that meeting being, well, the presidents of the Jilla Panchayat, Taluk Panchayat, and Village Panchayat to discuss certain issues relating to their villages or their hobli or their taluk. Well, that was presided over by the ministry in charge of the district. The participants in that meeting being, well, the chief executive officer, a senior IAS officer, the superintendent of police, the deputy superintendent of police, all presidents of the Jilla Panchayat, Taluk Panchayat, and Village Panchayat. Well, all these persons, and in that meeting, my lord, the deceased would raise a query against the district in charge minister, and district in charge minister would tell him, you shut up and keep quiet, others are there to attend to it, is their case. Well, I am not on the merits of the matter as to what they have said and what they have not said. Far and in, because that is the motive that is presently projected, far and in connection with what transpired in that meeting, which is now sought to be projected as a motive for the commission of the crime to implicate the 15th accused, are number one, PW1, Malava, CW21, Gurunath Gowda, CW41, Shankaraya, CW42, Shivananda, CW43, Gangappa, CW47, Jagadish, CW61, Mahendra Naidu, CW127, Anjana, CW72, Dr. Satish, who is the CEO. Well, I have placed on record in the case before your lordship now the record that is available in the trial court vis-a-vis the statements of all these witnesses. I have brought it. What is the record here? Well, the additional documents
Here.
which I have filed, well, I have produced.
No,
Not-
all this submission is to say that there is copious evidence.
Copious evidence. That is the minimum. Now, my lord, we will go to the findings of the trial court. What the trial court says is, unfortunately, it is a case that rests on circumstantial evidence. There are no eyewitnesses to the incident. Who is more loyal than the king is the question now here. Well, the prosecution would cite 8 eyewitnesses. The learned judge says there are no eyewitnesses to the incident. It rests on circumstantial evidence. The circumstances are the one that is mentioned by the first accused, for which there is no evidence. That is wholly incorrect. May I request your lordship to kindly go to first page, only 2 or 3 sentences from 4 or 5 pages. Kindly go to page 88 first for a second.
Yes.
Well, internal page 39.
Yes.
Page 88.
Yes.
From the top, my lord. Held at the second application, my lord's order, he quotes, second application seeking pardon under section 360 RPC is maintainable only on change of circumstances, as also in the kind of circumstances that is projected in the case on hand. In order to maintain the said application, firstly, the accused number 1 is required to point out the change in circumstances. As rightly argued by the learned senior counsel, the applicant has to point out the change in circumstance on which the present application is filed, and the same should not be available at the time of making the earlier application. Well, kindly pause for a minute.
Yes.
Well, it is not that he forgetting to mention. Not that there is an omission in his part in making a mention. Was it available to him or not is a question. If it was available to him, if he has not chosen to make that in the application, incorporate that in the application, can he maintain the next application?
Res judicata. Yes.
Admittedly, in the above case, when the application was filed by the accused number 1 at the first instance, nothing was narrated in the application. That application came to be rejected. Then, my lord, the accused who is seeking pardon is required to point out the circumstances on which he is seeking the pardon. However, at the first instance, nothing was narrated and a bald application was filed which came to be rejected by this court. Thereafter, the second application was filed, wherein once again, no detailed averments were made. However, the accused number 1 has stated that he would disclose the true and material fact if he was provided with an opportunity to get his statement recorded under section 164(5) of the CRPC. That is again incorrect, because in the counter which came to be filed by the respondent state, well, they would enclose the undated application filed by him before them.
That's what I have observed in the earlier order.
All the details. On the basis of the same,
230 mood matters one. Mood matter. Sir, as usual, we'll continue it tomorrow.
Please, please.
Because 2:30, lot of
Please,
advocates.
please, please. ಹಂಗೆ ಕೊಡಿ.
ನಾಳೆ ಒಂದು ಕೆಲಸ. Tomorrow, sir, tomorrow can we do this way? We'll start at 4:15.
Please.
And I'll continue, I'll sit up to 6
I don't know
o'clock.
how
No, up to
Lordship
6
would
o'clock.
accept my request.
Yes, sir.
Because my lord is sitting on Saturday. If Saturday is a free day for my lord. they are not
Saturday is a
required-
working day.
Working day, my lord.
Yes.
It may, free day in the sense, my lord, this court may not be overloaded or overburdened with more work ಅಂತ ಅಷ್ಟೇ ಇನ್ನೇನಿಲ್ಲ.
No, that we don't know. But,
ಅಲ್ಲ,
ಅಲ್ಲ,
ನಮಗೆ-
ನಾಳೆ 4 ಗಂಟೆಗೆ ಹಾಕಿರ್ತೀನಿ.
ಮಾಡು.
ಎಲ್ಲ
ಅಲ್ಲ, I am at your lordship's disposal, my lord.
4:15
Anytime my lord wants me to be here, I am here.
No, 4:15 I will start.
Please.
So that I'll complete the 2:30 mood matters and everything. Let not others wait.
Please.
I'll sit up to 6 o'clock and close it. Ellaru mugisbidi. That should be all right, sir. Raju, sir.
It's all right. Only thing
Yes.
I might require some time for.
Yes, we'll give, sir.
I may
Tomorrow or day after the same pattern will do. Yes.
But I will require some time, few days, because I'm held up in the Supreme Court.
After tomorrow, I will hear the respondent's reply, other petitioners' reply, other two, to
Yes.
what submissions you have made. Chowta sir and you can come from wherever you are, sir.
Then my lords may give me a date of my convenience. I'll
Yes,
come.
sir. Yes, sir.
Very well.
Yes.
Report upon, sir.
In the air, appear from air, sir. So what? That's why I said you can appear from anywhere,
He's
including air.
He is capable, my lord.
Arre, what, sir? Avaru illa andre na
Has- God has bestowed him, my lord, such kind of powers.
The threat perception has not been endorsed by the CBI in their objections. The threat perception is a new ground. But in their objection, in their not objection to in their supporting document. But I would say it as a supporting document. The threat perception is not told at all. It is heeded only by the accused.
Rating ಅಲ್ಲಿ ಹಾಕಿರೋದು ತಾವು ರೇಟಿಂಗ್ ಅಲ್ಲಿ ಹಾಕಿರೋದು ಸರಿ
ಅಲ್ಲ ಥ್ರೆಡ್ ಪರ್ಸೆಪ್ಷನ್ ಎವಿಡೆನ್ಸ್ ಕೊಡಿ ಅಂದ್ರೆ ಎಲ್ಲಿಂದ ಕೊಡ್ತಾರೆ?
That, my lord, 300.
No, that I have said it's a continuing circumstance.
A plain reading of section 306, my lord, would say that may not be a ground. It is in or in relation to the offense that has been committed. That perception, that as my lord has pointed, continues till the judgment is pronounced.
That's what.
In the case, last day of the pronouncement of judgment, he can say that I want to be an approver in the case. I did not disclose
No,
this
the
day because of the.
Provision permits. Prosecution is saying so.
Change in ground is not forthcoming. The change in ground But which is the sole basis for the third application. It's not being endorsed by the prosecutor.
All right. Yes.
So then, my lord, the constructive res judicata.
You can construct from here tomorrow. All right. You will have land ಆಗಿರ್ತೀರಾ? I thought you're not going out of the country. Hyderabad ಬಗ್ಗೆನಾ?
इनका मतलब
The one who certifies is the prosecutor. My lord, it is not the state, it's not the prosecuting agency. So, my lord, we see that that's how the language. My lord,
He represents.
Certifies what? ಆ ಸ್ಟೇಜೇ ಬಂದಿಲ್ವಲ್ಲ ಈಗ ಮತ್ತೆ ದಟ್ಸ್ 1 minute 308 ಸ್ಟೇಜ್ ಬಂದೇ ಇಲ್ವಾ ಈಗ ಮತ್ತೆ ವೈಲೇಷನ್ ಆಫ್ ಪಾರ್ಡನ್ ಅಂದ್ರೆ ಯಾವ ವಿಚ್ ರೆಸ್ಪಾನ್ಸ್
The prosecutor who is saying, it is the CBI officer who is saying it, one Mr. Jha. My lord, how can a CBI officer become vocal to, my lord, a request synthesis that happens in the court? It is the prosecutor, my lord, that's what, my lord.
ಪ್ರಾಸಿಕ್ಯೂಟರ್ ಯಾರು ಸರ್?
But prosecutor is independent.
Who is the prosecutor here?
The state.
CBI prosecutor.
All right.
It is the CBI prosecutor who should have said, yes, there is that paucity of evidence, we want it. In this case, my lord, it is not that. One Jha.
ಹೆಸರು ಜಾ.
The ACP of CBI says, yes, he is required for all these things.
He may have a point.
No, you can drop your submissions day after tomorrow. ಮತ್ ನೀವು ಪ್ಲೇನ್ ಇಂದ ಅಪಿಯರ್ ಆಗ್ಬೇಡಿ ಇಲ್ಲಿ. ಎಸ್ ಎಸ್
grateful, my lords.
ಎಸ್ ನಾಳೆ 4:15 ಸ್ಟಾರ್ಟ್ ಮಾಡಿ.
mood matters.
ತಾಹಿರ್ ನಿಮ್ದು ರಿವ್ಯೂ ನಾಳೆ ಹಾಕೊಂತೀನಿ ಮತ್ತೆ. ಐ ವಿಲ್ ಪಾಸ್ ಆರ್ಡರ್ಸ್ ಟುಮಾರೋ.
Tahir ಇದಾರ ಇಲ್ಲಿ?
ತಾಹಿರ್ ಎಲ್ಲಿ ಹೋಗ್ತಾರೆ?
I was
ಅವ್ರು
told
ಇಲ್ಲೇ
in the morning that he is in Hyderabad court, the division bench.
Yes.
Defendant is always.
Hey, that's all right. Wait, don't in the lighter way, sir. Why do you take it?
Lighter way, because he himself
It is good.
challenged
Tahir
the
is all over.
My friend has made
No,
it
his colleague made a
very-
submission.
very
He is
clearly
physically
that
not in Bangalore. He is in Hyderabad. He can
Don't
check.
worry.
Through VC I was appearing, while London is aware about this. just-
No, I am not aware. How
In
will
the
I
lighter
aware what
ways.
is where he?
Tahir, take something lightly also. 4:45 ಅದಕ್ಕೆ. Yes.
Not for, but before that.
4:35. Yes. No. This I'll post it tomorrow. Your review I'll post it tomorrow.
2:30.
2:30. Yes.
More review matter is also there, my lord, the lordship's permission.
ಒಂದು ನಿಮಿಷ 2:30 ಮೂಡ್ ಮ್ಯಾಟರ್ಸ್ ಮುಗಿಸ್ಬಿಡ್ತೀನಿ. ವೇಟ್. Parole.
What passport?
SVP, ಶಾರ್ಟ್ ವ್ಯಾಲಿಡಿಟಿ ಪಾಸ್ಪೋರ್ಟ್. ಚಾರ್ಜ್ ಶೀಟ್ ಇದೆಯಾ? ಏನು ಅಫೆನ್ಸ್ ಮೇಡಮ್?
23, 24, 504, 506.
ಅಷ್ಟೇನಾ?
ಅಷ್ಟೇ.
ಅದಕ್ಕೆ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದಾರಾ? ಸ್ಟೇ ಕೇಳಿಲ್ವಾ ನೀವು?
ಅದು ಕಾಶಿ ಹಾಕ್ಲಿಲ್ಲ.
ಮತ್ತೆ ಇನ್ನೂ ಆಗಿಲ್ವಾ?
ಇಲ್ಲ ಅವರು. He has to accompany his mother to
Correct,
go to
but
Opera. He is aware, I have told him.
ಶಾಂತಿ ಭೂಷಣ್ ಹೇಳಿದ್ರಾ?
ಹೌದು, ಅದು ಹೇಳಿದ್ದೇನೆ, ಬರ್ತೇನೆ ಅಂತ ಹೇಳಿದ್ರು. He was
ಬರ್ಲಿ,
there
ಅವ್ರು
that
ಬಂದ್ರೆ ಅವ್ರು ಡೈರೆಕ್ಷನ್ ಕೊಡ್ತೇನೆ. Before I rise, I'll pass orders.
Should I wait, my lord?
Wait. ನಾಳೆ ಬರ್ತೀರಾ?
ಇಲ್ಲ.
ಮತ್ತೆ ವೇಟ್ ಮಾಡಿ.
Yes.
ಶಾಂತಿ ಭೂಷಣ್ ಆಚೆ ಇರ್ತಾರೆ, ಕರ್ಕೊಂಬನ್ನಿ.
Sure, I'll get it.
ವೇಟ್. ಶಾರ್ಟ್ ವ್ಯಾಲಿಡಿಟಿಗೆ ಶಾರ್ಟ್ ಪೀರಿಯಡ್ ಆದ್ರೂ ವೇಟ್ ಮಾಡಿ. ಎಸ್.
My lord, sale has taken place.
Already taken place. ಏನು?
Not to issue sale certificate, my lord.
ಎಷ್ಟಿದೆ?
2 crores 43 lakh, my lord. It's their
ಸ್ಮಾಲ್
extent of
ಫೈನಾನ್ಸ್
property.
ಬ್ಯಾಂಕ್ 2 crores ಕೊಟ್ಟಿದ್ದಾರೆ ನಿಮ್ಗೆ. ಅಂದ್ರೆ ಎಷ್ಟು ವರ್ಷದಿಂದ ಕಟ್ಟಿಲ್ಲ?
Last 1 year. They have taken possession, my lordship. Now
ಕರೆಕ್ಟ್,
they are-
ಕರೆಕ್ಟ್ ಆಗಿ ತಗೊಂಡಿದ್ದಾರೆ.
they are ready to, we are given a 2 crores for settlement. We are not able to make payment in time. So that.
Then ಇವಾಗ ಏನ್ ಪೇಮೆಂಟ್ ಮಾಡಕ್ಕಾಗತ್ತೆ?
We are ready, my lordship. After taking possession.
ಎಷ್ಟು 50 ಲಕ್ಷ ಕೊಡ್ತೀರಾ?
20 lakhs, man.
25 lakhs now you pay in next 3 weeks. ಆಮೇಲೆ post it after 3 weeks, let's see.
4 weeks.
No.
Please.
The petitioner is before this court calling in question the possession ಇದು
Alla, sale note.
sale notice dated 29/3/2024. The sale is said to have taken place. Not yet ಅಲ್ಲ, ಇನ್ನೂ ಇಲ್ಲ.
They have taken, as per their notice annexure B.
The sale is slated to be held on 29th March, but possession of the property has been taken and the amount in due is supposed to be 2 crores. Therefore, there shall be an interim order of stay as prayed for, subject to the condition that the petitioner would deposit 25 lakhs on or before the 4th of April, list the matter on 4th of April.
4 weeks time.
In the event 25 lakhs is not deposited by the said date, same conditions. Yes. Next.
For 3, Dish Gowda CP.
It's regard to, my lord, the performance of Karga Mahotsava. my lord.
Karga.
Date fixed, my lord, on 4/4.
Notice ತಗೊಳ್ಳಿ. ಏನ್ ಮಾಡ್ಬೇಕೀಗ?
ಇವಾಗ ಡೈರೆಕ್ಷನ್ ಅನ್ನು ಕೊಟ್ರೆ ಅಲ್ಲಿ ಆರ್ಡರ್ ಮಾಡ್ತಾರೆ.
ಏನ್ ಡೈರೆಕ್ಷನ್ ಕೊಡ್ಬೇಕು?
I sought for, I gave a representation.
For what? Police protection?
No. For performance, carry Karga.
Who are you?
My lord, I am the secretary of the.
Who carried it on the last occasion?
Myself only.
Look into it, Jafar. Who appears here? ಅವರಲ್ಲಿ Religious and charitable endowments. Look into this. I'll take it day after tomorrow morning. It's on the 4th, but by then we'll pass some order. Day after tomorrow in the fresh matters list, Learned AGA to secure instructions with regard to submissions of the petitioner. Next.
For 4, Sir M. Deshpande.
For petitioners, my lord, the lapse tender, my lord, there was an interim order, my lord, at page number 150.
Lapse tender.
90 days period. ಅದ್ರಲ್ಲಿ ಏನು ಆಗ್ಲಿಲ್ಲ. By rule 22, it has lapsed.
Correct.
So subsequently in December, they tried to issue work order. I had filed a writ petition.
I had stayed it.
At page number 159, there is an interim order.
ಹೌದು. ಈಗ ಏನ್ ಮಾಡಿದ್ದಾರೆ?
Despite the interim order, annexure work order has been issued.
Page?
Page 20, ಮೇಡಮ್, annexure.
ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ ಇಲ್ಲಿ? ಯಾರು ಇವರಲ್ಲ, ಗವರ್ಮೆಂಟ್ ಅಲ್ವಾ?
ಕೊಟ್ಟಿದೆ.
ಮತ್ತೆ ಯಾರು? Yes. Where is the interim order? Page
159, my lord. Referring to the judgment of Sambhava Constructions, my lord. Under rule 22, they shall.
160, is it?
160, my lord.
The petitioner was before this court in writ petition 33857 of 2024. This court passed the coordinate bench of this court passed the following order. The learned counsel for the petitioner submits, despite the grant of an interim order and it being brought to the notice of the respondent state, they have gone on to issue the work order to the successful bidder. The work order is issued on
Annexure
page
20, mil.
The work order is issued on
18/2, mil.
On 18/2/2025. Long after the grant of interim order, which was granted in the presence of the state. Therefore, the state shall explain as to why action should not be taken as the act of the respondent fringes on the borders of contempt by the next date of hearing. There shall be an interim order of stay as prayed for till the next date. The list the matter on 4th April. Shanti Bhushan. Tomorrow morning ಆಗಲ್ಲ 2:30 ತಗೊಂಡು. Yes.
5. Siddharth Sinha.
Please, Lord. Lord, pertains to a notice dated 2/12/2024 issued by MESCOM to me, my Lord. Lord, my contract with them, Lord, my contract with them was to refurbish and repair transformers. Anything in the guarantee period, my Lord, I have to do it for free. I have already serviced 963 transformers. Lord, out of which
Guarantee period ಆದ್ಮೇಲೆ
guarantee period ಆದ್ಮೇಲೆ, my Lord, I do not have to because then they'll have to pay me for it. So whatever is
guarantee period ಮುಗಿದಿದ್ಯಾ ಅವಾಗ?
ಮುಗ್ದಿದ್ ಮಲಡ್ insofar as I produce all of it ಮಲಡ್.
ಕಮಿಷನ್ ಆಗಿದ್ದು ಯಾವತ್ತು?
Commission ಆಗಿದ್ದು ಮಲಡ್. Now, if my lords were to kindly come to annexure
You
C.
give me simple dates. When was the electricity
No, it's all
commission?
separate mlord, because 963 is not all together. 963 is on separate dates. I
All
produced it
right.
for
Now,
Udupi, Karkala.
when did the warranty period expire?
Mlord, warranty period for certain of these transformers. Mlord, I'm not on that at all.
You
I'm
tell
on
me the last one.
I'm on transformers in respect of which 3 coils have burnt. Mlord. So this
Three
does-
coils have burned.
3 coils have burnt. So if 3 coils
When-
have burnt,
When did they burn?
Mlord, that is during the course of after I finished it, Mlord. So that 18
After warranty or before warranty?
But
ಅದನ್ನ ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
it may not be per se on warranty, Mlord, because this will not come into the contract at all. Contract would only say this.
ಈಗೇನ್
Contract
ಬ್ಯಾಂಕ್
says-
ಗ್ಯಾರಂಟಿ ಎನ್ಕ್ಯಾಶ್ ಮಾಡ್ಕೊಂತ
They have already encashed it. Now they want to blacklist me, Manod. So that blacklisting is what I am on, Manod, because they've already given me an extension saying that yes,
Mescom
work
ಯಾರು
is
appear
satisfactory.
Mescom who appears?
Morning we have served also here. I found out if anyone else is there, Manod, nobody represents. The morning we have already served the council.
Learned counsel for the petitioner to serve on any panel council representing Mangaluru Electricity Companies, Mescom, so and so. The learned counsel for the petitioner submits that the petitioner respondents are now wanting to encash the bank guarantee. The respondents have already encashed the bank guarantee on the score that coil of three transformers are
53,
burnt.
Manod, 53. 3 coils in 53 transformers.
3 coils in 53 transformers are burnt. And now the buck is put on the petitioner
Yes.
on the score that they are burnt during the warranty period. The learned counsel submits that the warranty period had long been over, and therefore the servicing ought to have been only on certain payment.
It is only on bad workmanship, Manod.
On certain payment. The learned, till the appearance of the respondent, there shall be an interim order of stay of any coercive
Annexure
coercive action to be taken against the petitioner, blacklisting or otherwise.
Please, obliged.
List on 25th in the fresh matters list,
It was 27th, Manod.
27th,
Please,
all right.
obliged.
Fresh matters list. Next. ಇದೇನು ಎಲೆಕ್ಟ್ರಿಸಿಟಿ
Electricity.
ಕಟ್ ಮಾಡಿದಾರ?
Cut ಮಾಡಿದ್ರು.
ಮಾಡ್ಬಿಟ್ಟಿದಾರ?
ಮಾಡ್ಬಿಡಿ.
Why?
ನೋಡಿ, the property belongs to the petitioner. ಈ ಖಾತೆ ಅಷ್ಟೇ. Other three don't. They are not obtained any plan for the purpose of construction is concerned.
ಇನ್ ಹೆಂಗ್ ಮತ್ತೆ ರೆಗ್ಯುಲೇಟ್ ಮಾಡೋದು
The
ಹೇಳಿ?
matter is already.
ಕೋರ್ಸಿವ್ ರೆಗ್ಯುಲೇಷನ್ ಆಗದೆ ಹೋದ್ರೆ ಆಗೋದೇ ಇಲ್ಲ. One, H.V. Devraj is directed to accept notice for the respondent. List the matter. Disconnect, reconnect ಮಾಡಕ್ ಹೇಳ್ಬೇಕಲ್ಲ?
Please.
Arrears ಇದೆಯಾ ಬೇರೆ
ಇಲ್ಲ,
ಏನಿದೆ?
arrears.
H.V. Devraj is directed to accept notice for the respondent. List the matter next Wednesday ಹಾಕಿ. There shall be an interim order of stay spread for till the next date of it. Next.
The freezing of bank account by the deputy registrar, my lord, in the earlier occasion, my lord, your lordship passed an interim order. This, my lord, in spite of that, my lord, she directed the bank to freeze our account.
Where is where is the direction?
Annexure Q is, my lord, direction is in respect of the dispute of management, my lord.
Where is the direction?
Yeah,
directing
annexure
the-
A, my lord, annexure A, my lord, in page 16, my lord,
ಯಾರಿಗೆ ಹೇಳಿದಾರೆ ಇದನ್ನ?
bank, my lord. Fourth respond, bank. She has made it personally, therefore I made her as a personally as also a party, my lord.
Fourth respond bank ಅಂತ ಎಲ್ಲಿದೆ ಇಲ್ಲಿ?
Fourth respond, bank. Address to branch manager.
ಅಡ್ರೆಸ್ ಟು ಬ್ರಾಂಚ್ ಮ್ಯಾನೇಜರ್.
Yes.
ಆಡಳಿತ ಮಂಡಳಿ ಲೆಕ್ಕ ಪರಿಶೀಲಿ ಎಲ್ಲಿದೆ ಬ್ಯಾಂಕ್? ಏನಕ್ಷರ ಏನ?
Annexure A, my lord.
ಏನ್?
Yes.
ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದು ಎಲ್ಲಿದೆ?
Annexure Q, my lord, 69, my lord. She is anticipating further direction from the yesterday. She has written a letter, one more letter.
ಕೊಡಿ.
Yes.
This court, in terms of its order dated 10/3/2025, granted interim order of stay.
11/3.
On 11/3/2025, granted interim order of stay which reads as follows. The direction therein that was stayed was one that directed freezement of the account of the petitioner.
Earlier, not freezement. Earlier regarding it, we terminated the members. They approached the civil court. Civil court did not grant an interim order. They approached the deputy registrar. Deputy registrar stayed their
Their termination.
Their termination.
The This court, in terms of its order dated 11/3/2025, state the order of termination, state the order directing stay of termination of those employees who had been terminated.
Members.
Members who had been terminated despite the civil court not granting any order in their favor. After the grant of the interim order comes the impugned communication dated 7/3/2025, directing the accounts of the petitioner to be frozen, the accounts that are maintained at the Canara Bank. The reason is verbatim similar to what formed the reason for grant of an interim order in the earlier petition. Therefore, the state shall secure instructions as to why action for committing contempt of the court should not be initiated against the person who is wanting to overreach the orders passed by this court by indirect or circuitous methods. There shall be an interim order of stay as prayed for. Since the third respondent is made party by name alleging malefides, objections be filed by the third respondent by the next date of hearing. Emergent 1 AGA, 1, 2 AGA, 3 emergent notice returnable by 8th April.
Bankman.
Emergent notice.
Yes. And remember, since 10 days, bank.
We'll see. Yes. No. It could ನಾಳೆ ಸಿಗುತ್ತೆ.
Covered by judgment, my lord.
Covered by ಯಾಕೆ ಮೂವ್ ಮಾಡಿದ್ರಿ 2:30ಗೆ?
My lord, they are threatening us.
Covered by why do you move it at
They are
2:30?
threatening us to cancel the bid, my lord.
Where?
We are the successful bidder of the timber auction, my lord. They are demanding forest development tax, my lord.
FDT na? Page. FDT disposed.
Annexure D, my lord, the impugned.
I have disposed 10 petitions, 10 or 20 petitions in Dharwad. FDT, forest development tax cannot be demanded at all. Simple, yes. Which page you have?
Page number 140, my lord.
Judgment adena? Yes. Covered. The petitioner is before this court calling in question the action of the respondent forest department in directing payment of forest development tax. And in the event they would not pay, the petitioners are now directed to be evicted of the said premises.
Auction.
Timber, sorry.
Timber auction.
In the event they would not pay, the timber that is timber yaratride ಈಗ?
Timber.
The timber that ನೀವೇ ತೆಗ್ದಿದ್ದೀರ timber ಏನು?
We are the successful bidders, my lord.
Tender ಅಲ್ಲ.
Timber.
ಬರ್ಕೊಳ್ಳಿ madam. The petitioner is before this court seeking the following prayer. The petitioners are the successful bidders pursuant to a tender notification issued for the purpose of sale of timber. The timber is not being allowed to be lifted by the respondent corporation on the score that they should pay the forest development tax. The issue stands answered by plethora of judgments rendered by this court that forest development tax cannot be demanded on such tender processes. The page 140. The learned counsel for the petitioner seeks to place reliance upon the judgment rendered by the coordinate bench in so and so.
142.
Page 140. In that light, the petition deserves to succeed for the aforesaid same order of the lane there. Next.
Challenging, my lord, and police notice, which is at page 9.
Why police notice challenge?
My lord, at page 8 is the social media poster of a meeting that is being convened this evening at 5 o'clock. So last night at 10:30, the police sent me a notice saying that I cannot convene a meeting in my own office because of the fact that my lord would see at page 9.
ಏನ್ meeting ಮಾಡ್ತಾ ಇದ್ದೀರಾ madam?
But my lord would see, my lord would see the second paragraph of the police notice, if I may just read that. It says, Sadri ವಿಚಾರಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಕರ್ನಾಟಕ ಘನ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ರಿಟ್ ಅರ್ಜಿ ನಂಬರ್ so and so ದಿನಾಂಕ 4/7/2024 ಹಾಗೂ 21/2025 ನಿರ್ದೇಶವನ್ನು ಗಮನದಲ್ಲಿ ಇಟ್ಟುಕೊಂಡು ತಮಗೆ ಈ ರೀತಿ ಪ್ರತಿಭಟನೆ ಅವಕಾಶ ಇರುವುದಿಲ್ಲ ಒಂದು ವೇಳೆ ತಾವುಗಳು ಕಾನೂನು ಉಲ್ಲಂಘನೆ ಮಾಡಿ ಪ್ರತಿಭಟನೆ ಮಾಡಿದ್ದಲ್ಲಿ ಸೂಕ್ತ ಕಾನೂನು ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ಆಗುವುದು. My lord would see that I am not a party to this order.
May not
which has been
be.
passed.
May
But my
not.
lord would also see the order says the order in writ petition number.
ಏನು ಕನ್ವಿನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ಇದು ಧರ್ಮಸ್ಥಳದ?
My lord, the issue is this. I'm holding a meeting. I'm not
For
holding
what?
a protest.
For what?
But in respect of the poster is at page 8. I mean, it's the social media post that was circulated.
ಹೋರಾಟ ಏನಕ್ಕೆ ಹೋರಾಟ ದಿಕ್ಸೂಚಿ ಸಭೆ?
My lord would see.
Earlier ಅದನ್ನೇ ಮಾಡಿದ್ರಾ?
It's a meeting to formulate a direction.
Who are you to formulate directions?
Lord would see in the writ petition, I am not a party. And the order says if there is a violation of law and if the petitioners in that petition.
No, there is already an order passed by the coordinate bench in identical circumstances.
My lord.
You will get the same benefit that is passed by that court if there is anything.
My lord.
You will have the same benefit that is passed by the coordinate bench.
No, the order that the police notice refers to, the police notice refers only to one writ petition.
That's
1938.
just gave us order.
Yes, my lord. Which my lord would see the operative portion of the order. My lord would come to page 23. It says, I may read from the second line. In that regard, if any material is placed by the petitioners or any person aggrieved of any such action on the part of the 9th respondent or his followers, and if such information is placed before the police, it is the bounden duty of the respondent's police to take action immediately. Correct. I am not the 9th respondent. I am not the follower of the 9th.
That's all right. If
It states, no,
if
my
the subject matter is an offshoot of this order,
no,
can't help.
but my lord, when we lethum, the principle is settled. A judgment is only an authority for what it decides,
Oh,
not
seriously?
what follows.
All right.
It's therefrom.
Oh, no,
My
don't
lord.
worry about all that.
No, my lord, my
Don't tell rudimentary things to this court. Yes.
submission is this, my lord.
Yes.
There is, my lord, the judgment is very clear. The order passed by the coordinate court is very, very clear. It says if there is any information placed before the police, and if there is, my lord would see the previous statement. It says if there is any offense committed, then in accordance.
Madam,
with
coordinate bench on the same, you may be a party, you may not be a party. Coordinate bench on the same subject has passed some order.
My lord, it is the
Yes.
I am not for one moment derogating from the finding of that order.
Leave it then.
If there is an offense, my lord, I am convinced.
If there is an offense, they will take action.
My lord, but I am being.
Why are you apprehending that there will be an offense?
That is not the text of the police notice. My lord would see nothing. I was.
I will only say the coordinate bench's order will be followed. That's all.
My submission is.
That is all I am going to say.
My submission is.
My lord,
they
if I
said
may.
that I cannot convene this meeting.
Well, and 1 minute.
Yes, ma'am.
You heard it, madam. Yes.
No, they have said that pretty much in this notice, they said I cannot convene a meeting in my own office. My lord, this is not a protest in a public place. At best, a protest can be regulated
Madam,
in its manner.
I will clarify this police notice to be the one in consonance with the coordinate bench's direction.
My lord.
If there is any offense committed, they will take action.
My lord.
This will not come in, the coordinate bench's direction will be followed and this notice will not come in the way of you holding whatever.
My lord.
But if there is an offense committed, they will be at liberty to follow the coordinate bench's order and pass orders. That's all. Right? Yes, Velan?
My lord, in a connected matter, my lordship may take item number 12 and 14.
ನೀವು ಅದೇ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
Yes, my lord. I represent a trust. If I may seek my lordship's indulgence to page. No, my lord. I stand on a very different footing, my lord.
Then wait. Then
Yes.
wait. Yes. We'll pass this order. Yes, we'll clarify that it is in tune with, yes. The petitioner is before this court calling in question a notice dated 17th. And what notice is this? Police notice?
It's a police notice.
35-3.
There's no provision of law. It's just a notice which says, I know that you're holding a meeting. You can't hold a
Why?
meeting. There is
Wait, madam.
Circulated in social media. Police got to know that they are going to conduct a protest rally.
ಎಲ್ಲಿದೆ ಪ್ರೊಟೆಸ್ಟ್ ರ್ಯಾಲಿ ಅಂತ? ಸೋಷಿಯಲ್ ಮೀಡಿಯಲ್ ಪ್ರೊಟೆಸ್ಟ್ ರ್ಯಾಲಿ ಅಂತಿದ್ಯಾ? ವೇರ್ ಇಸ್ ಸೋಷಿಯಲ್ ವಿಳಾಸ ಸಿರೂರ್ ಪಾರ್ಕ್ ರೋಡ್ ಸ್ಥಳ ಸಭಾಂಗಣ ವೈ ಸಭಾಂಗಣ?
It's a meeting, my lord. It's being.
No, you said in your own house. You live in Sabangana?
Not in my own house,
Then?
my own office.
Office.
The general secretary of the petitioner number 1 is the general secretary of AITUC.
Hmm.
It's in the AITUC's registered office, and petitioner number 2 is an advocate.
There's a meeting that's being convened. The police say, we are not going to allow you to hold this meeting. If you hold this meeting, we have been telephonically informed after that WhatsApp message was sent to us, telephonically informed that we will be taken into preventive detention.
Petitioner telephonically informed.
My lord, the
Yes.
WhatsApp.
The petitioner is before this court calling in question a notice dated 17/3/2025, which in effect has is a direction to stop the meeting that is supposed to be held on 18/3/2025 today at about 5 p.m. The police notice refers to an order passed by the coordinate bench in writ petition 19382 of 2023, which comes to be disposed on 4/7/2024. The coordinate bench,
2025.
sorry,
21, 2000.
then what is that they are referring to?
That is an interim order, my lord.
Which comes to be disposed on 20th January 2025. The coordinate bench, while disposing the petition, observes as follows, para 11 quote 20. The coordinate bench holds that the petitioners the police are required to take action in accordance with law if the ninth respondent therein or his followers or any person makes any statement in the open public or publishes any derogatory statement which is in offense in accordance with law in that regard, and any material is placed by the petitioners or any person aggrieved thereon, it would be the bounden duty of the respondent police to take action immediately. The plea of the petitioner is that the petitioners are not the same respondents therein. The issue in the list is with regard to statements against whom is that? The issue in the list is identical to the issue that was projected before the coordinate bench. The meeting is said to be for the said purpose. Therefore, the petitioners, even though they are not parties to the said petition, are bound by the directions that are given by the directions given by the coordinate bench. Directions, I mean, to the respondent police. If the petitioners are seen to be violating the law as observed by the coordinate bench, it is for the respondent police to take action. Till such time, till such eventuality comes about, the police cannot obviously stall any meeting that is to be held in the office of the petitioners. With the aforesaid observation, petition stands disposed.
One submission, my lord. It's not identical because there are some statements. Here it's a meeting of
Correct.
people convened. There's a discussion.
No
There can
problem.
be no bar on free and frank discussion. I mean, it's not identical to the list.
Do it. Unless an offense is committed, they will not.
Insofar as where my lord says it's identical to the list in 19382.
No, we'll say it is different. Even if it is different, the same order. Yes. Next. In terms of.
Bank is asking for the stay of the auction sale.
Bank is asking stay. Why?
My lord, respondent number 4, my lord, availed a loan of 2 crore 10 lakhs from the petitioner bank. My lord, in the year 2020.
Sale notification matter.
Under Buds Act, my lord, there was a complaint, my lord, and.
Buds Act?
Oh.
Yes, learned AGA is HCGP is directed to accept notice for the respondents. Yavat is sale.
My lord, they have not confirmed, my lord, when is the sale. Possession has been taken.
Accept notice for the respondents. Copy kotilla. Notice to the respondents list day after tomorrow in the fresh matters list.
4 is the individual.
Copy code. Yes. Next.
Number 12.
My lord, item
1 to 3. 1 minute. 1 to 3 anta heli. Amele 4 emergent notice. Yes, Velan.
My lord, item 12 and item 14 are connected. My lord, I request my lordship to take item 14.
Aitu kodi. Idu nim meeting ena?
My lord, here the facts are slightly different. My lord, here the state has issued in effect, in essence, a gag order against any person.
Appearing for you.
No, my lord, I am appearing.
Serial number 14 is surfacing matter, sir.
No, no. WP number 7953 and 7957.
79?
53 and 7957.
That is 16, Karnataka Karmikara Vedike.
Yes, yes, my lord.
Adyaru.
Namdeno.
Serial number yavudu, sir? 16 and?
8.
Yes, Velan, yarg appear ಆಗ್ತಿದ್ದೀರಾ ನೀವು?
My lord, Niti Trust versus State of Karnataka and Karnataka Karmikara Vedike.
Karmikara Vedike.
Yes, my lord. Yes, my lord.
ಇನ್ನೊಂದು ಯಾವ್ದು, which serial number ಏನದು?
ಅದೇ both of these.
16 ಆಯ್ತು, ಇನ್ನೊಂದು?
12.
18 is native empowering equipping team.
That is Niti, that is Niti.
Oh, sir. ಆಯ್ತು.
My lord,
12, what do you want me to take?
my lord, the Niti Trust versus State of Karnataka, my lord.
18 ಕೊಡಿ ಮೇಡಮ್. ಹಾಗಾದ್ರೆ wait, 12, 18 ಬಂದಾಗ ತಗೊಂತೀನಿ.
Obliged, my lord.
Number 12, third one.
The paper. Petitioner, my lord, the.
ಲೋಕೇಶ್,
3,70,00,000 ಇದೆ ಸ್ವಾಮಿ.
ಯಾವ್ದು ಸೇಲ್ ಇದೆಯಾ?
ಸೇಲ್ ಆಕ್ಷನ್ ಮೊನ್ನೆ 14 ಅವತ್ತೇ ಮ್ಯಾಟರ್ ಲಿಸ್ಟ್ ಆಗಿ
ಆಗೋಗಿದೆಯಲ್ಲ?
ಏನ್ ಗೊತ್ತಿಲ್ಲ ಸ್ವಾಮಿ.
ಗೊತ್ತಿಲ್ವಾ?
ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಇನ್ಫಾರ್ಮ್.
ಕೆವಿ ಲೋಕೇಶ್ ಕೇವಿ ಇಟ್ಟಿದ್ದಾರೆ. 2:30 ಮೂವ್ ಮಾಡ್ಬಿಟ್ರೆ ಕಷ್ಟ. ಲೆಸ್ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಇನ್ ದಿ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಲಿಸ್ಟ್.
ನಾಳೆ ಸ್ವಾಮಿ
ಸೇಲ್ ಇದೆ, ಸೇಲ್ ಆಗೋಗಿದೆ. ನಾಡಿದ್ದು ಎಸ್,
ನಾಳೆ ಸ್ವಾಮಿ.
ನಾಳೆ ಬರಲ್ಲ ಸರ್ ಹಾಕಿದ್ರು.
ಅರ್ಜೆಂಟ್ ಸ್ವಾಮಿ. 14ಕ್ಕೆ ಬಂದಿತ್ತು ಸ್ವಾಮಿ, ಅವತ್ ಬರಲ್ಲ. ಅವತ್ ನೆನ್ನೆನು ಮೆಮೊ.
ನಾಳೆ ಈಗ ಪೋಸ್ಟ್ ಮಾಡಿದ್ರು ಬರಲ್ಲ, ಲಿಸ್ಟ್ ಕ್ಲೋಸ್ ಆಗಿರುತ್ತೆ. ಟ್ರೈ ಟು ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್. ಇಲ್ಲ ನಾಳೆ 2:30 ಮೂವ್ ಮಾಡಿ 2:30 ತಗೊಂತೀನಿ.
ಅಲ್ಲ, ಅವ್ರು ಬೆಳಗ್ಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೆ ಸ್ವಾಮಿ.
ಇದೇ ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ. ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಬೆಳಗ್ಗೆ ಬಂದ್ರೆ ಬಂದೇ ಬರ್ತಾರೆ. ಅಬ್ಲೈಸ್ ಟು ಕಮ್. 2:30 ಮೂವ್ ಮಾಡಿದ್ರೆ ನಾಟ್ ಅಬ್ಲೈಸ್ ಟು ಕಮ್. ಎಸ್, ಲಿಸ್ಟ್ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಇನ್ ದಿ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಲಿಸ್ಟ್.
Petitioners are the tenants ownership. Respondent number 2, 3 are the borrowers.
They are shooting from your shoulder. ಎಷ್ಟಿದೆ?
We are not borrowers. We are more
ಹಂಗಾರೆ ಬರಲ್ಲ ಬಿಡಿ. Why are you worried?
Seeking time.
For what?
For vacating.
Where is the lease?
Page 11. 3 lease agreements have been.
Subsisting lease ಯಾವುದು?
Subsisting lease A, annexure A, page number 11.
HDFC Bank ಯಾರಪ್ಪ? ಅಲ್ಲ, ಯುಕೋ ಬ್ಯಾಂಕ್.
UCO Bank.
ಯಾರಿದ್ದಾರೆ ಮೇಡಮ್?
Parshuram.
Parshuram. Council Parshuram is directed to accept notice for the first respondent, UCO Bank. You list the matter on Tuesday in the fresh matters list. Till such time, the petitioner shall not be dispossessed.
Obliged.
Yes, next.
14.
I appear for petitioners in this matter. Petitioner is the wife of.
Sale.
No, my lords, the
14.
petitioner is the wife of the borrower. And
You are
they
staying in the premises?
And they're living separately. Husband has refused to pay the EMI. The bank has issued 13(2).
The petitioner is the wife of one. How do you show that you're living separately?
My lords, I have, he's not living with me. The residence of the petitioner is his office.
Huh?
Yeah.
Residence of the petitioner is in the office.
Is his office. His is dental clinic. He's residing in the ground floor.
No, to escape liability, you should not play hide and seek. That's why I'm asking.
In
Where
fact,
are
there's
you?
a divorce petition I have.
That's exactly what I asked.
The divorce petition. But they
The
have
petitioner is said to be the wife of one, Johar Kripa.
My lords, but in that divorce petition, I have decided to reconcile. Both the parties have reconciled. Subsequent to the reconciliation, he's left their home. So there is nothing that I can show at the point that he is living separately from me, apart from the fact that he's living in his
No, reconciliation had some conditions?
No, nothing.
Without condition?
Without conditions, reconciliation. The order I have produced also, my lords.
Then how can the bank be held responsible for all this? Yes. The petitioner is the wife of one Johar Kripa, against whom the husband and the wife had some dispute, had some disputes between them, which led the wife to file a petition seeking annulment of marriage. It transpires that in the said proceeding, the parties arrive at a settlement or reconciliation of their differences and begin to live together. The counsel for the petitioner submits that the wife is now left in the lurch and the petitioner has abandoned them. How many children?
2 children.
With 2 children. With 2 children in the, and the petitioner is staying in the said premises. The issue now is the husband has refused to pay the EMI, which has led the bank to initiate steps under Surface Act 2002. In that light, there shall be an interim order of stay as prayed for emergent notice to respondent 1, 2, 1 and, HDFC Bank, Francis Xavier. Francis Xavier is directed to accept notice for respondent 1 and 2. The emergent notice to the third respondent returnable by 8th April.
Great.
Yes, next.
Appearing for the petition. The respondent number 2, BESCOM has issued a.
ಕಟ್ ಮಾಡಿದಾರಾ ಕಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರಾ
Cut ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಯಾವಾಗ ಮಾಡ್ತಾ ಇದ್ದಾರೆ
Swami, ಅದು because we take to annexure A.
ಯಾಕೆ ಕಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ
Because based on a letter given by the BBMP, that is in page number
ವೈಲೇಷನ್
violation. Swami. But then if you see in annexure C,
ಅದೇನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ ಅದನ್ನ
order ಸಿಕ್ಕಿದೆ Swami. Before the letter given by BBMP, we have got a stay against BBMP. In page
Fine,
number
yes.
15, annexure C, the same petition.
HV Devraj accepts notice for respondent 1 and 2. There shall be an interim order of stay spread for till the next date. Next.
16, trans BA.
ಕಾರ್ಮಿಕರ ವೇದಿಕೆ ಇದು ಅದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದು
16 and 18.
18 ಜೊತೆ ತಗೊಂತೀನಿ. ಎಸ್ ಜಗದೀಶ್
For petitioner, my lord. There is auction tomorrow. I'm ready to pay the.
ಏನ್ ಆಕ್ಷನ್
Property, subject property.
ವೈ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಯಾಕೆ
The deputy commissioner.
ಆಕ್ಷನ್ ಬೈ ಹೋಮ್ ಸರ್
Deputy commissioner
Why?
is empowered to the special tahsildar, my lord.
ಅಲ್ಲ ರೇರಾನಾ ಏನು
Howdu, RERA.
ಎಷ್ಟಿದೆ
4 crore, 17 lakhs.
ಯಾವಾಗ ಪೇ ಮಾಡ್ತೀರಾ
In 4 weeks, my lord.
ಆಲ್ ದ ಮನಿ
Lord, I'm ready to, kindly may 4 weeks, my lord. Kindly may give 4 weeks to deposit the interior amount of 20%.
20% ಇಲ್ಲ ಯು ಆರ್ ಅ ಡಿಫಾಲ್ಟರ್ ಇನ್ ಸಾಯಿ ಡೆವಲಪರ್ಸ್ ಅಂಡ್ ಬಿಲ್ಡರ್ಸ್
I'm a owner of the subject property defaulted by the developer respondent number 4.
ಡಿಫಾಲ್ಟರ್ಸ್ ಡೆವಲಪರ್ ಎಸ್ ಒನ್ ಡೆಪ್ಯೂಟಿ ಕೊಟ್ಟಿಲ್ಲ ಕಾಪಿ ಯಾವತ್ತಿದೆ ಆಕ್ಷನ್
ನಾಳೆ ಇರೋದು.
ಕಾಪಿ ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ
Sorry.
ಕಾಪಿ ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ ಗವರ್ಮೆಂಟಿಗೆ
So,
ಟು ಡೂ ಐ ಡೋಂಟ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ಎಷ್ಟು ಹೇಳಿದ್ರು ಕೇಳಲ್ಲ ವಿಲ್ ಟೇಕ್ ಇಟ್ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ
sorry, my lord. I
ಏನ್
apologize for
ಮಾಡಕ್ಕ
that.
ಎಸ್ ಲುಕ್ ಇನ್ ಟು ಇಟ್ Let's the matter on Friday in the
My
fresh
lord, sorry,
matters
it's
list.
my default. The party should
The
not be defaulted.
Auction
Apologize
slated
for
to
that,
be
my
held
lord.
tomorrow shall be deferred until further orders. Yes, next.
Lord, on humble submission, interior model may be given by hand.
ಈಗ ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ ಸರ್ ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಅವ್ರು ಹೇಳ್ತಾರೆ ಬಿಡಿ ಇಲ್ಲ ನಾಳೆ ಬೆಳಗ್ಗೆ ಸಿಗತ್ತೆ
Please.
ವೇಲನ್ ಟೆಲ್ ಮಿ
My lord, I beg to appear for the petitioner here, my lord.
ಎಸ್
My lord, the state, by relying upon the said judgment, has in essence effected a gag order against any person speaking on the very subject matter. My lord, the petitioner happens to be a trust, my lord, which has been functioning for a long period of time. The petitioner makes a request seeking police permission, which was granted.
No,
I take my lordship to
all this is springing from the video, is it?
my
No,
lord,
all this is springing from that YouTube video.
my lord, these protests with regard to the said matter has been ongoing. My lordship is well aware.
Oh, it's ongoing. Yes, well
Lord, I
aware.
take-
I'm not aware, sir. Yes, tell me.
My lord, I take my lordship to page 28 of the petition, my lord, if I may, my lord.
Yes, sir. Where is the gag order?
My lord, page 28 is the order by which I was granted permission at first.
ಆಮೇಲೆ
My lord, may I read, my lord?
yes.
The last 3 lines, my lord. Permission is granted to hold a peaceful protest march and a massive protest in front of so and so on 15/3/2025 on 11 a.m. to 2 p.m. subject to conditions which was imposed. Now, my lord, I take my lordship to page 32. The
Yes.
said permission was revoked on the sole ground that directions were issued by this court by relying upon the said judgment. That is, my lord, writ petition 19382 of 2023.
I will again grant the same order directing the police to take action if there is anything that is found in the violative of the judgment that is rendered. I will not stop you from peaceful protest.
My lord, that is essentially in essence what has happened.
No. I will not. I will pass an order permitting you to hold a protest which should be peaceful.
Yes, my
And
lord.
if there is any violation of the order passed by the coordinate bench or its observation,
Yes, my
police
lord.
will be at liberty to take action.
My
That I
lord,
will permit.
My lord, here the difficulty is, my lord, the understanding of the decision of the coordinate bench by the respondent state. That is the difficulty. My lord, I take
Then
my
if you
lordship.
have any clarification, you have to go to that bench only.
No, I'm not seeking a clarification, my lord. I take my
Then,
lordship
yes.
to page 46.
No, I'm not saying, Velan, that I'm going to stop you from protesting or whatever.
Yes, my
It
lord.
should be peaceful and in accordance with what the coordinate benches observed.
Yes, my lord. That is where, my lord, for a moment, my lord, if I may seek my lordship's indulgence to page 11,
Yes.
page 46.
Mm.
That is paragraph 11.
I am there only, yes.
Yes, my lord. Having regard to the facts and statements narrated herein above,
Mm.
this court is of the considered opinion the petitioner herein have a right to seek such direction to the respondent police.
Mm.
My lord, here the petitioner seeks a direction to the respondent police, wherein the respondent and number 9, my lord, essentially apologizes before the contempt court, saying the fact that he was in the teeth, his actions were in the teeth of the order of the division bench of this court. That is not the case before the petitioner. My lord, this cannot be a basis.
No. See, this is a general direction.
My lord,
Maybe in those facts, wherever if any protest would turn violent, they are always entitled to take action in accordance with law if the protest turns violent.
Well,
for reasons known to them on the said date.
There is no quarrel with the same, ma'am.
All right. Now, if you are wanting to hold a peaceful protest or whatever, yes, we will not stop them. So we will not stop you. Even the state will not stop you unless you indulge. Gag orders you can't pass, sir. Jafar. Mike use me.
Reference ಅಲ್ಲಿ, if your lordship can kindly see page 32. ಅದರಲ್ಲಿ reference ಅಂತ ಹೇಳ್ತಾರೆ.
Page 32 ಅಲ್ಲ.
Yes. The endorsement that they issued after the permission was granted to him.
Yes.
So the objections have been raised by one advocate. And referring this letter, in view of this judgment that they cannot hold such kind of a protest.
When are you wanting to hold this?
It was initially permission was granted for 15/3.
ಈಗ ಇನ್ನು ಡೇಟ್ ಫಿಕ್ಸ್ ಆಗಿಲ್ವಲ್ಲ ಬಿಡಿ, ಹೋಲ್ಡ್ ಮಾಡಬೇಡಿ ಅಂತ ಹೇಳಿದಾರಲ್ಲ.
What has happened is, relying upon this.
I'm only saying I'll take it tomorrow.
Obliged.
We'll take it tomorrow because I have a meeting. I'm already overshot the time.
Yes, madam.
Yes. I'll take it tomorrow at 2:30. 2:30 ಆಗುತ್ತೆ madam. Take it tomorrow at 2:30.
Obliged, madam.
We'll pass some order tomorrow, looking into the judgment. Other matters I'll finish and go. 2:30 more matter finish ಮಾಡಿ ಹೋಗ್ತೀನಿ.
But in fact, my lord, this is in the teeth of a division bench decision of this court itself.
No, ಅದಕ್ಕೆ I'll take it. See, 2:30 move ಮಾಡಿಬಿಟ್ರೆ ಇವೆಲ್ಲ ಏನು ಗೊತ್ತಿರಲ್ಲ. Suddenly you come up with so many submissions.
Obliged.
And Shruti madam says rudimentary things ಗೊತ್ತಿಲ್ಲ ನಮ್ಗೆ ಅಂತ. Yes, it's all right, madam. The lighter way, don't worry. Yes. Both ಯಾವುದು? Both 16 and 18 ನಾಳೆ.
Obliged, madam.
Next.
19.
ಯಶವಂತ್ ಸ್ವಾಮಿ. ಏನು ಸ್ವಾಮಿ ಇದು? ಲೋನ್ ಮ್ಯಾಟ್ರಾ ಎಷ್ಟಿದೆ?
8,12,000.
10% 4 weeks. Next.
20.
May kindly be added into.
Hand delivery. ನಾಳೆ ಇಸ್ಕೊಡಿ. ಏನು ಇವ್ರು ಸ್ಟ್ಯಾಂಡಿಂಗ್ ದೇರ್ ಅಲ್ಲೇ ಇರ್ಲಿ ಅಂತನಾ? ಕೇವೇಟ್ರ್ ಇದ್ದಾರೆ. TP ಮುತ್ತಣ್ಣ. ಎಸ್ ಸರ್. ಎಸ್ ಸರ್. ಏನು ಗೊತ್ತಿಲ್ವಾ? ಯಾವ ಸೇಲಾ? ಯಾವತ್ತು? ತುಂಬಾ ಟೈಮ್ ಇದೆ. ಎಸ್, ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಇನ್ ದಿ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಲಿಸ್ಟ್. ಕಾಪಿ ಕೊಡಿ. ಹಾ ಸರ್. ಎಸ್, ನೆಕ್ಸ್ಟ್.
21, Kavitadi.
ಎಸ್. ಸೇಲಾ ಯಾವಾಗ ಕೊಟ್ರು ನೋಟಿಸ್? 1 ವರ್ಷ 2 ವರ್ಷ ಹಿಂದೆ?
10-3.
10th ಈಗ ಎಷ್ಟಿದೆ?
2 crore 49 lakhs.
ಇಲ್ಲ, ಇವಾಗೆಲ್ಲ ಕ್ರೋರ್ಸ್ಗೆ ಹೋಗಿದ್ದಾರೆ. ಎಸ್.
10%, 4 weeks. 4 weeks, 10%.
10.
10.
2 crores, 20 lakhs. All right. 4 weeks, 10. Next.
22.
Emergent notice.
It's a mortgage loan with it's a mortgage loan, my lord. The petitioner has,
Mortgage loan ತಾನೆ.
for business purpose, the petitioner has taken the loan.
Diesel. What purpose?
Business purpose.
Business. ಎಷ್ಟಾಗಿದೆ? 86 lakh for 24,000.
ಇದರಲ್ಲಿ overdue ಬಂದು 11,30,000 ಇದೆ, my lord.
ಎಷ್ಟಿದೆ? ಆಯ್ತು, ನಾಡಿದ್ದು ತಗೊಂತೀನಿ. ಏನ್ ಸೇಲ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ?
ಅಲ್ಲ, my lord, ಇವತ್ತೇನೆ last date. They have asked to hand over the property today itself.
Learned. It's all right. The learned counsel so and so undertakes to enter appearance for the respondent. List the matter on Friday in the fresh matters list. Till such time, the respondent bank shall not precipitate the matter. Yes.
23.
Kalyan,
My lord, one more submission I want to make. There's a DD they have taken for 3 lakhs. So yesterday they went to the bank and they tried to
ಈಗ
pay. it.
ಶುಕ್ರವಾರದವರೆಗೂ ಇರಿ ಮೇಡಮ್ ಸರ್. ಎಸ್, ಅವತ್ತೇ ಕೊಡ್ಸೋಣ ಡಿ. ಆಯ್ತು, ಮಂಡೇ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್. ಎಸ್.
Auction sale tomorrow, my lord. The
ಎಷ್ಟಿದೆ?
outstanding due is 3 crores 42 lakhs 21,000. My lord,
ಸೇಲ್ ಆಗ್ಲಿ, ಸೇಲ್ ಆಗ್ಲಿ.
my lord, crop loan and agriculture loan.
ಕನ್ಫರ್ಮೇಶನ್ ಆಫ್ ಸೇಲ್ ಬೇಡ.
My lord, I'll deposit some amount, my lord, crop loan and.
ನಾಳೆಗೆ ಏನ್ ಮಾಡಲ್ವಾ ನೀವು? ಕ್ರಾಪ್ ಲೋನಾ?
Crop loan. Okay, annexure.
ಇವ್ರ ಅಗ್ರಿಕಲ್ಚರ್ ಇಷ್ಟ?
Agriculture is.
ಫ್ಲೋರಿಕಲ್ಚರ್.
Floriculture. Okay.
ಫ್ಲೋರಿಕಲ್ಚರ್
ಅಲ್ಲ, ಇದರಲ್ಲಿ agriculture land purchase, crop
ಸುಮ್ಮನೆ
loan.
ಫ್ಲೋರಿಕಲ್ಚರ್ ನ ಅಗ್ರಿಕಲ್ಚರ್ ಅನ್ಬಿಟ್ಟು.
ಅಲ್ಲ, crop
Yes.
loan, purchase of land.
ಫಾರ್ಮರ್ಗೆ 2 ಕೋಟಿಗೆ ಹೋಗೋದೇ ಇಲ್ಲ ಲೋನ್. ಅಗ್ರಿಕಲ್ಚರಿಸ್ಟ್ ಹೋಗೋದೇ ಇಲ್ಲ ಆ ಲೆವೆಲ್ಗೆ.
After the first sale.
ಫ್ಲೋರಿಕಲ್ಚರ್ದೇ ಪ್ರಾಬ್ಲಮ್ ಇದೆ.
After first sale notice, I have deposited 25 lakhs.
Anyway, we'll see. You deposit another 25 lakhs.
Please.
ಎಷ್ಟಿದೆ? 2 crores?
3 crores 42 lakhs.
3 crores ಅಂದ್ರೆ 10%. 3 weeks.
Please.
Yes.
Much.
24 withdrawal.
24 withdrawal. 25 withdrawal. ನಾಳೆ ಈಗೆಲ್ಲ ಆಗುತ್ತೆ.
25 serial number.
25 withdrawal ಇತ್ತು.
Withdraw, the connected matter survives. That's 2 petitions.
ಕನೆಕ್ಟೆಡ್ ಇದೆಯಾ?
Yes, your Lordship. Next page.
ಎರಡಕ್ಕೂ ಹಾಕಿದ್ದೀರಾ?
In 25 serial number, the convict was not released on premature release.
ಎದರ್ದ?
Hence it is infracted.
ಆಯ್ತು, ಈಗ ಯಾವ್ದು ಇನ್ಫ್ರಕ್ಚರ್ಸ್?
25.
25 disposed as withdrawn. 25.1 survives.
Survives, your Lordship.
ಏನದು?
That is challenging the order of pre-release.
Challenging the order.
ಹೌದು.
Why, who are you?
I am
He's
the
a
respondent, your Lordship.
He's a victim's husband, my lord, if I recall, because I have dealt with this matter.
Premature release ಕೊಡಿ ಇಲ್ಲಿ.
That is a withdrawal memo.
A withdrawal ತಗೊಳ್ಳಿ. Premature release, why are you challenging?
Because, your Lordship, there is guidelines. The guidelines would say that any convict who is convicted for the offense against a woman under certain sections, which also includes 302 IPC, cannot be released prematurely if he is convicted for life.
No, let's see. Because the apex court reversed the
Order of
premature release of Gujarat. Yes.
That
We'll
is
list,
why, Lordship.
we'll list it on Friday.
Right, gratefully.
Yes. List on Friday. ಯಾವ್ದು? 25.1. The respondent is served?
Served.
Yes. ಇನ್ನೂ ಇದೆಯಾ?
Disconnection of electricity.
ಆಗೋಗಿದ್ಯಾ? ಆಗ್ತಾ ಇದೆಯಾ?
ಆಗಿದೆ.
ಆಗೋಗಿದ್ಯಾ? ಯಾಕೆ ಮಾಡಿದ್ದಾರೆ?
The reason is BBMP.
BBMP ಇದು. ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ ಅದನ್ನ?
Appeal pending before the chief commissioner.
ಕರೆಕ್ಟ್. ಏನಾಗಿದೆ ಅಪೀಲ್ ಅಲ್ಲಿ?
There is an order of status quo notice.
Where is the order of status quo?
Lordships may kindly see the copy that has been.
Page. Time ಆಯ್ತು, fast.
Page number 78. Last portion of that particular.
78.
78. Last portion of that particular.
Praise this honorable court adjourned status quo as on today. Learned Counsel H.V. Devraj is directed to accept notice for the respondents petitioner to serve set of papers upon the aforesaid counsel. There shall be an interim order of stay spread for till the next date of hearing. List on 8th April. Yes, next.
Yesterday's 230 list, which is not reached.
ಇದೆಯಾ
This
ಇಲ್ಲಿ?
listed at serial number 63.
ಲಿಸ್ಟ್ ಆಗಿದೆಯಾ?
Yes, my lord. 63, 64.
ಇವತ್ತು ಆಗಿದೆಯಾ? ನಂಬರ್ಸ್ ಹೇಳಿ.
64.
64 to?
No, no, 63 is what she is saying. 64 is mine.
ಎಸ್ ಕವಿತಾ ಮೇಡಮ್ ನಿಮ್ದು ಯಾವ್ದು ಹೇಳಿ?
63, my lord.
63 ಕೆನರಾ ಬ್ಯಾಂಕ್
Sale notice was challenged, my lord. Today was the sale.
ಆಗೋಗಿದೆಯಾ?
I pray for confirmation of sale.
The learned counsel, the matter was listed yesterday. Due to paucity of time, it could not be taken up. The sale has taken place. Therefore, the bank shall not issue a sale certificate or confirm the sale, issue the sale certificate in favor of the auction purchaser without the leave of the court. List the matter on next Tuesday in the fresh matters list.
Well,
Wait, ನಿನ್ನೆ 4 matters ಯಾವ್ದು?
64 is.
ಕೊಡಿ.
437 page, my lord.
Same interim orders I have granted.
That's what I'm.
Similar matters, my lord.
Ah.
They are, my lord, claiming parity with another company called GSW.
ಇದಲ್ಲ ಅದು. I will explain him. ಅಲ್ಲ ಅದು that matter, my lord, which my learned friend is referring to, did not challenge
Against-
section 11(1) order.
They did.
Order, Manmohan's order, that is completely different. 437, my lord, annexure P. Lordship's interim order is all that I am asking. Not to
My lord,
precipitate the matter.
They challenged the 11(1) order, also claimed parity. My lord,
ಇದು
that was
ಧಾರವಾಡದಲ್ಲಿ
rejected.
ಕೊಟ್ಟಿರೋದು.
Same order, my lord.
That was rejected, my lord, and they have been remitted to, my lord, appellate remedy, and appeals are pending against the very same order.
Was challenged. Let him show, my lord, that order. I am aware of that order, Honorable Justice Hegde's order.
ಹೌದು.
There, my lord, on KERC's order was challenged. Here, the government order is challenged. That is
The government orders challenged, my lord, one round government's orders are challenged. My lord, after that, my lord, KERC has determined 11(2) tariff. Now, my lord, the demand made under 11(2) tariff, against that, my lord, he is seeking an interim order.
And
Lord,
lordships have
same-
passed an order
kindly
saying that
have a
no
look.
prescriptive action be taken. Let it be
Till
heard.
now,
I am
On-
ready to.
On Friday I'll take it.
my lord, any day, my lord.
On Friday I'll take
The
it.
ground, my lord, the ground on which he comes.
ಅಲ್ಲ
before-
ಈಗ ಆಗಲ್ಲ.
ಅದೇ,
Friday
any day,
fresh matters ಅಲ್ಲಿ ಹಾಕ್ತೀನಿ.
ಆಯ್ತು.
List the
No prescriptive action.
ಒಂದು ನಿಮಿಷ.
ಅಲ್ಲ ಇಲ್ಲಿ ಇರೋದೇ 9 ಲಕ್ಷ. I don't know why he is making such a fuss about it. No, if the interim order is granted, my lord, he'll come with another 50, my lord. I want to, my lord,
Another 50 ಅಂದ್ರೆ?
50 petitions, my lord, because there were so many.
ಅವ್ರಿಗೂ ಆಗುತ್ತೆ ನನಗೂ
ಅದು
what
ಅದು
is
ಬೇಡ. Therefore, my lord,
No, I-
consider.
gag order against filing petitions.
No. Let this issue be considered.
There are 6
He says
petitions in
that
which your
appeal
lordships have
cannot
passed.
be filed because there is a, my lord, there was a circuit bench. That is the contention. That is, my lord, I have to show.
Circuit bench.
ಅಲ್ಲ ಅದೆಲ್ಲ ತುಂಬಾ ಲಾಂಗ್
ಎಲ್ಲ ಹೇಳಿದ್ದಾರೆ.
437, my lord, is the
Yes, lord,
granted by
He
the-
says, because there is a circuit bench, I will not go there, I
ಅಲ್ಲಿ
will come here.
ನಾಡಿ ಫ್ರೈಡೆ ಆಗೋವರೆಗೂ ಬೇರೆ ಪೆಟಿಷನ್ ಹಾಕ್ಬೇಡಿ. Yes. List on Friday in the fresh matters list. The heard the learned counsel Sridhar Prabhu and learned senior counsel Sriranga appearing for the petition respondents. List the
But let
matter
there
on.
be no interim order, my lord.
List
Till Friday, we
list
will
the
not do
matter on
anything.
Friday.
Yes.
No
List the
precipitate action.
But
list
we
the
will
matter on Friday. The respondent shall not take any precipitative steps against the petitioner. ಅದಿರ್ಲಿ.
But let there be no order, my lord. I am giving an, my
Ah,
lord, I
sir,
am
the
making a
learned, one
statement.
ನಿಮಿಷ. The learned senior counsel Sriranga undertakes that there would not be any precipitative action
Yes.
till the next day.
Straight
Till next.
That's even.
ಅಷ್ಟೇ ಸಾಕು.
My lord, serial number 53, I prayed for.
ನೆನ್ನೆ ಇದ್ದಿದ್ ಮಾತ್ರ ಹೇಳ್ಬೇಕು.
My lords,
ಸರಿ.
one
ನೆನ್ನೆ
submission.
ಮಧ್ಯಾಹ್ನ 2:30 ಇದ್ದಿದ್ ಮಾತ್ರ.
Serial number 63, my lords, I appear for the bank. The sale has not taken place, my lords. The petition has
ಆಯ್ತು
been.
ನಾಡಿದ್ದು ಹಾಕಿದ್ದೀನಿ ಯಾವತ್ತು ಹಾಕಿದ್ದೀನಿ?
Tuesday.
ಟ್ಯೂಸ್ಡೇ ಹಾಕಿದ್ದೀನಿ ಕ್ಲೋಸ್ ಮಾಡೋಣ. ನೆಕ್ಸ್ಟ್
The lordship provision law.
ನಿನ್ನೆ ಇತ್ತ ಅದು? ನಿನ್ನೆ 2:30 ಮೂವ್ ಮಾಡಿದ್ದ ಮೇಡಮ್ ಅದು? ಎಸ್ ಏನು ಹೇಳಿ?
They are trying to disconnect electricity, my lord.
ಅಲ್ಲ ಡಿಸ್ಕನೆಕ್ಟ್ ಆಗೋಗಿದೆ ಸರ್.
ಆಗೋಗಿದ್ಯಾ?
ಆಗೋಗಿದೆ.
ಯಾಕಾಗಿದೆ? BBMP-ನ?
BBMP-ನೇ ಮೆಲೋಡ್
ಅಲ್ಲ ಅಲ್ಲಿ ಅಪೀಲ್ ಹಾಕಿದಾರಾ?
ಅಲ್ಲ ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ.
ಅದು ಸ್ಟೇ ಆಗಿದೆಯಾ?
ಅದು ಇನ್ನೂ ಸ್ಟೇ ಆಗಿಲ್ಲ.
ಸ್ಟೇ ಆಗಿದ್ರೆ ಡೋಂಟ್ ಟೇಕ್ ಆಕ್ಷನ್.
ಅಲ್ಲ ಆಲ್ರೆಡಿ ಇದು ಡಿಸ್ಕನೆಕ್ಷನ್ ಆಗಿದೆ.
That's all right, sir. You have disconnected on the ground that it is violative of the plan. ಅದು ಇದು ಎಲ್ಲ
Based on the
BBMP.
BBMP notice.
All right, your chief commissioner has stayed that order. If there is a stay of that order.
Milord, my problem is this.
Sir, 1 minute. If there is a stay of that order, then how can you disconnect electricity?
ಅಲ್ಲ Milord, it's a false submission. I'll submit this. He is saying that OSL stay ಆಗಿದೆ injunction order.
Injunction order.
That injunction order itself is violative of this honorable court's order.
Injunction, how can court, trial court grant against the KPTCL?
Not against me also, it's
Then-
against BBMPA, not to demolish.
BBMP. Yes, list day after tomorrow in the fresh matter.
Lord, 66 also same.
We have appealed. before
Same,
that.
66 also, day after tomorrow.
Serial number.
Day after tomorrow, yes, yes.
Serial number 65, my lord, it may be taken up tomorrow, my lord. There is some urgency.
Tomorrow, ಬೆಳಗ್ಗೆ move ಮಾಡಿ 2:30. I'll take it
Or
at
even
2:30.
day after tomorrow also, my lord.
Day after tomorrow, I'll definitely take.
65 and 82, my lord, both are connected.
Day after tomorrow, I'll definitely take, and all the matters that have not reached the court officer will assign dates after asking me.
My lord, serial number
There's
12,
already a
my lord.
meeting.
Position,
I
my
had to
lord.
get up at 4:45, I overshot it.
Position.
Serial number 47, my lord. Serial.
Reposition, my lord, mine is 53.
But submission, serial number
Unpaid, my
15
lord.
and BWSS ಇದೆ. Similar matter already stay granted.
My lord,
Tomorrow, my lord.
is a cover by.
ಏನು ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ. ಎಲ್ಲಾರು ಹೇಳಿದ್ರೆ ಏನು ಗೊತ್ತಾಗಲ್ಲ.
ಅಲ್ಲ, serial number
ಯಾವ್ದು ಆಗಲ್ಲ.
77, my
my
lord.
lord.
57, my lord.
Judgment, my lord. These are pending from 2 years, my lord.
Serial number 47 may be taken up day after tomorrow, my lord. RP.
Sir, VC, one ನಿಮಿಷ sir. Yes, sir.
My lord, 71 and 72, it is squarely covered by M. Chiranjeevi judgment, my lord.
So
It may be taken up, my lord. It may be disposed of, it may be taken up.
now,
Not now, my lord.
then
It's
sir,
on Monday.
We'll-
and
I'll take it. Sir. Yes.
My lord,
We'll fix the dates for all the matters that are not reached.
ಅಲ್ಲ, serial number 59, one submission.
ಏನು ಗೊತ್ತಾಗಿಲ್ಲ, 10 ನಿಮಿಷ ಕೂತ್ರು ನನಗೆ ಏನು ಗೊತ್ತಾಗಲ್ಲ. Yes.